It's not mine. You might want to take it away. Sorry for dropping it on you. Hopefully you won't be too far away. Right, where did my sheet go? Here we go. So, members, the committee is resumed on the Immigration, Fiscal Sustainability and System Integrity Amendment Bill. When we were last debating the bill before the lunch break, we had just concluded the debate on Part 2. We now come to Part 2A. Part 2A is the debate on Clause 56A, amendment relating to repeals, transitional provisions, saving provisions and related matters. The question is that Part 2A stand part. Ingrid Leary.
Thank you, Madam Chair. As you have rightly said, this is around amending deportation liability of residents class visa holders, and it amends section 431 of the Principal Act. And it is really good to see that the care has been taken to cross-reference and make sure that where there has been an extension of imposing of conditions or imposing of and limiting of rights, that the Minister and officials have taken care to ensure that there is equally the exemptions that correspond. So if we go to the Principal Act, Clause 431 talks about the deportation liability of residence class visa holders convicted of a criminal offence. In subsection 1A, B and C, it has various carves outs for people who would be exempt under that Principal Act. And what we see from this amendment, from the original amendment, not the amendment of the amendment that was dropped today, is that suddenly we have got people who have been found guilty captured by some of those provisions. And so what this quite rightly does is it includes ensuring that those who are found guilty are also able to access those exemptions. I guess the question is, why go to all that trouble to unpick something when it would have been easier just to not add found guilty into the original deportation provisions? We haven't asked or heard from a minister whether she has received Ministry of Justice advice on the rights and impacts of that. And those provisions are in sections 156, 158, 161 and 18C. So I would like to know why we have got this convoluted kind of carve out rather than not simply extending them in the first place. Did the Minister receive advice about that? And also, if we think about proportionality, which is impacted here, and particularly when we're talking about people who are guilty, there are people who are convicted for things overseas, for very petty things, including political things, where they could be found guilty overseas, and now they are able to access this exemption, but they're still captured by the extension of guilt to the conviction list in the original Act. I know that's a bit confusing, but it is a very convoluted process, and we haven't heard the advice that the Minister received on why those powers have been extended. And wouldn't it have been simpler to not have to do this, and we could do away with Section 2A and simply not have that extension? And on that basis, my colleague Vinushi Walters actually does have a tabled amendment. She is much more across the legalities of this, and I would really like her to have the opportunity to speak to that, Madam Chair.
Madam Chair.
Vinushi Walters.
Thank you, Madam Chair, and I thought I would rise and speak to my amendment filed at 12:05, which reads in Part 2A, Clause 56A, insert in section 431 in the heading to section 43 the words unless subject to a discharge without conviction after the words or guilty. And so this, as my colleague Ingrid Leary has said, responds to that concern that was raised by the Law Society in their submission, where they pointed out that the automatic triggering of deportation liability in such cases would really place, or could really place, a person in jeopardy of severe immigration consequences, even where the courts have determined themselves that applying a proportionality test in section 107 of the Sentencing Act, which is a test that can and should be applied, because we expect judges to be turning their mind to the specific consequences of the case, that the consequences of a conviction would be out of proportion to the gravity of the offending. So this isn't something that's used all the time by judges, but certainly as the decision makers closest to the individual concerned and the context of the issues, the concept is there. It's a familiar one in law, that the judge can determine whether the circumstances are such that a discharge should be granted. And I think in the flip side of that as well is that judges will be aware of this legislation coming through the pipeline. And so you can imagine that a discharge wouldn't be granted if it wasn't in the interest to do so, or if there were security risks in place. So just once again, really urging the Minister to consider whether that is an aspect of this bill that can be changed. And ideally, my sense is we wouldn't just be doing it in this part, of course. We would be doing it in both the substantive heading as well as the substantive provision. However, this is an opportunity to fix what seems to me to be clearly an issue, and an issue that sits starkly against judicial powers to assess situations and determine whether liability should attach, whether conviction should attach or not.
Dr. Lawrence Yunnan.
Thank you, Madam Chair. And just following on from the previous two speakers, I want to focus on the fact that this one says convicted or guilty. But again, I don't want to, I'm going to mention a reference, a previous section, but not actually talk about a previous section, which is that in previous section, we specifically talk about two types of being guilty, being found guilty and being pleaded guilty. But over here, the title is, rather than saying, like previous section, convicted, found guilty or pleaded guilty, it is just convicted or guilty. And I'll check with the Minister that in this case, the inserted word or guilty covers both types, found and also pleaded. But if it does cover both types, for example, not just simply those who are found guilty, I wondered if the Minister could advise the House on, when you're looking at deportation or deportation liabilities, has there been any work that's being done looking at how this would potentially affect people's ability to, or people's intention to plead guilty in the first place? Just because if they are going to, whether they are pleading guilty or found guilty or no longer have, or doesn't have a conviction, is acquitted or is convicted, the outcome is all going to be the same to them in terms of deportation liability of resident visa class. So so I just want to check those kind of two questions with the Minister, if guilty covers both types, and whether there's any sort of research or any sort of advice being given around the impact this will have for people who may no longer then wish to plead guilty because they're going to be deported regardless. They might as well try their luck and go through the court process.
Okay, so we don't potentially have any answers to those questions. Could you just, I'm sure, Lawrence, you can ask another question. I'm just going to get some advice.
Yeah.
And this is not a reflection on the Minister.
Absolutely not. And I really appreciate you, Madam Chair, that we understand that the Minister in the chair is not the same Minister we had previously, but also that there are officials involved. I just want to seek clarifications from you, Minister, Chair, that should the minister receive some advice on this, it's something that the minister could speak to at a later part and just quickly reference this section on some of the questions we may have. That's all.
I'm just taking some advice. Thank you. Sorry, I'm going to put vote on it. We don't have the answers to the questions, and maybe that's the explanation we just take.
I think that's what we're going to have to do.
Yeah.
Unless they have more questions.
Yeah, okay. Yeah, okay. So the advice is, unless you have some more questions, we will take this part to a vote. So we'll do that now. So the question is that Venushi Walters' tabled amendment to clause 56A be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. Party vote is being called for. Please, clerk, conduct a party vote.
Ready for the call.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakaai.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori.
E whā ngā poti e whakaai. Oh, and 2 more.
Can I just check that the Green Party hold the proxy? Because I don't think any Te Pāti Māori members are on the press.
So we're just checking to see if you hold the proxy. Are the Te Pāti Māori members on the precinct, and you do hold the proxy?
We do.
You do?
Yes.
You're confirming that you do?
Yes, I think we have a docket that confirms that.
Because I think the clerk had been advised that they didn't.
We were advised that the TP were no longer on the precinct, so but you can just take them over. You can ask them again and just confirm whether TP you are able to cast the TP as proxies or not.
Okay. Yeah, we just do need to confirm whether they're on the precinct and whether you are able to, because we're not sure that they're actually on the precinct. I'm not sure if they're on the precinct. Can you confirm that you're able to take their proxies? Oh, here we go.
Okay.
Okay,
Great.
Thank you.
But what about the 2 independents?
Thank you.
Okay, great. Thank you. That was not our whip.
The whip knows.
I know. that was magical. Just kind of whips in and comes. Great.
Tāku te Ferris.
Sorry?
Tāku te Ferris.
Kotahi te poti whakaai.
Miriam Anna Kapakini.
Kotahi te poti whakaai.
The ayes are 51, the noes are 68. The question is not agreed. The question is that part 2A stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kaumarima ngā poti whakahē.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku te Ferris.
Kotahi ngā poti whakahē. Oh, te poti.
Miriam Anna.
Kotahi,
Wait till after the vote.
kotahi te poti whakahē.
Order, Madam Chair.
We'll just call the vote. Is it about the vote?
Yep.
Okay, I'll take the point of order now.
Madam Chair, just confirming that Act is 11 in favour.
Oh, okay. Act is 11 in favour.
So the vote record will be corrected.
Yeah, thank you. That's fine. It's on the right side of the ledger now, Mr. Court. It's on the right side of your ledger as you called it. Oh. The ayes are 102, the noes are 17. The question is agreed. Members, we come now to part 3. Part 3 is the debate on clauses 57 and 58, consequential amendments, and schedules 1 and 2. Ingrid Leary.
Thank you. We've just got a couple of
Oh,
questions.
sorry, the question is that Part 3 stand part.
Thank you, Madam Chair. The consequential amendments, section 57, schedule 1AA, basically inserts the part set out in schedule 1 and makes all the necessarily consequential amendments, which includes creating a new part 4. And we just have a question around what the impact of that is from a rule of law perspective regarding the new ministerial powers that might come into effect, because the people could be out in the community on conditions under the original Immigration Act or other acts, and then new powers have been conferred by section 324F. I don't think there has been a Bora vet, so, but I do understand that there may have been section 7 advice. And so we're trying to understand what would happen if a new condition was imposed on somebody under those circumstances. It could be an oversight, and my question is a kind of policy question, I guess. Is that an intentional oversight to extend powers to ministers? And does a minister accept that it's a Bora issue? And would she want to have a look at it and maybe close it up if it is? Or is it something that happened unintentionally? And I think it would be important to have some more legal questions on that. I'm just laying out what the substance of the policy question is, which is about the impact of this section and schedule on situations where existing conditions have been imposed on people and are now swapped out, and there are broader powers for conditions to be made.
Madam Chair.
Venushi Walters.
Thank you, Madam Chair. And perhaps just to add some detail to the issue that Ingrid Leary's raising, I wanted to compare the two separate powers, so the existing power to impose conditions versus what's being proposed here to impose conditions, because they are different. So the current power is under section 320, and the language there is that the conditions imposed on release may be any conditions that the judge thinks fit to impose in the circumstances, including all or any of the following. It then lists 3 quite specific potential conditions that can be imposed. So applying the rules of statutory interpretation, Aestum Generis says that the general word shall not extend in its effect beyond the subjects that are listed. And in this case, again, while it appears to be a broad power, it's actually listing 3 very specific circumstances. The new power, which again Part 4 is referencing for these people who already have conditions imposed on them under Section 320, is 324F, apologies. Now, in that new power, it feels like much more of what I would call a God grant. So the power is very broad. It says, may impose any other condition that the judge thinks fit to impose in the circumstances, including, and then it uses the words without limitation. And those, Madam Chair, are the key words here, because it says to me that the powers to grant conditions are much broader than those foreseen in the current legislation, where the 3 specific instances, if you like, are listed quite explicitly. Then you go from there to the Section 7 advice to the attorney, which does examine whether this is a reasonable limitation on freedom of movement and association generally, and it concludes that they are. So again, no Section 7 Bill of Rights Act vet. However, it doesn't consider the circumstances where you could have someone who had been detained partially because of criminal offending, had conditions imposed on them under current Section 320, and once this bill passes into law, would have new conditions put on them on the basis of their past offending. Now, that would potentially rub up against Section 26(2) of the Bill of Rights Act, which says no one who has been finally acquitted or convicted of or pardoned for an offence shall be tried or punished for it again. Now, the courts have taken quite a broad view in terms of what constitutes being punished. So certainly the imposition of further conditions could fall within the scope of what the BORA is considering here. And it just strikes me that it's not something that legal advisors turn their minds to, and it's not articulated as an issue in the Bill of Rights Act. And so at this committee stage, just wanting to hear from the Minister whether she had turned her mind to these circumstances, and if someone had been convicted of something, whether that could be, someone had been convicted or acquitted or pardoned of something, whether that occurrence, if you like, could be considered as part of justifying the imposition of new conditions under this new section, under the new Act, that would not have been possible under current Section 320.
Honourable Casey Costello.
I just think it's important to clarify that this part we're talking about relates to the civil detention components, not the the detention components that so criminal convictions, all of that stuff has nothing to do with this part. This is about the continuation of existing conditions and therefore variations of conditions of that part would occur under this. So it's a very different component.
Dr. Lawrence Shunan.
Thank you, Madam Chair. I just have one question for the Minister for Schedule 2. And this is so this is Clause 58, Consequential Amendment of Part 3. And in Schedule 2, it makes amendments to the Search and Surveillance Act, and particularly 293B. And we're looking at may apply for and execute warrant to enter a dwelling or marae and search for a person. I want to check with the Minister in terms of the scenario, for example, because it says dwelling or marae. Now, in the existing search and surveillance, dwelling is, I want to check if the dwelling is based on the definition, if any, in the Search and Surveillance Act 2012, or are we looking at a definition of dwelling that we have just seen in a previous part of this bill, which is Clause 25 and the new 286 subsection 3. So in that particular definition, dwelling, it does specify that dwelling has to be, means any building or part of a building that is used for residential accommodation of any kind and includes a garage or shed associated with the building or part of the building. However, in both that definition of dwelling as well as marae, you're looking at a fixed construct, essentially, but not necessarily the grounds. So, for example, hypothetically speaking, that a person is in a tent, either on the grounds of a property or within a precinct of a marae, does that mean that the immigration officer could not search that because it's neither a dwelling nor a marae?
Madam Chair.
Ricardo Menendez-March.
Thank you, Madam Chair. I've got a specific question in relationship to Schedule 2. One of the grey areas in relationship to immigration officers' sort of ability to enter different premises is in relation to faith-based institutions. And I do raise that because quite a few years ago now, this would have been under the previous national government, we did have, for example, some Indian students who were facing deportation, and they were in the Unitary Church because that was one of the institutions that often are deemed to be kind of out of touch for immigration officials. But it's what I'm seeking clarification for is whether it's by convention. Pardon? Well, interesting. The member may wish to seek a contribution if he wants to challenge my question. But
The question here is about whether there's the current definition of dwelling would include faith-based institutions. And that is important because it's not just in New Zealand, but across actually different jurisdictions, faith-based institutions having one of those areas that are seeing a sort of safe havens for people who may be trying to, for example, sometimes resolve, like even having like a current appeal in front of a minister or in the IPT while they may be liable for deportation. And so I do want to understand how those institutions may be captured under Schedule 2 or otherwise. And I think clarification on that would be useful because we do have a history of faith-based institutions actually being a safe haven for migrants who may be appealing to the minister, for example, which it is their right, despite what the heckles from the ACT Party may otherwise try to assume.
Venushi Walters.
Thank you, Madam Chair. And I just want to make a brief contribution to clarify my earlier question to the Minister. So I do understand that it's a civil regime, but my question was more in relation to the Bill of Rights Act provisions 26.2, which are about a second punishment, and that punishment could be a civil punishment. So a second punishment, even if it's a civil punishment, then touches on section 26.2. If it's the decision maker is bearing in mind a prior conviction or a prior acquittal or a prior pardon as part of their decision making to impose the civil punishment. And in this case, the civil punishment would be the imposition of those further conditions.
Madam Chair,
Ryan Hamilton.
I move that debate on this question now close.
The Minister's just taking some advice, so I'll just see if the Minister wants to take a call first before I take your motion. Honourable Casey Costello.
Yeah, I think we're getting back again. It's not a civil punishment. This is a detention process that is being managed through, as you know, in the immigration process that we're talking about. This is not a punishment, it's a detention process.
Madam Chair. Madam Chair.
Simon Court.
Madam Chair, I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. Contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku Te Wheres. Maria Mena Kapkingi.
The ayes are 68, the noes are 49. The question is agreed. The question is that Part 3 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku Te Wheres. Maria Mena Kapkingi.
Yeah. Can we clarify the Labour Party vote, please? The ayes are 102, the noes are 15. The question is agreed. Schedule 1, no debate. The question is that Schedule 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called. Please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Party Māori. Taku Te Whereas. Maria Mino Kapkingi.
The ayes are 102, the noes are 15. The question is agreed. Schedule 2, no debate. The question is that Schedule 2 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Party Māori. Taku Te Whereas. Maria Mino Kapkingi.
The ayes are 102, the noes are 15. The question is agreed. Members, we now come to our final debate, clauses 1 to 3. This is the debate on title, commencement and principal act.
Yeah.
Ingrid Leary.
Thank you, Madam Chair. I'd like to start with some questions regarding the commencement, because what we see in the amendment paper today is that section 2A subsection 3 refers to a number of sections which will not come into effect until the first anniversary of royal assent, and the rest of the Act comes into effect upon royal assent. And when I look at those sections, they relate specifically to the electronic monitoring system. We are really happy with the changes in the amendment paper around safeguarding people so that electronic monitoring is not used as a form of detention, and that it has been narrowed. And it is on that basis and from the Select Committee work and the understanding that electronic monitoring was one of the biggest issues for us that we have supported this bill. I just want to seek clarification from the Minister, and I apologise that I'm asking for some context here, but it is an amendment paper that we saw today. Does this mean that there will be a transitional period of about a year where the limiting of the electronic monitoring provisions will not be in effect? And what does that mean if there were to be a mass arrival in that time? I would like to remind the House that the reason Labor is not fixated but very concerned about electronic monitoring is because of the international conventions and legal principles, which include the ICCPR, the 1951 Convention relating to the status of refugees, Universal Declaration of Human Rights, the UN High Commissioner for Refugees, and they all basically say that deprivation of liberty should only be used as a last resort, and if at all, that electronic monitoring should not be seen as arbitrary, that it shouldn't be a digital shackle. It talks about privacy concerns, vulnerability, and the issue that the Minister has mentioned herself in some ways when she talked about immigration detention being different from criminalisation and from civil punishment, and yet there is this blurring around the edges. And the overwhelming message in international law and best practice is that the goal should be to manage individuals in the community through less intrusive means wherever possible. Now, because this amendment paper is quite new, it may not have the effect that I think it has. And in that case, I'd like to know what effect it does have. But it just feels like there is now a separation of when everything will come into effect. So you've got the original amendment from royal assent, and then you've got these subsequent amendments that have come in that limit the intrusion into people's rights that are going to take longer, if I am reading that correctly. And And that might explain then why my amendment paper on Section 40A and 40B were declined. But in the absence of that, what is the situation in that transition period? And even if I am not interpreting that correctly, it still does cause some confusion, clearly for me as a parliamentarian, but probably more so for people trying to work out what the arrangement is around electronic monitoring and the different timeframes. A subsequent question, which is similar, and I won't dwell on it, Madam Chair, is the other period of time which talks about some of the sections, I won't read them all out, coming into force 3 months after royal assent. What is the rationale for that? And what is the advice around, clearly there's been some advice, I would assume, to have these different milestones coming in. Hopefully they are to support the human rights of people. They may well be to make sure that the regime is set up adequately to be able to cope with an influx of people. My concern is that if there isn't a system and process in place that assures the limiting of the electronic monitoring provisions that we are so keen on in Labour, and which is part of why we are supporting the bill as it's currently being drafted up to the amendment, then we'd like to hear from the Minister exactly what that looks like for clarity. Thank you.
Honourable Casey Costello.
Yeah, I think just for clarification, the delays and the commencement of the electronic monitoring relates purely, as you sort of suggest in your outline, it's about establishing the systems and processes to ensure that all of that system is in place. It is a complex system to ensure it's done right, so it's that 12-month period to ensure all of that contracting and system is set up in place.
Ingrid Leary.
Subsequent to that then, is it correct to understand that the electronic monitoring may still take place, but with the much broader incursion into the rights of people who might be detained under the mass arrivals, or will there be no electronic system in place?
Ricardo Menendez-Marsh.
Thank you, Madam Chair. I have two questions. One on title, which is, considering that the bill actually increases the number of people who would be liable for deportation, does she think that the title accurately describes the bill to a lay person watching this debate? Because otherwise, who is the system supposed to keep the integrity for? This term of system integrity is used as a catch-all phrase. I think it's interesting because I remember the minister herself in the second reading talked about and criticised I think our party for talking about slogans, but I think system integrity is actually a relatively broad term that I think can be weaponized. So I'm curious to know as to whether the reality that the actual provisions on this bill, and this bill actually has quite a few different moving parts, whether the title actually genuinely describes what the bill does. Now, on the commencement, I did want to ask also on the provisions which will come into the first anniversary of royal assent in relationship to electronic monitoring. Did the minister receive any advice around, for example, the procuring of the devices that would be needed to be able to adequately implement this bill, and whether part of the 1-year period would be to also, for example, procure these devices? Has she already started work or to receive advice in that regard? And if so, what is it? Because I kind of can see that the 1-year gap could be also to sort out some of these devices that would be needed. And if that is the case, how many devices is the government looking at procuring in order to be able to make sure that once we reach the first anniversary of royal assent, should there be this mass arrival that we've been told that we need to prepare for, despite kind of no substantiation of evidence that it is coming, that will actually be ready? And if so, will a year be sufficient to adequately prepare and procure the necessary devices?
Ingrid Leary. Oh, Honourable Casey Costello.
So just in terms of the previous question, the electronic monitoring wouldn't come into effect until the 12 years, so there wouldn't be any interim electronic monitoring system in place.
Madam Chair. Ingrid Leary had previously stood up to make a call, so I'll take a call from Ingrid Leary.
Thank you. It's just around the title as well. As I've previously noted, there's kind of a strange twinning of the mass arrivals part of this bill, and then there's also the fiscal sustainability and system integrity. And what we heard from the previous minister and the chair was that the fiscal sustainability actually relates in a very narrow way to levies that respond to visa applications essentially, and the funding of health and education, and making that a little bit fairer, but also being able to extend the powers of it. The system integrity part probably relates to both, including the mass arrivals part. And I just wondered if it would be clearer if the title should read Immigration, Visa Fiscal Sustainability and System Integrity Amendment Bill. Just getting the word visa in there so that when we're looking at those sections about the levies and all of that, we're not going to get confused and think that that relates to mass arrivals, because in some ways it probably should have been in a separate bill. If we can add that into the title, it's very clear to us that under the section 2, which talks about fiscal sustainability, that levy section is very narrowly focused, and that we could expect, if we want to look at the affordability of what is being proposed, and I do think it will be value for money because ultimately it's going to save money down the track, but we're not going to be looking into this bill for that affordability. It's been made clear to us things like policing, but the airports being stepped up to be able to cope with this kind of system, the training that's required would come from a general taxation and not from here, but that's not very clear from the title at the moment. Thank you.
Catherine Weir.
I move that debate on this question now close.
The question is that debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Party vote's been called for, please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori. Tāku Te Whereas. Maria Mano Kapakingi.
The ayes are 68, the noes are 49. The question is agreed. The question is that Dr Lawrence Yunan's tabled amendment to Clause 1 be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand
8
First.
votes opposed.
Te Pāti Māori. Tāku Te Whereas. Maria Mano Kapakingi.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku Te Whereas. Maria Mano Kapakingi.
The ayes are 102, the noes are 15. The question is, yeah, that's right, Clause 1. The question is agreed. The question is, we've had so many votes today. The question is that the Minister's amendments to Clause 2 set out on AP number 445 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. Please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku Te Wheres, Maria Meno Kapakingi.
The ayes are 102, the noes are 15. The question is agreed. Question is that Dr Lawrence Yunan's tabled amendment to clause 2, amending subclause 1, be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The ayes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori. Tāku Te Wheres, Maria Meno Kapakingi.
The ayes are 49, the noes are 68. The question is not agreed. The question is that Dr Lawrence Yunan's tabled amendment to clause 2, inserting new subclause 2AA, be agreed to. All those in favour say aye. Aye. Contrary, no. No. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori. Tāku Te Wheres, Maria Meno Kapakingi.
The ayes are 49, the noes are 68. The question is not agreed. Question is that clause 2 as amended stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. No, have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand
8
First.
votes in favour.
Te Pāti Māori. Tāku Te Wheres, Maria Meno Kapakingi.
The ayes are 102, the noes are 15. The question is agreed. The question is that clause 3 stand part. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The noes have it. Party vote has been called for, please, Clerk.
New Zealand National.
49 in favour.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāku Te Wheres, Maria Meno Kapakingi.
The ayes are 102, the noes are 15. The question is agreed. I will report this bill with amendment.
The House is resumed.
Madam Speaker, the committee has considered the Immigration, Fiscal Sustainability and System Integrity Amendment Bill and reports it with amendment. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion, please say aye. Aye. To the contrary, no. The ayes have it. The bill is set down for third reading immediately.
Madam Speaker.
The Honourable Nicole McKee.
Madam Speaker, I move that the Immigration, Fiscal, Sustainability and System Integrity Amendment Bill be now read a third time. This bill is an important step forward for New Zealand's immigration system and supports the government's broader priorities of driving economic growth and attracting the skills New Zealand needs to thrive. A strong, fair and responsive immigration system is essential to delivering on our ongoing Growing for Growth plan, supporting businesses and ensuring New Zealand remains an attractive destination for talent and for investment. Immigration is vital to our economic and social prosperity, and this legislation helps to strengthen the foundations of a system that New Zealanders can have confidence in. It ensures that our settings continue to be fair, transparent and fit for purpose in a changing world. This bill is important to ensure that compliance and detention settings are more balanced and transparent, to better align our provisions with the recommendations of KC and Heron KC reviews, strengthen both immigration risk settings and the protection of migrants from exploitation, enable the immigration system to respond to challenges with greater flexibility, and allow the costs of the immigration system to be recovered more fairly. The bill delivers on these objectives through a series of targeted, sensible reforms. It introduces stronger safeguards for vulnerable people, including a higher threshold for the detention of asylum seekers and judicial oversight of out-of-hours compliance activity. These changes respond directly to the recommendations of Victoria KC and Michael Heron KC made in their independent reviews, and they reflect our commitment to transparency and accountability. It also addresses migrant exploitation by creating a new offence for charging premiums for employment offers. Charging for job offers is already illegal under New Zealand law, but it only applies when the victim is an employee here. It does not cover people who are extorted but who never arrive or who arrive to find that the job offer has evaporated. This awful practice is causing real harm and is undermining trust in our immigration system. By closing these legislative gaps, we can prosecute more cases and send a clear message that exploitation is not tolerated in New Zealand. The bill strengthens immigration risk settings by clarifying deportation liability for residence class visa holders who commit serious offences, and by enabling the cancellation of residence status in those very rare cases where a person poses a significant security risk but cannot be deported immediately. These measures protect the integrity of our system while respecting our human rights obligations. Flexibility is another key feature of this bill. It allows the Minister to respond quickly and fairly to unusual events, such as airline disruptions or natural disasters, where large groups of people are stranded in New Zealand. This ensures that our system can adapt to real-world challenges without unnecessary bureaucracy or costs. I know there have been concerns expressed about the potential for overuse of those powers, but I'm very confident about the scrutiny and transparency provisions in the bill. The Select Committee further slightly raised the bar regarding ministerial consideration. The Minister will have to certify that an exercise of the power is reasonably necessary to address the situation and that it is a very appropriate addition. Finally, the bill future-proofs immigration funding by creating options to share costs more fairly and sustainably across those who benefit from or create risks for the immigration system, or, with appropriate safeguards, including consultation, those who benefit from services in the wider community. The amendment paper that was passed by the House made minor and technical changes that will ensure the workability of the electronic monitoring provisions. I look forward to those provisions being available. Electronic monitoring, where it is practicable, will be a very positive alternative for people who would otherwise have to be held in corrections remand facilities. There is a lot of work for both the Minister's officials and corrections officials to operationalise electronic monitoring, which is why those aspects of this amendment bill will not come into effect until a year after royal assent. Madam Speaker, I would like to acknowledge the many submitters who engaged in the Select Committee process. Their insights have strengthened the legislation. And also, on behalf of the Minister, she is very grateful to the Education and Workforce Committee, which undertook a thorough and thoughtful review, ensuring the bill reflects robust policy and serves the public interest. She also thanks her parliamentary colleagues for their constructive debate and careful consideration throughout all stages of this bill. Madam Speaker, this is a balanced, forward-looking package of reforms that will help New Zealand manage risk, protect migrants and maintain confidence in the integrity of our immigration system. I am proud to commend this bill to the House.
The question is that the motion be agreed to. Honourable Phil Twyford.
Thank you, Madam Speaker. This bill is not perfect, and the Labor Party would have preferred to see stronger safeguards, that is, clearer limits expressed in the legislation and stronger judicial oversight on the new powers that allow the Minister of the day to cancel a residence visa of someone who is categorised as a threat to national security, on the use of electronic monitoring, on the conduct of out-of-hours compliance visits, otherwise known as dawn raids, and perhaps most importantly, on the detention of asylum seekers. But on balance, we took the view that the positives in this bill, judicial oversight on the detention of asylum seekers, a new bespoke regime that recognises the particular vulnerability of asylum seekers, the out-of-hours compliance regime, which requires a warrant of commitment, and a much stronger and clearer offence in law for people who seek or receive a premium for a job in order to get a visa, as one of the ways of combating the exploitation of migrant workers. And on the other elements in the bill, the extended levy-making powers, the ability to cancel the visa of someone who's classed as a threat to national security, the flexible powers, that is the ability for the Minister to make a special direction for a whole class of people, and the provision around deportation and criminal offending. On all of those, probably on balance, Labor took the view that they are, on balance, probably useful and helpful additions to the system. Why is this bill important? Well, around the world right now, immigration policy is a political dumpster fire. Right-wing populist parties in so many countries, but including in the United States and across Europe, have campaigned against and demonised refugees and migrants. And they, sadly, they have succeeded in so many places. Political parties who were once committed to the 1951 Refugee Convention are now engaged in a race to the bottom, and it distresses me to see the UK Labour Party and other European social democratic parties engaging in that race. Madam Speaker, New Zealand needs immigration. The demographic modelling is very clear. We can't survive in the same political and economic form without more young, skilled, energetic, hard-working migrants to come here and help us develop this country. We have so many industries that have structural labour shortages. We need migrants, and we need to get better at welcoming them here to make new lives. Respect for human rights, the 1951 Refugee Convention, it's part of our modern history of this country, and the values that underpin it, welcoming people who are escaping genocide and persecution to come here and make successful lives and become great New Zealanders, that is absolutely at the heart of who we are as a people. And it pains me to see parties like New Zealand First in this Parliament deliberately mimicking the corrosive and divisive anti-migrant rhetoric of the UK Reform Party. And when you add to that attention seekers like Brian Tamaki openly and deliberately using racist anti-migrant rhetoric in a desire to get a few more dollars in the collection plate, these things, this kind of political rhetoric gives permission to the racists to divide our society and do damage to our democracy. And in my view, the best thing that we can do as a country and as a parliament is to strengthen, not weaken, our adherence and commitment to international human rights standards. And secondly, to be constantly improving and fine-tuning the immigration system in a way that makes it clear to the public that the system is fair, it is well administered in the interests of the people of this country and, of course, of migrants, to retain that public confidence in the system. It is incredibly important that in this Parliament and in New Zealand society that the centre holds, that we maintain a consensus, hopefully a cross-party consensus in this Parliament, that New Zealand needs migrants, that we are better for migration, that migrants make an overwhelmingly positive contribution to our country, and that we need to get better at welcoming them, helping them settle here and become great New Zealanders. And how we welcome newcomers and how we make them feel and how well we assist them to settle goes to the heart of our values as New Zealanders and who we are as a nation.
Apologies, I was just taking attention to some detail. Ricardo Menendez-Marsh.
Thank you, Madam Speaker. We have more in common with asylum seekers and migrant workers than we do with billionaires and politicians on the other side of the House who seek to divide our communities and hand out billions of dollars to landlords, the fossil fuel industries and the tobacco industries. This is a Trojan horse of a bill, because for all the virtuous signaling that we have heard from the previous members, the reality is that this bill diminishes the rights of migrants, and it also expands the liability of deportation for migrant communities. It also keeps painting refugees as though they are a security threat. So when we hear narratives about the integrity of our immigration system and how important it is to Manaki migrants, why don't these politicians, from whichever side of the House they come from, focus on genuinely improving the human rights of migrants, which, by the way, are not even recognized adequately in our Immigration Act, because the policies that come out of the Immigration Act are effectively exempt from the Human Rights Act. Migrants are actually not protected in legislation when it comes to the human rights adequately. And so it's really important to put it on the record that what this bill does is it creates additional tools for the minister to effectively deport migrants. And to say that this is about protecting migrants by, adding an additional charge for charging premiums offshore and criminalizing that, while at the very same time gutting the support that exploited migrants can receive, is a joke. This is not a government that takes migrant exploitation seriously, because if they did, they would not have been cutting the length of time that someone can be on the migrant exploitation protection visa. Simply not a serious government when it comes to migrant exploitation and treating our migrant communities with the respect and dignity that they deserve. On the government side, we have had the New Zealand First Party scapegoating migrant communities left, right, and centre. In fact, their whole fuck-up of a party has been on scapegoating migrant communities. On the other one, we have had the ACT Party, who has continuously scapegoated refugees and painted them as a security threat. And then we've got National, who have not hesitated to using the language of the far right when it comes to opening the floodgates and their language. And I do want to say I'm incredibly disappointed that the Labour Party continues to support this kinds of legislation. But then again, I remember that as the Greens, we have been fighting against unjust deportations, whether it's a Labour or national government. The truth is that this came off the back of a mass arrivals bill that was not supported by human rights organizations introduced by the previous Labour government, who refused to listen to the voices of human rights organizations who said, why this bill? And they said, because we've got to prepare. In the same way, the government side has said, we have got to prepare for mass arrivals. But you know what they have not prepared for? Our underfunded health system, our education system that is struggling to keep up with the needs of students, our public housing stock. They prefer to use slogans of getting prepared for mass arrivals by boats or planes that have never happened and have not been able to be substantiated as an imminent threat. But the things that we do know we have to prepare for, they have failed to adequately resource. They have gutted our public housing infrastructure. They have gutted the ability for us to have interregional rail so that we can connect our towns and cities. Instead, they have given billions of dollars to the wealthy few and the companies that are wrecking our environment and our planet. If they are so serious about preparing for the actual risks that our country faces, they would be turning their heads to issues around infrastructure and the cost of living and the climate crisis. Not this bill that seeks to continue treating migrant communities as a security threat when most asylum seekers are actually lacking adequate support for them to be adequately settled in our communities. And to use one horrid attack in West Auckland as the one example to justify stripping residency from asylum seekers is honestly disgusting, because we saw charities on the ground as well as advocates, including a former Labour Party MP from a refugee background, who at the time rightfully pointed out that that attack should absolutely not be used to diminish the rights of asylum seekers. And what do we have now? A bill that seeks to strip residency status from people who may have sought asylum if they are deemed to be a security threat. And when we talk about a security threat, it's also disingenuous for the government members to point to issues around terrorism, again, pretending that refugees pose as a terrorist threat to our country. The definition of security in our legislation also includes issues in relationship to reputational damage effectively to our country, which could be weaponized against our communities. And we have seen that in the past in the way that Black and Middle Eastern communities have been weaponized and targeted by politicians on the other side of the house. And not that long ago in the previous national government, we saw an opposition that was also quite willing to scapegoat Asian communities for a housing crisis that we were experiencing. The political football of targeting migrants and refugees and using that as a distraction to not deal with the serious issues that we had at the time, right? Housing, like healthcare, that is actually supported by countless of migrant workers who simply want to be treated with respect and dignity and yet are experiencing unsafe staffing conditions. Additionally, this bill seeks to try and remediate the cuts that the government has made to our public services like health and education by charging migrants levies without recognizing that migrant workers already contribute disproportionately so to the tax base and to the services that we all need and use. Why? Because migrants, especially in the first few years of being here in this country, are unable to access many of these services that we all need, yet they're contributing in tax. Now the government, after cutting our healthcare system, after gutting our infrastructure and instead passing that on to the wealthy few, have chosen to put in place levies. And it's interesting that Casey Costello, who tends to just use Philip Morris's lines, says repetition, when actually, in her contributions in relationship to this bill, she has failed to own up to the fact that her own leader has had a career of scapegoating migrants and refugees, and all that she has said during her contributions has been slogans and completely frivolous contributions that do not address the issues in front of us. It's actually disgusting that we have a New Zealand First Party that is quite happy to form a coalition with the National Party who shows up to ethnic communities events and does not own up to the fact that they have decided to form an agreement with the most anti-migrant, anti-refugee party in this parliament. The Green Party, instead of causing division by targeting migrant communities, is committed to taxing the wealthy few so that we can all have dignified lives, so that we can fund our public services that our communities need, instead of charging levies through this bill to make up for the cuts that they have made, because they have realized that they're now having to make up for the shortfall due to the billions of dollars they have handed out to landlords, the tobacco company, and the fossil fuel industries. And when it comes to electronic monitoring, easy to say that it's a better alternative to detention when it comes to mass arrivals, when it was once again, parties on both sides who supported having a mass arrivals regime. We tried to add additional protections for people subjected to electronic monitoring during the Committee of the Whole House stage. We tried to put an amendment to exempt children from being subjected to electronic monitoring, and that was not supported by the government side. And what that tells me is that they seem quite happy to have children escaping some of the most harrowing conditions that one can ever imagine, being subjected to policies like electronic monitoring. This government paints these issues of asylum seekers as though we are receiving a huge amount of asylum-seeking claims. But last year, Mr. Speaker, we had one asylum-seeking case per 10 days. That's a tiny fraction compared to the claims that countries like Canada, the US, and the UK see. Like, extremely small amount compared to others. And so what we have as a country instead is an opportunity to boost the support systems and the judiciary, who can often help process those very same claims so that asylum seekers can be processed in a dignified manner, as opposed to pushing forward legislation that simply increases liability of deportation and pretends that the government cares about migrant exploitation, when every other action that they have taken tells us the exact opposite. For example, they could have decoupled work visas from single employers to give migrant workers better mobility for when they are in exploitative situations, and they have chosen not to do so. Once again, the Green Party will keep fighting to hold both major parties to account for their policies on immigration and their track record of, when things get tough, pointing the finger at migrants instead of addressing the reality that we've got billionaires hoarding up a stupid amount of wealth at the expense of our communities, and property speculators who continue making a buck while people go without. The Green Party does not support this bill and will fight to overhaul our immigration system so that it genuinely puts human rights at the center of decision making.
Dr. Panjit Palmer.
Thank you, Mr. Speaker. I don't know which bill that member was talking about, but I'm taking this call on Immigration, Fiscal Sustainability and System Integrity Amendment Bill. And Mr. Speaker, I'm taking this call on behalf of ACT to support this bill. And we know, Mr. Speaker, that immigration is important to our nation, but immigration doesn't mean open borders for anyone or everyone. And I know that is what the Green Party wants, open borders for anyone and everyone. They don't care about national security. They don't care about safety of our communities. They don't care about immigration system supporting our economic activity. They don't care about those things. All they want is...
Point of order, Ricardo Mendes March.
Offence at the imputation we don't care about national security.
You can't
I take offence at the comment.
You can't take personal offence on behalf of a group of people.
I take personal offence. I'm part of the group that was mentioned.
Wait, hold a sec. I'll just take some advice from the clerk. Okay, so the advice I have received is that because this is a wide-ranging debate, and the member himself has been wide-ranging in his comments as well, in terms of his references to other political parties, that is also afforded to other political parties to be wide-ranging. But I would ask the House to not be personal in your comments. Dr. Panjit Palmer.
Mr. Speaker, Mr. Speaker, resuming from where I left, Mr. Speaker, we do really care about national security. We care about supporting our economy, and we do care about supporting our community. And we want to see that our immigration system is healthy, that is not compromising safety of communities or safety of our nation. And that is why, Mr. Speaker, we want to see that our borders are managed in a way we need to. We are learning new things in the immigration system, and we know that people are applying different kinds of mechanisms So they are becoming really innovative to dodge the system. And so we have to keep up, and we have to make sure that our legislation is able to keep up as well. And that is why this bill is so important. Mr. Speaker, the other thing the Green member spoke about is the exploitation visa. He is concerned about exploitation visa, but on this side, we are trying to stop exploitation. We are actually working on the root problem rather than create the problem and then see how we can solve that problem which has been created and let that problem be created even at a bigger scale. We don't want that problem to be created at a bigger scale, but we want to see that we are minimizing that problem, and that is why, Mr. Speaker, we are ensuring that this bill goes through, which is about the integrity of our immigration system. And yes, policies are great, good policies are good, but if there are no compliance checks, there is no point having good policies. And that is why we have put some provisions in this for compliance checks as well. But yes, of course, for out-of-hours warrants, for compliance checks, there is going to be additional oversight through this legislation. Final point, Mr. Speaker, I want to make, I'm not going through all the changes that this bill is making. The other point which I'm really happy to see in this bill is that we know that a lot of people, those who use or misuse our immigration system to bring people from overseas, those who really want to be here in New Zealand, they can't come through the normal legal channels. And so they are enticed to pay for a job offer which doesn't exist. So these people, those who pay for this job, come here to New Zealand, they are not filling the genuine gap that we have in our businesses. They are here as surplus people, Mr. Speaker, I would say, because they just want to be here in New Zealand. And we want to stop that activity, charging premium, whether it happens here or it happens overseas. That needs to be stopped. And we want to see that our immigration system is bringing people, those who are genuinely filling the gap in our economic activity. So overall, Mr. Speaker, I would say it's a great bill. And any party that cares about our immigration system being a sound system should support this bill. ACT Party is really happy to support this bill. Thank you, Mr. Speaker.
Honourable Casey Costello.
I rise to speak on the Immigration, Fiscal Sustainability and System Integrity Amendment Bill. New Zealand First has always stood for a sustainable immigration system that serves the interests of our people, safeguarding the vulnerable ones from exploitation. Mr. Speaker, before entering this House, I was actively involved in both the investigation and advocating for exploited migrants and invoking a lot of resource and energy in terms of providing the prevention that immigration from exploitation that immigrants often need to have. It is from this experience, Mr. Speaker, that I appreciate how important these pieces of legislation are. New Zealand First's previous manifesto has consistently emphasised the need for integrity in the immigration system and a fairer cost sharing so that New Zealanders are not unfairly burdened. This allows the system sustainable. It is important in this House, Mr. Speaker, that we stand on our record of what we've delivered and how we've achieved for the betterment of this system. And I think this piece of legislation will deliver exactly that, a track record that shows that we are committed to ensuring that exploitation is eradicated from our country, that our immigration system is sustainable and fair and transparent, and that we are prepared for any event, should we need to address the fairness of our system. And therefore, Mr. Speaker, I commend this bill to the House.
Dr. Lawrence Unan. And
this
is the next one. Dr. Lawrence Unan.
Okay.
Just for clarity for the House, if Te Pāti Māori is not here, that call drops down to the bottom and people can compete for it at the end. And so it will then go to the next call, and this is a split call with the Te Pāti Māori and the Green Party. I call Dr. Lawrence Unan.
Cool. Thank you, Mr. Chair. Thank you, Mr. Speaker. This is a shameful bill, and we are proud as the only party in Parliament that opposes this particular bill. So what this bill does is it creates fear. It wants to divide and conquer and create a distraction on the fact that this government and successive government have not put enough funding into our core infrastructure and public systems. This is creating an ice light of the US by saying that, you know what? we don't want the judiciary to actually exercise discretion, the experts, the legal experts of this country to exercise discretion. What we want instead is to make sure that that power is held with Immigration New Zealand, so that way they can deport people as they wish. The fact that they have changed the language from convicted into guilty and also found guilty as well as pleaded guilty is shameful. Legal experts have submitted to say that the status quo is sufficient. The broadening is not going to be good, and there's no evidence to say that the broadening of this is going to be good. This is not going to be a bill that is going to be palatable for my communities, because my communities are the ones who are going to be affected, not by someone who apparently categorically say that they will support the bill for their leader just to turn around and say that they don't support it 2 days later. This is a bill that just basically said that we don't trust the law and order system that we have here in Aotearoa. We don't trust the decision of the judges, unless the judges is taking a punitive approach, in which case, you know what, they are doing a great job. What this bill does, it is going to be looking at punishing children. It is going to make sure that people who have already suffered from trauma are going to be further traumatized. As we are seeing this bill, we are seeing that Hapu and Iwi have not been consulted as a part of this. Te Tiriti is not a part of this. There is no part of this bill that talks about manakitanga as a core principle of the Te Tiriti or Waitangi. Because when people are coming here, rather than taking the approach that we should be taking, instead we're saying, don't you dare do anything. Don't you dare express the fact that you have also suffered trauma. Mr. Speaker, we have just recently seen what we have done in terms of the abuse in state care. And the Greens has also been incredibly vocal of the fact that we want to break some of these vicious cycles that we're seeing. Yet in this bill, we're seeing that that same level of care, that same level of understanding have not been extended to asylum seekers, to refugees, to migrants. And the fact that every other party in Parliament is supporting this is shameful. All of you are happy to go to meetings and community events and celebrations and pose with the ethnic communities to get a photo, to get their vote. But when the time comes to speak on behalf of our communities, you shy away. You stay silent. You know what? This is something that is going to create a double tax system. You're saying that migrants are coming here, they are working, they are residents, they are doing all this, they are paying tax dollars, but that is not good enough for you. They should be paying additional levy on top of it because they are putting our health system and public education system in burden. You know what? So does the fact that decades of underfunding in the education and health system is why it is. Stop scapegoating my communities. Stop scapegoating my communities. Seriously, this is something that we have seen over and again. And the previous speaker, Ricardo Menendez-March, has spoken on the fact that we are seeing these sort of bills coming through regardless of who is in power. During the committee stage, people in this very party, regardless of who you are, have raised concerns over some parts of it, yet they still support this bill. They are happy with the fact that levies are going to be used not for the purpose of levy, but it's an extra tax for the migrant communities. That is shameful. At what part of this bill at what part, as being a New Zealander, is it okay for us to do that to one group, while at the same time we're giving $2.9 billion to landlords, $200 million to offshore oil and gas, and $200 million to the tobacco industry. So, Mr. Speaker, the Greens will fight for migrants, and we will not support this bill, and apparently we're the only party here who are willing to do that.
Colbert. Thanks, Mr. Speaker, for giving me the opportunity to speak on the final reading of this bill. I just want to again acknowledge the great work of the Select Committee. We clearly did good work in terms of the amendments, and that was talked about both in the second reading and in the committee stage. So therefore, I want to commend it to the House.
Helen White.
Speaker. I first of all want to acknowledge the emotion in the House today, particularly from my Green colleagues, but also from my ACT colleagues, I think. And obviously this is the kind of bill that becomes an issue in, And I would suggest that it, in fact, has been a robust debate throughout, where really the whole issue and the issues in this bill have been canvassed robustly by this House, and that's what it's there to do. I support this bill, and I want to talk about why. The first thing I want to talk about is something that is not been talked a lot about, but was talked about on the committee stage, and that is the issue around premiums of employment. And I'm talking about that because I know a little bit about it from a practical level. When I was an employment lawyer, I had this case when I was relatively new to the profession, and I had 3 Indian chefs who had been kicked out of their employment when they'd attempted to join the union. The employer had kept their passports, and they were in a really difficult position with regard to immigration. And we told their tale in what was, I think, the employment tribunal at the time rather than the authority. And we had an interpreter tell their tale, and their tale included that they had given to the employer premiums, and the authority or tribunal member at the time dismissed this out of hand, said that's just ridiculous, that wouldn't happen. And the interpreter stepped out of the role as interpreter because he was so shocked and said, "Excuse me, sir, but this happens all the time. This is called bakshish. This happens all the time." And I look back on that case because it had some other features which were pretty shocking. These guys were working 92.5 hours a week. They were working dinner and lunch, and they were living on the premises, and their work was dismissed by the employer as really just, they weren't really doing anything at all. It was really, they were layabouts, they were lying, etc. We had a contract which had a company seal for one price, which had been given to immigration, and a company seal on another price per week's work on another. The tribunal awarded an amount under the minimum wage for the first 40 hours, but refused to allow any extra money for the extra hours worked because there was no requirement under our law for those things. These are the things that make relationships like that exploitative. And I think back to that time and I think, if only that tribunal member had taken it seriously, because it was outside of the norms and values of that time, the tribunal member just immediately sided in that way with the employer and thought that these people were lying and making it up. It was just beyond his experience. So I'm glad to see the law catch up a little bit here. And it's a really good lesson for me, because I think there would have been a lot of less pain if we had. And I think some of the concerns that the Green Party have expressed about exploitation are very real. We haven't nailed this one. There's a lot further that we can go to make sure that people are not trapped in exploitative situations when they're migrants in this country. So there are other places we can go. But I think we have to come to this from a realistic point of view. And I wanted to talk about the other situation I know a little bit about, and that is the situation of the Newland stabbing. That was a situation where people knew that the person involved was radicalised. They knew he was very dangerous. He was an asylum seeker. And so they were in a very difficult situation. The judges were in a difficult situation with regard to him being, I think he'd spent more time in the prison on remand than he could be kept on for. So the police were in a really difficult situation, and I think they had 2 officers constantly tracking that man because they were just waiting for the bomb to go off, basically. And that would have not only cost people a lot of money doing that, but people were in real danger. And there was a real price to pay. So when these freedoms are very important to the Labour Party in terms of making sure that we make sure that there is a balance, but there is a balance. There are victims in this situation, and that's not scaremongering. And it's something we have to be responsible about in this House. We have to think our way around really hard problems. We can't always stand on the moral high ground if there are going to be real victims in the situation. And in that case, we didn't have the law right. And people paid a really high price. And so I think it's really important that we think around this and we don't let our sense of moral rightness or get in the way of looking around a problem. That these are tough problems. And now I want to come to probably the one I struggled with the most, which is the mass arrivals. That's a hard thing to do. It's really hard. And we will have supporters in the Labour Party who will be upset by this and not think that we've got it right. And what I would say to those people and to the ones who didn't support us who are in the same position is this is a piece of legislation that attempts, again, to deal with the reality of the situation, which is that we are in a time of great crisis where people will travel a long way to get away from oppressive situations, from desperate economic situations. They will take enormous risk, and we will struggle to cope when they arrive on our shores, and we will do our best to make sure that they are treated justly in those situations. It won't be a case where we will close our eyes to that situation. But these are very real predicaments that we face as a country. And I, for one, would like to see us take on a lot more refugees in this country and expand our definitions. I, for one, see that as being a pathway to reaching out to a world that's in crisis. I'd love to do that. And I'd like to put my actual energy into making sure that we actually do reach out to people in those countries. Not only actually as refugees coming to our own country, but as supporters of their capacity to stay in their own countries. Because from what I understand, most refugees would actually rather be at home. That's their predominant wish, to go home. And I get that. I think that's really important. So we need to not close ourselves off in New Zealand. I appreciate that we can be subject to a lot of forces at the moment that are quite evil. They're quite fear-based. I don't intend to suddenly succumb to those kinds of fears, and I don't intend to encourage them in others. But I think it's incredibly important that we have a realistic law with realistic boundaries, which actually helps protect that, because people won't get fearful if they don't have examples of not feeling safe. That's a really important part of what we're doing here. We're assuring people we learnt the lessons from something like the New Lynn situation when we're responding to it, because of the actual reality of the world we live in, which is not ideal. Not everybody is a saint. And so I am wanting to say that I think that the debate in here over this bill has been robust. You saw how carefully my friend Ingrid Leary went through the bill and asked questions, and you have seen it be tenacious. But we've ended up with a bill that we're supporting. And that's why we're not joining the Greens in opposition to the bill, because this is reality, and we hope that this bill deals with it, if not perfectly, in a way that is thoughtful and is compassionate.
Dr. Vanessa Wienick.
Thank you, Mr. Speaker. I commend the bill to the House.
Vanessa Walters.
Thank you, Mr. Speaker, and just like others to acknowledge that this isn't an easy area to make policy in. We've struck a few bills that have similar themes to this, much like the Countering Foreign Interference bill that this House debated as well. It is a question of really looking at security interests and balancing those against the rights interests that clearly also exist. I do spend a fair amount of time speaking to parts of our migrant community and our former refugee community in Auckland. And whenever I'm speaking about the immigration space, I find myself using the words the God grant when I talk about the discretion that the Minister has. And that's really because of two reasons. Firstly, because the discretion itself, even under the current legislation, is incredibly broad. The Minister has really robust powers to make decisions without providing reasons in the current legislation. But the other reason I call it a God grant is because those powers have this impossible ability not just to affect the lives of individuals, but to affect the lives of generations to come. And I think about when the Honourable Phil Twyford was the Minister for Immigration and Kabul fell. And within days, our government stood up a system to look at who needed to come to New Zealand urgently and set up a system of visas to do so. I think about the families that I know now who have children who will grow up as Kiwis. So again, the God grant seems like a fitting way to term these extraordinary powers in what is rather an extraordinary act. We did, of course, the same with Ukraine, and there will be Ukrainian children who grow up as New Zealanders as well. As it is the God grant, it's also the God grant when a minister decides not to use their powers, as we've seen here this term, when the minister hasn't set up a system in response to the humanitarian crisis and the unfolding genocide we've seen in Gaza. Extraordinary discretionary powers, and probably if you look at the set of legislation, some of the broadest powers that you will see in terms of how it can impact people's lives, which is why several of my amendments at committee stage tried to not provide an anchor on the discretion. I would say they would provide more of a compass in terms of guiding the minister's discretion to direct the minister to turn their mind to our obligations under the Genocide Convention, under international human rights law and humanitarian law. And I say this all to make a very simple point, which is, although those amendments weren't accepted into the bill, those obligations still exist. As this bill becomes an act, certainly on our side of the House, we will be looking to ensure that the minister, when they're exercising discretion under these very broad God grant powers, is turning their mind to international human rights law, humanitarian law, and our obligations under the rights system here. I raised a number of amendments trying to include them, but I also raised a point at the end about the imposition on conditions of people who were released into the community, and that there was potentially some unfairness around that. And the minister's response was that that wasn't a penalty. And I was listening intently. I would just say that there is a trend internationally of recognition in some jurisdictions of the fact that even where there is a civil penalty, even when something is framed as a civil penalty in the law, it can feel like a criminal penalty in truth. And I know that that has happened, for example, in the US, where it's been said that labelling of a sanction as a civil sanction is not determinative of its status, but also in Canada, where the Canadian Supreme Court has rejected the argument. It also noted that it was possible in some cases for non-criminal sanctions to be considered punishment for the purpose of double jeopardy, and the same in the European Court. So those human rights interpretations, in my view, are also very, very important. The final thing I'd say is that my view is that this is one of those bills that should be reviewed. And it should be reviewed very soon once we've seen how it operates in the context of those human rights principles.
Mike Whateroa.
Thank you, Mr. Speaker. It would do well for one party in particular in this House to remember a tried and true saying, a failure to plan is a plan to fail, and this bill is about planning. I commend it to the House.
Speaker.
Ingrid Leary.
Often when we're out in the electorate, we get asked as MPs, why isn't there more cross-party collaboration? And it's quite tricky sometimes to explain that if the government of the day is setting an agenda and then expecting everyone to agree, that is not collaboration. However, today I think as parliamentarians we can be proud that what we have seen is a truly cross-party collaboration and bipartisan journey that started actually under the previous government and shows pretty good lawmaking. I think we can, the indicator of that is that we've landed on something that is not perfect, as the Honourable Phil Twyford said, but it is something that probably all of us can live with, apart perhaps from our friends in the Greens. When I look at the way they have characterised this debate, they have expressed moral outrage at what they see as an impingement on human rights and a targeting of immigrants. I don't share that view, but I do have to say that I was very suspicious of this bill when it was first discussed under our government. And what I wanted to know was really, what is the problem we're trying to solve here? Is this something that is American or Trumpian in its intended impact? Is it hysterical, or is there going to be a real problem? And as times have continued, we have seen continuing issues on the high seas involving asylum seekers and pirates. We have continued to see the huge immigration problems in Europe. And then I'm also reminded of our own recent history with the really unfortunate stabbing in Auckland. We must remember our immigrant communities, but we also must remember the communities that have been impacted by that event and the sovereign inability to deal with a very high-risk, known situation. That is something that was a gap in our law. And we can also go back to the Tampa scenario of 2001, when we did have a mass asylum effectively, because there were the refugees on the Tampa, the Norwegian container ship that happened to be near Australian waters. There was an impending election in Australia. Those people were rejected from there and sent to Nauru. There were hundreds of people on board and 43 children, and 133 of those were eventually accepted into New Zealand by the compassionate decision-making, in my view, of the then Prime Minister, the Right Honourable Helen Clark, who has talked about that event as one of her proudest decisions. And when we talk about the contribution of some of the people from these communities who have endured real hardship and been shown the monarchy in New Zealand, we have Abasakari, who went on to become an international scholar who settled in New Zealand. They have gone on to have families, as Venushi Walters has said, so that we have, descendants of people who have benefited from the manaakitanga that we have shown, and who in turn have contributed immensely to our society, the fabric of our society and the richness of our society. So the problem is there, and as the previous speaker said, the failure to plan is planning to fail. And if I look at what the Green Party are suggesting, if I think of the counterfactual about not having a system, in fact, I think we will end up with a situation, if there is a mass asylum scenario, where it will be way more unfair for the people trying to enter New Zealand. It will be considerably more arbitrary. They will be more exposed to human rights abuses, and that is the last thing I'm sure that the Green members would want. So I think it's really important for us to be pragmatic and understand that this is not a fiction. This is a real risk. It may be a low risk, but it is a real risk, and that is why we need to have a solution which may not be perfect, but which we can all live with. Having said that, I do agree with the comments from my colleagues that we would have liked to have seen some more caveats on some of the extended powers. There are ministerial powers that have been extended and they haven't had the proportionate oversight or accountability in my view, so we will need to keep an eye on that. And also we did see, I think, in terms of looking at a cross-party approach, a really diligent manner which with this bill has gone not only through the House but through the Select Committee, and a minister who seemed very engaged and willing to listen and to make amendments, particularly around the electronic monitoring situation, because we did have amendment papers and also recommendations that came out of the Select Committee which discussed the concern that electronic monitoring would be used for compliance with movement restriction conditions rather than as a more limited requirement, that they would be a boundary protection tool rather than a containment tool, and that is indeed what we have managed to land on, which is quite a big shift from what was originally proposed, and I think that shows the democratic system working effectively. I too would like to have seen the Minister perhaps have more influence in her own executive when it came to the application of what Venushi Walters has described as the God powers, when it comes to visas being able to be granted to the families of those who are suffering in Gaza. I have been continually in contact with many families in my own electorate. We have a lot of Palestinian families down in Dunedin. They have been through hell and back, quite frankly, Mr. Speaker, over the last couple of years. One of my dear friends, my dear Palestinian friends, has gone to the bedside of her incredibly ill father in Gaza with no certainty about the visa status of family members there and also of her own immediate family. And that is a failure of this government, in my view, to do the right thing and to accord the access to families and use those God powers in a way. Now, I'm not suggesting that's the Minister's fault. I just don't understand why the Minister perhaps doesn't have the influence to be able to make that happen when that would be the right thing to do, and she's very aware of the concerns from my community. I'm also a little concerned that a Bill of Rights, a BORA vet, doesn't appear to have been done on this bill. That would have been ideal, particularly given all the competing rights that were involved here. And what we did see through the Committee of the Whole House right near the end was that there could be either an unintentional or an intentional extension of conditions on people who may not normally have that requirement legally as a result of the way the schedules operate. We did ask the Minister and the Chair at the time to explain whether that was intentional or unintentional, because if it was intentional, that would be rather sinister in my view. If it was an unintentional, then it would have been an opportunity to fix that up. And Venushi Walters spoke very clearly about the way that could be done. And in fact, she dropped an amendment onto the table that would have tidied that up really nicely. But unfortunately, we didn't see that. I want to agree with some of the things that the Greens have said, because I do think that there are real concerns in our country about the type of support that we offer to refugees. So while I support the comments from my colleague Helen White about needing to up the number of refugees that we take, because the world is in such a conflicted and vexed and precarious situation, we also do need to ensure that we have resourcing that they can have, not be re-traumatised by their experience of coming into New Zealand. I don't think we have those resources even at the right level currently, and we need to make sure that we do so. So better mental health supports, for example, that might be able to avoid the situation that we saw in Auckland last year. There's no guarantees for that in PTSD type situations, but at least mitigating the risks around mental health scenarios would be really important. And also not just assuming that migrant communities are going to be dropped into a particular city because that's where many of their community are. I know, for example, for many of our rainbow community, they would actually rather be in communities away from immediate families or connections where LGBTQI plus rights are a difficult conversation in their own countries. So we do need more resourcing. We do need to show a bit more love, I think, to our refugee communities. But ultimately, one of the best ways we can do this when it comes to mass arrivals, in my view, is to make sure that we have a well-considered and thoughtful system that treats people fairly and humanely, that protects national security and gives them every judicial process available that we can to make sure that we are treating them with dignity and compassion. I commend the bill.
Grant McCallum.
Mr Speaker, I commend this bill to the House.
Oh, Glenn Miller.
Kia ora, Mr Speaker. And it's a privilege, and it's a heavy privilege to stand and speak to this legislation this afternoon. And as I was in the House last night and a lot of today, listening to the arguments, listening to the critique of this legislation, Mr Speaker, it is, again, not words on a page, but the lives of people and of communities, as we've heard about, people in their own electorates talking about migrant refugee families that will be impacted potentially, or their whānau from across the seas. And Mr Speaker, I reflect on what we're talking about this afternoon and think of the privilege we have to live in these shaky isles, Mr Speaker, the privilege we have to live in such a beautiful place at the bottom of the world, a place of peace, of tranquility, and a place that people want to come to, because for so many people around the world, for so many people there is not peace, there is not tranquility, there is struggle, there is famine, there is war, there is persecution, and the list goes on. So, Mr Speaker, as has been said from the Honourable Phil Twyford, our lead on this legislation, and the following speakers from the Labour Party, we do support this bill, but we do say that it's not perfect. But we know that we need to put things in place to ensure that the protections, that the care of those immigrants, those coming in, are looked after. And as I look at the words and at the different clauses of this bill, I just want to make a point around the 1951 Refugee Convention. And again, we've moved so far into the 21st century and beyond that convention that we just need to pause and again remind ourselves what are we doing as a nation in terms of our responsibility to refugees, to those who don't have the privilege that we have in this space. As I look and as I listened this morning and this afternoon, there were 9 amendments to the Immigration Act. And again, these were about ensuring that we improve, that we fine-tune the immigration system. And we did some work in the previous government on these changes, and I think that we could say that yes, we have a party that is opposing it, but when it comes to the majority of the House, we've landed in a place where we can agree and we can move forward. And some of that is to look at the broadness of a piece of legislation like this, even though it's around a specific group in terms of refugees or those coming to New Zealand. It is interesting as I look through the bill and looking at things like the ministerial powers that this will provide around granting visa applications. When I look at the criminal offending and the deportation changes that it brings, the challenges of when it comes to the need to potentially cancel somebody's residence or visa class application. Then it's looking at the out-of-hours warrants and what was talked about. And as I look And we talk about electronic monitoring, and it is a challenge. And like my colleague Vanusha Walters said, this is a piece of legislation that, if it does pass this afternoon, which I assume it will, that we would and we should revisit it in the years to come to make sure that we aren't overstepping the mark, making sure that this isn't just something that that goes unchecked, because I would rather not have someone locked up in a prison. I'd rather not have someone on electronic monitoring. But if it's a better position than being in prison. We look at asylum seekers, Mr. Speaker. We look at the reason they would want to come here, as I said at the start of my contribution. And we need to ensure that we have and modernise the laws of this place. And again, the last bit is around the immigration levies and what that looks like. So, Mr. Speaker, this is a small piece of legislation that can potentially have a big impact, and we hope that is for a good reason, and that it does protect refugees, that it does protect those coming into our country. And we have a privilege, we have a diversity in this country, and we should share it with others, and we should be open. Therefore, Mr. Speaker, I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. No. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National. 49 votes in favour. New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Takuta Ferris. Mariamino Kapakingi.
The ayes are 102 and the noes are 15. The question is agreed to.
Immigration, Fiscal Sustainability and System Integrity Amendment Bill, third reading.
I call on Government Order of the Day, number 15.
Legal Services Distribution of Special Fund Amendment Bill, second reading.
Mr. Speaker.
The Honourable James Mager.
Speaker, I present a legislative statement on the Legal Services Distribution of Special Fund Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website.
Speaker, I move that the Legal Services Distribution of Special Fund Amendment Bill be now read a second time. Mr. Speaker, look, I would like to firstly give my strong and sincere thanks to the ever hard-working and robust Justice Committee for your consideration of the bill. The committee only seems to have gained in strength and skill over the past 10 months, so I want to congratulate them for the work they've done on this bill. The committee recommended unanimously that the bill be passed with only one change, and that is to the commencement date, and that is because the original date has since passed. So I think that's a pretty sensible change to recommend, and one which I'm sure all members will support. This government is committed to an effective and efficient justice system, and community legal services play an important role in promoting access to justice. The amendments in the bill are necessary to support the long-term funding of organisations that deliver community legal services by clarifying how the Lawyers and Conveyancers Special Fund can be used. The Special Fund works by collecting interest from banks on solicitors and licensed conveyancers' nominated trust accounts. Money in the Special Fund must be paid to the Secretary for Justice for the purpose of funding community law centres. However, as the law currently stands, it is narrowly framed. It's actually unclear whether the Special Fund can be used to meet other expenses incurred by community law centres in the provision of those services, such as their overheads. Without the Special Fund, Crown funding or other sources like donations have to be used. So this bill makes a narrow but important change to provide that certainty to community law centres that money from the Special Fund can be used to meet these indirect expenses. It does not affect the core purposes of the Special Fund, which is to fund community law sentences. The change will support sustainable access to legal services within our communities around the country. And Mr. Speaker, I commend it to the House.
The question is that the motion be agreed to. The Honourable Dr. Duncan Webb.
Oh, thank you, Mr. Speaker. And first of all, want to recognise the really important work that community law centres do. They're an important part of access to justice in New Zealand, and the special fund that the Minister's just referred to is of course the way in which they do get the way that they are funded. I guess it is interesting that last night we were doing a statutes amendment bill, which was full of tweaks and clarifications, and yet here we have a bill which has one substantive clause and is purportedly a tidy-up because the original legislation wasn't sufficiently clear, and why we need to trouble the House with a single bill for a tidy-up rather than putting it in a statutes amendment bill, either the one that we've just seen or I know there's another one which is waiting in the wings. Why we couldn't do that, I don't know. The other question, you know, and this was always my... I was always perplexed and I never got a good answer in Select Committee, to be perfectly honest, as to why this bill is even needed. Because the way the whole framework operates is the money from lawyers' trust accounts goes firstly to the Law Society and then it goes into a special fund which is administered by the Department of Justice, the Ministry for Justice, and then the Ministry of Justice purchases services, legal services from community law centres so they can enter into the various contracts with community law centres around the country. And I don't know who it was, but someone seemed to think that when you purchase you know, community services, and if this is the precedent, there's going to be a whole lot of contracts around the country for all kinds of services which are in trouble. But the idea is that whilst the existing law says you can purchase community legal services, apparently it wasn't clear enough that that includes ancillary services. So all of the things that go alongside it, things that support. So for example, computer systems, administrative staff, library systems, and all of those things that are a necessary part, an absolutely necessary part of providing community legal services. And of course the other thing is community law Aotearoa, which is the overarching body, the idea of an organising and coordinating body across community law centres, and whether in fact that could be purchased out of the special fund because it didn't strictly fit in with the phrase, the purchase of community legal services. Now, to be perfectly honest, I can't accept that when you enter into a contract for purchasing a service, you're not also empowered to purchase those things which are necessary for the service to be provided. I mean, whether it be community legal services or social work services or drug and alcohol addiction services, all of those things have a necessary administrative framing around them. But somewhere in the Ministry of Justice, I think some over-enthusiastic lawyer, and there's far too many of those we know, have come up with the idea that purchasing community legal services is a narrow thing. And, you know, I get it. You're dealing with Crown funds. Well, actually, you're not. You're dealing with funds from lawyers' trust account. These aren't, and that's actually an important point that I would point out, that sometimes the Ministry of Justice seems to deal with this special fund as if it's its own money. It's not. It's money which must be spent on community legal services. They are simply a clearinghouse for those funds, and they perhaps need to take a slightly different approach because it's not an appropriation. And one of the things when we read the budget and look at the provision of funds to community law, it doesn't appear in the budget because it's not an appropriation. It comes from an entirely different way. There are occasionally, or there have been occasions, where the government has topped up the special fund, in which case obviously an appropriation is needed. So the kind of rigour that the Public Finance Act might bring to an appropriation line in the budget is not the kind of rigour you necessarily need when you're purchasing community legal services from funds, from the special fund which comes from lawyers' trust accounts. So, main point is, this could have been in a statutes amendment bill. Thank you, Venushi Walters. And we probably don't even need to be here anyway. But here we are. And I guess the other thing is this. Here we are under urgency, right? They want to keep cracking on with this. They want to go straight into the committee of the whole stage when we have a lot of questions. And yet it's about as urgent, well, it's just not urgent. And it's a really good example of how this government does in fact use urgency for non-urgent work. This is an issue that's been floating around for a while. It's a short bill and it could have gone on any order paper, but no, they've put it in here under the auspices of urgent business, and it's simply not urgent. And I guess the other thing I'd just observe here is that the special fund, it's worth just examining it in the longer term. And in fact, there's other work around the special fund that would have been far more useful. And in particular, the amount of the interest or the split of the interest, because lawyers' trust accounts, in fact, have hundreds of millions of dollars in them at any one time. And banks love that because that's money that they can take, because it's sitting there and use as essentially their float and lend money out and so on, make good money on it. So they are therefore required to pay an appropriate rate of interest on it into the special. But the way it's done is 60% of that interest goes to the special fund and 40% goes to the bank in their back pocket, notionally for the administrative costs of administering trust accounts. Well, that was done way back, I think, when was that? 2008, when the Law Practitioners Act turned into the Lawyers and Conveyancers Act. And arguably there was some administration, but the administrative burden of administering trust accounts now is extremely low. And if you look at it, the banks are getting about $10 million a year from the special fund in profits. And that is eye-watering. I think it works out I've done the numbers, I think from memory it was about $10,000 per account that the banks get to keep. And that's $10 million that could usefully go into the community, ideally I suppose because it's lawyers' trust accounts for legal services to the needy. But look, if the government is determined to proceed with this bill, and the other thing I would note, and that I'll raise later, is if the government has been funding the ancillary services, as it says, other services which support the provision of community legal services, is there a validity problem? And how are they addressing that? Because if the government has entered into contracts without authority, then we've got a problem on our hands. But this bill doesn't seem to have any validation, and it's quite common to see validation bills, right? Local government muck things up all the time. We're constantly validating their actions, but there's no validation aspect to this bill. So that's something I'd really want to interrogate and understand a bit later on. But we do absolutely, I do want to make this clear that we absolutely support the work of community law centres. A little shout out to Sue Moroney, who has been the Chief Executive of Community Law Centres Aotearoa and has stepped down given a new role that she's got, I think, on Hamilton City Council. So, yes, we're going to support this bill, but, if you're going to bring it through urgency, a bill that isn't urgent, could have been in a statutes amendment bill, we'll give it a working over it and see where we go to from there.
Dr. Lawrence Zilan.
Thank you, Mr. Speaker. I think just want to pick up on first of all, the previous speaker, the Honourable Dr. Duncan Webb's point that this bill is being brought back into the House under urgency. But I also think that there is a level of symmetry there because if the Honourable Dr. Duncan Webb remember that this bill was introduced under urgency in June. And one of the questions that we had back then was, why was it introduced under urgency in the first place because, I mean, yeah, I guess on one hand, tangentially, you can have a budgetary implication, but again, the budgetary implication of this bill is about as removed from the rest of the bill that is needed potentially under urgency as it comes. But then here we are under urgency again, going through the remainder stages. But I think the first thing I do want to mention and kind of pick up on is that during the initial urgency, because it was the first time that we were able to see the bill, that the Green Party did oppose the bill out of caution. And in the first reading, I mentioned, I spoke on the necessity of this bill in the first place and whether there is something more to it than initially meet the eye. Because again, it was introduced under urgency. There was no any form of regulatory impact statement at that stage that I could see. But however, we had, as before the Honourable James Meager mentioned, there was a very robust and, Justice Select Committee process. And, again, props to the Justice Select Committee for the work that they do on a variety of different bills. But this is one of them that had a lot of consideration by that Select Committee during the Select Committee process. So in terms of some of these contexts, so yes, in terms of the legal services distribution of the special fund, we are looking at particularly the special fund that is done through the Lawyers and Conveyors Act 2006 that provides money into the special fund that must be paid to the Secretary of Justice for the purpose of funding community law centers. And I'll talk a little bit more about the purpose and some of the details of the fund which we are able to obtain as part of that Select Committee process. But just in terms of the Select Committee, there were 13 submissions on this particular bill. 19 written submissions on this particular bill. And then we've had quite a few people who oppose this bill, interestingly. But I think the most important oral submission was done by Community Law Centre Aotearoa, CLCA, and which is appropriate since this is one of the bills that affect them the most. So in terms of the submissions, I think it's important to note that while there were some submissions that oppose this bill, they were partly out of the scope of the bill in their opposition. But nevertheless, both themes in the opposition deserve some highlight in the second reading. I think the first theme that took place as part of that is what does it mean for other sort of less funding for direct community legal service? And one of the ones I can think of immediately is the Citizen Advice Bureau, for example, that also offers a different kinds of service, but also as an important service to this area. And they also do a lot of work in terms of educating the communities on some of the legal or awareness things around Privacy Act and etc. But this highlights the importance when it comes to things like access to justice, which is one of the core priorities for the Greens when we're looking at this. Because again, I think many of us, all of us should hopefully unanimously agree that the rule of law and equity in access to justice is something that is paramount when we're looking at the legal system. But again, at this stage, we don't see that equitability when it comes to the justice system, and both Community Law Centre that this bill affects as well as the CAB fulfill some of those and fulfills a requirement, as well as the legal aid, fulfill various requirements for our communities to be able to have that if people aren't able to pay for lawyers in the first place. So that's one of the first things, and I think that is probably, it is outside of the scope of this bill, but it does highlight an issue that we need to address more broadly when we're looking at other concerns. For example, when we're setting budget for various community organizations. And again, because this bill was introduced under budget in May, it's appropriate to also bring the budget into the conversation here in the second reading. Also, the other, I guess the other theme when it comes to opposition is around what it means for any particular ring fencing for sort of, I guess, from a Māori and for Māori law perspective. And I also think that in that case, it is also important, I guess, to note that while the bill itself doesn't really address this particular area, but through conversations with CLCA does have a very big focus, only regionally dependent because it very much depends on the need of the communities. But the equity impact or Māori-led service deliveries is something that is quite prominent within CLCA, depending on where you are. And with that, I do want to give a special shout out to the Community Law Centre Aotearoa in Rotorua, and that particular CLC, for example, does deal with a lot of the cases around Māori land court, for example. So it is again one of the things that the submitters has raised as part of the submission process that deserves highlighting, and is something that we should always consider as sort of any policy setting or legislation, is to ensure that we consider the equitability for Māori and how Te Tiriti o Waitangi and Whakaputanga are also centered in a lot of the decisions that we make. Finally, Mr. Speaker, I mentioned in the beginning that we, as a select committee, as a Justice Select Committee, did wanted to get some more information from, as a part of that process, on exactly what are some of the fundings that is being available, and what are some of the, I guess, relationships between the Crown and how how the special funds in this case is used. And I think it's important as part of that select committee process, Mr. Speaker, that we are looking at the fact that in cases where, okay, so I guess to start with, when we're looking at the Lawyers and Conveyance Act, it does set out how the special fund is used. And in that particular legislation, Section 301, subsection 5 allows banks to retain 40% of all interest payable on nominated trust accounts, but with an agreement, the CLCA has arrangement in place with 5 of the commercial banks to receive an additional 20% of interest on lawyers' nominal bank accounts. And this is what is being used to fund the 24 community law centers. And I think this is where, I guess, the initial concern and the initial purpose, the reason that the Minister of Justice brought this bill to the attention of the House and was introduced into the House is around the contractual relationship under that particular usage of this special fund, and also the way that the Secretary who holds some of that special fund is able to distribute the special fund, and we see that being played out on Clause 4 of the bill. But it's also important to note here that as part of that submission process, that the New Zealand Law Society also notes that the amount of interest on trust accounts retained by the banks and the impact this has on practicing fees, and the amount appears to be greater than what is retained in other jurisdictions. And I think this is also something that is worthwhile, although outside of the scope of this. But I think, again, it's something that the legal experts in New Zealand Law Society has raised, and that is an important consideration for any further bills. I agree with the Honourable Dr. Duncan Webb that something like this potentially could have been packaged as part of the statutory bill, because it seems to provide clarifications as opposed to make any sort of substantial changes. So I think this is where some of the, I guess, the overlap took place during the select committee process with submitters, hoping that the scope of this bill could be expanded, and maybe there was a room in this bill to expand that scope. But again, as the bill stands, it's quite a minute adjustments and clarification on how this particular bill, how actually the Legal Services Act is playing out, and how the Secretary is able to do that. So with that, Mr. Speaker, I'm happy to say that in the second reading, the Green Party of Aotearoa, New Zealand will be supporting this.
I think the next call, Laura McClure.
In support of this piece of legislation, and I note that my colleague Todd Stevenson normally sits on this committee, but unfortunately can't be here to take this speech. So this bill just clarifies how money from lawyers and conveyancers special fund may be used by the community law centres, ensuring that the Secretary for Justice can contract for a wider range of costs that support the delivery of community legal services. And this is a good bill, and I commend it to the House.
Jamie Arbuckle.
I rise on behalf of New Zealand First to support the Legal Services Distribution of Special Fund Amendment Bill. Mr Speaker, I sat on the Justice Committee to hear the submissions on this bill. As has been briefed by other speakers, we had only 19 submissions, but the submission that we did have from the Community Law Centre, they made a very good contribution to the committee. It was very interesting to hear the 24 community law centres across New Zealand that rely on this funding. From their submission, just taking a part out of it, Mr Speaker, the 47,000 clients that they provided free law-related services to, and education up to 26,000 people. So I thought that contribution was very much and showed how important that this funding is to them. The biggest part of this, Mr Speaker, was trying to broaden the use of the fund. We had in the initial briefing how the direct services, the legal services, the representation, advocacy work and education could be used for this funding. However, things like the overheads, professional development and training fees, the coordination and maintenance couldn't. So really this bill through section 94(1) is just broadening the ability to use the fund. Also, Mr Speaker, it is enhancing community law centres' ability to assist the most needy. And that again is very, very important. It offers sustainability within the legal aid system without new government spending. And on this side of the House, any way that we're not using that taxpayers' money, we can actually make dollars go further, is something that we endorse. So, Mr Speaker, on that, I look forward to the Committee of the Whole and I commend the bill to the House.
Scott Willis.
Thank you, Mr Speaker. This bill, as my colleague Lawrence Unan mentioned, is something that we initially opposed. The caucus, well, the bill was originally considered under budget urgency. I think it was in May rather than June, but then introduced in July. And it appeared at that time to be a change which would broaden the acceptable use of funds that were legislatively ring-fenced for legal aid services, but resulting in less funding for legal aid itself. So here we have again, here we are again in urgency, considering a bill that doesn't really need to be done under urgency. In fact, we seem to have been sitting under urgency for most of this term, Mr Speaker, which really shows that we have a government that is more anti-democratic than anything and doesn't really pay attention to good legislative process. Mean-spirited perhaps, but you know, it is a Friday and we do have things to do. But we'll stay here until Tuesday next week. We're quite happy, Mr Speaker, because we know that a major barrier to seeking justice is its cost, and high fees mean some people cannot have access to their rights, and this is not in the public interest. Community law centres are available to help with some matters, but are not adequately resourced. So legal aid is limited. And Mr Speaker, I do remember many, many years ago having had recourse to legal aid, and without the money to be able to go to a lawyer, it was really, really helpful to be able to deal with a double glaze, a company that was doing double glazing but did a very poor job and contested their work, claimed money that they shouldn't have claimed, and I didn't know quite how to deal with that. Community law was incredibly helpful at enabling people we were a young family at the time, to deal with that problem and assist us through a myriad or a challenging situation.
So, Mr Speaker, we know that community law centres are an essential part of meeting the growing access to justice gap that we have, empowering people to resolve their legal issues. And we know that the need in this area is growing. It is growing because we have increased poverty in our community, we have people under energy hardship in our community, we have people dealing with disreputable companies who are willing to take whatever money they can get. We have people who are dealing with agencies that are not serving their need in our communities because of this government's actions. And that's a problem. So we do need access to legal assistance. We need to resource community law centres so they're better able to meet their clients' needs, their clients who are the people who are suffering or are struggling the most in this society now, and restore their mandate to act in individual cases and engage in more justice sector advocacy. Mr Speaker, we were opposed to this bill at the earlier reading because it appeared to usher in a change that would broaden the acceptable use of legal services funding. But as my colleague Lawrence Zunan has mentioned, that concern has largely been resolved during the Select Committee process, and we note that the Community Law Centre has given its support to this bill. And as a result, Mr Speaker, we will support this bill at this point, but we will note that we think that the overuse of this urgency is a dangerous thing that this government has engaged in, and we think that the anti-democratic nature of this government is something that we really do need to address. We need to consider this. It's a bigger question. So while we certainly do listen and pay attention to our community, we also want to make sure that our community has the ability to input into legislation. Rather than sitting in urgency, we want to see better time for Select Committee process, longer time. So this bill's had some time. But we're sitting in urgency doing the devil's work with this government, and we want to make sure that they don't abuse urgency and give us more time to have the public to have input into processes. Thank you, Mr Speaker, and I will support this bill.
We have an opposition that is crowing about the use of urgency at the same time as saying these are non-controversial bills, Mr Speaker. Why don't we clear the order paper, get through this quickly and get on with the work of this House, Mr Speaker? I commend the bill to the House.
Thank you very much, Mr Speaker, for the opportunity to speak on the Legal Services Distribution of Special Funds Amendment Bill. What a crucial bill for the cost of living of all those Kiwis that are out there right now struggling to put food on the table. I'm sure this bill will make a big difference to people who queue up in the grocery line each week wondering how they're going to feed their kids or put shoes on their feet. Because what this bill does is it identifies that the Legal Services Act in 2011 enables the Secretary to enter into contracts with community law centres to purchase legal services. But however, Mr Speaker, there's a glitch. Because this provision is narrow, it is really unclear whether the community law centres can use money from the special fund to meet the indirect costs incurred when providing services such as leases or utilities. So the government has taken upon itself to sit in urgency, not to help people get a job, not to help people pay for their food, not to help people pay for their mortgage or their rent, or even help clothe their kids. We're changing it so that there's a small technicality in the Legal Services Act to enable community law centres to access some funding. Saying nothing wrong about community law centres though, Mr Speaker. They do an outstanding job in New Zealand. Can we just pause for a moment and take a look at all the good work that they do? Substantially underfunded by previous national governments and have really struggled to be able to provide the free legal advice that they do. But I think this will actually go towards paying their leases potentially. Would have been even better if there was additional money to be able to provide them to function and do all the good work, because we know that many people people struggle to access justice because of the funds are prohibitive. Many people who want to be able to proceed with legal advice, whether it be through family law or other issues, immigration, employment law, we know that the ability to pay for a good lawyer is really prohibitive for a lot of New Zealanders. And so community law steps into that space and does an excellent job. I'd like to acknowledge the Hutt Valley Community Law. We refer a lot of people through both of my offices that operate in Petone and Wainuiomata, and who provide people with free legal advice in areas where they can't afford a lawyer and they don't know what to do next. What the community law services often do is they stipulate special sessions where people can come in and receive expertise advice about a particular area, whether that be immigration, family or employment. There's special sessions dedicated where people can come and access a lawyer. And to acknowledge those lawyers who do give their time and effort to go and provide that advice, it is warmly received in the community, and people often who are stressing about issues they don't fully comprehend or understand how it's going to impact upon them and their future and their families and their budget, having that legal advice accessible to them is incredibly important. So for those reasons we support the bill, but we do think that we don't think urgencies are particularly good time to be passing legislation like this, given the fact that New Zealanders are struggling under a cost of living crisis, and that largely Christopher Luxon is out of touch and broken his promise to New Zealanders. He's cut women's pay, he's promised to make the cost of living better, and while families struggle to pay the bills, he's looking after property speculators and fuel fossil companies and largely abandoned middle New Zealand. But don't worry everybody, we've now got a technical change to the legal services bill so that they can all pay their rent, so rest assured help is on its way. Mr Speaker, I'd also like to say that the Lawyers and Conveyancers Special Fund was established back in 1982, and it collects 60% of interest from banks earned on solicitors and licensed conveyancers nominated trust accounts. The Select Committee only wanted one change made from this bill. The commencement date was changed to reflect the fact that the 1st of July 2025 is already passed, so we missed that one. This government has fallen behind its plans in passing legislation, hence why we're all sitting here ramming through a whole bunch of stuff at the end of the year because they couldn't plan the legislative program properly. But that's all right, we can just stay on a Friday and do all the work they didn't manage to do during the year. We can expect more of that next year as the government realises that it's failed to deliver on its promises and it's running out of time, and New Zealanders are beginning to take notice of that, and that's reflected in our polls right now. But this bill is important for those people who want to access more ability to get to legal services, because if your local community law is struggling to pay the rent, now this change will enable them to pay for their lease. And in some of those areas, I know in Lower Hutt it's not easy and cheap to afford rent, so it allows the costs and the functions to be met through the special fund rather than Crown funding, so saving the ability of the Crown to fund that and funding it through the special fund. It will enable future Crown funding to be reprioritised, and we hope that does happen. And we're grateful for the fact that this bill broadens the use of the Lawyers and Conveyancers Special Fund to allow for these expenses in the delivery of community legal services. Mr Speaker, it's not explicit in the current legislation that the delivery of community legal services can be paid, and so that's what this bill is doing. And it's important that community legal services are funded properly because they provide that vital role. Mr Speaker, I don't actually have all the submissions that we have, so Mr Speaker, we think that it's a really important move to do that. But again, once I have highlighted that we are really concerning about what the priorities of this government are, and it does highlight that maybe they got their priorities just a bit wrong, because if people are 200 people leaving New Zealand, every day to Australia to find better paying jobs, really I wonder if they could have a better policy program to try and retain New Zealanders here, to provide jobs, to give young people some hope, some training, apprenticeships. All those things will be great things to do to actually give people here in New Zealand some sort of vision about what the government intends for New Zealand to be like in the next 5 or 10 years. But don't worry, because Labour's got that sorted out. We'll be talking a lot about jobs, health, homes, and real action on the cost of living. And we do have a vision for New Zealand, and we want it built by New Zealanders for New Zealanders, because that matters. And we want an economy that works for everybody, not just a two-tiered economy that serves some people while the rest of the country is really struggling to be able to make ends meet. That doesn't seem fair, and it seems, quite frankly, really out of touch. And so while all we hear from the government is trying to blame the previous government, as the clock ticks on, people are starting to realise that actually a lot of the entrenchment and the prolonging of the economy and the recession that we're seeing now is largely because so many of those big projects right around the country got cancelled. 20,000 construction workers went overseas, and that's been a significant reason why prices have continued to go up and why people just don't have the wages. But, Mr Speaker, the fact that we've now had this technical change to the Legal Services Bill really has no impact whatsoever about all of those pressing issues on New Zealanders right across our lands who are really wondering and scratching their heads and looking at the current government to try and find some solutions as to the daily issues. And it demonstrates really that they have no clear understanding of the reality of day-to-day lives. And so many New Zealanders, of course, are out of work. The rates of unemployment in regions such as Gisborne are way up. I think it was like 70% increase in unemployment in places like Gisborne and the Hawke's Bay, huge ones, and particularly the doubling of unemployment for people aged 40 to 44. Big doubling of unemployment rates. And our youth unemployment rate, Mr Speaker, that's at 15.2%. Huge amount of increase in our young people. And the solutions offered, apart from this Legal Services Bill, are also the fact that they're taking the job seeker benefit away from 18 and 19-year-olds, as well at the same time as cutting funding to apprenticeships and tertiary training. You would think at a time when they're taking unemployment off 18 and 19-year-olds, when there's record unemployment in New Zealand, that you would offer some alternatives like training or education or opportunities, but no, we're consigning everybody on a flight to Australia because they don't really care about the outcomes. But at the end of the day, Mr Speaker, we can all be rest assured that the rent in our local community services office will be paid on time because of this bold, forthright and ambitious bill for the future of New Zealand. I commend it to the House.
Ryan Hamilton.
Commend this bill to the House.
Compliments.
Kamala Bellich.
Thank you, Mr Speaker. A pleasure to take a call on the Legal Services Distribution of Special Fund Amendment Bill. I'm a big fan of community law centres. When I was a law student, one of the first things I did was head along to, I studied at Victoria, head along to the Wellington Community Law Centre and volunteer as a student. And then as a lawyer, and I used to volunteer on the employment night, as my colleague Ginny Anderson says. Many of the sessions are specially focused on particular issues that people have, and there was always a line and there were always a lot of people waiting to see lawyers there. And, you know, it was just, I really love the community law centre movement because although in my particular line of work and doing a lot of employment law work, and I did do a lot of work for trade union members, there will always be a section of the community who, for whatever reason, usually financial reasons, they're unable to get assistance in any other way than going to a community law centre. And the lawyers at community law do provide a really invaluable service. I don't know how much people know about community law centres, but it's not a full service. We're going to take your case to the Supreme Court usually. I think maybe there might be a few instances, and my colleague Vanushi Walters, who is much more experienced in community law centre legal provision than I am, can probably think of a few examples of some strategic and important cases that community law centres do. But generally it's the type of hard work of looking through people's papers, figuring out what their legal problem is, pointing them in the right direction and telling them it's going to be okay. And it's not glamorous, and usually won't get your name on a reported case, but it will make a big difference to those people. And for some of them it will be the first time they've talked to a lawyer, and the work of community law is really invaluable. And I think New Zealand should be proud of the fact that actually our legal community has got together and decided to support New Zealanders through not only staff in community law, but also with their trust accounts. And you'll know if you've ever bought or sold a house, when your money goes to your lawyer, it sits in a trust account. And so sometimes there can be millions of dollars sitting there, of course, earning interest from the bank. And so 60 of accumulated of people's different house transactions, Mr. Speaker, not usually just one house, but of course that could be also the possibility. Anyway, so a lot of money in trust accounts. The interest goes to funding community law centres. At the moment, it's about 60%. And this money then goes to fund these community law centres. So, I mean, I've spoken very positively about the community law movement because it's something that I think is really important and invaluable, and we should support it. And my wish is that we support it more than we currently are. It is disappointing to see this bill focus so much on funding but provide no real additional change in the amount of funding that will be provided to community law centres. So as far as I'm aware, this is a clarification, it's a funding fix, and it just clarifies that the practice as it currently stands is legal. So it's not an additional amount of funding for this very important service. So that on one hand is disappointing. The second thing is, if we are going to spend the House's time looking at community law, I wish that we were doing something that would actually be improving the situation for community law. And this bill doesn't do that. This bill finds an issue which I think, looking at it, it's arguable. I did look at the primary piece of legislation, and I mean, I think probably what's happening currently is probably on my brief reading of that, probably okay. I'd be really surprised to find an instance of where someone would challenge that, as Duncan Webb said, the provision of legal services that requires, you know, a building, a premises, a photocopier, the lights to be turned on, running water, health and safety to be present there, desks, computers. I would really be surprised if that was not current, which is what currently happens, and that's funded through this fund, would be found to be not permissible. So we will support this bill. I'd like to see more support for community law centres, and I'd also like to see greater ambition with the legislative program in front of this House. If this was truly a necessary change, why didn't we look at how we might be able to support community law centres more? Surely there was something additionally that this House could have done to enable them to do their work. And I know everyone around this House who is an MP will have at some stage, or maybe weekly, almost daily, be referring their constituents to community law. They deserve our assistance, they deserve our support, and I wish this House would do more to support them.
Suze Redmayne.
Thank you, Mr. Speaker. This bill is amazing. It supports our community law centres who do great things in the community for people who can't afford to pay for their own private representation, and I have great pleasure in committing this bill to the House.
Vanushi Walters.
Thank you, Mr. Speaker. Now, of all the bills that we've seen come through the House under urgency, this one has to win the prize. This one has to win the prize for the strangest use of urgency to put a bill through the House. Shame on you, government. But I've got to say, I'm at least very happy. I'm at least very happy that you didn't use urgency and you did let the bill go through to Select Committee. You know why I'm very happy? Because we got this beautiful quote from community law itself that says, "We view legislative change to be unnecessary." Fantastic. Absolutely fantastic use of time. So they're kind of going, yeah, okay. But they don't see that it's necessary. And not only are you passing legislation on it, this is the second time you've put it on a list as being urgent. It is absolutely bizarre, I've got to say. It is a pleasure, though, to speak about community law because I spent almost a decade there as a lawyer, a supervising solicitor, and then managing youth law Aotearoa. So they have a very close place to my heart, and I'll have a lot more to say about that at committee stage, of course. But I do think that they play a crucial role, or the role that's most frequently known is the role their lawyers and student volunteers play. But they do play other roles as well. And one of those roles was the first one that I got involved with as a law student when Youth Law were involved in drafting the shadow or parallel report to the United Nations on New Zealand's compliance with the Convention on the Rights of the Child. So Youth Law is part of an organisation that's called Child Rights Alliance. When I was part of it, it was called ACIA. An interesting fun fact, the current Children's Commissioner was on the board of that organisation as well. That's the first time I met her. But we travelled to Geneva and we were the civil society delegation who were holding the government account to see whether the government were actually complying with children's rights. The Honourable Anne Tolley was leading the government delegation at the time. And so, yes, they play an important role in terms of direct legal services like the provision of advice and representation, but they also look at law reform roles and the issues, and they also look at broader issues in terms of reporting internationally. Another interesting fun fact was that in a previous national government, the national government decided that they would no longer fund community law to do law reform work. So that funding was shifted into other legal services, and it's only with the restoration, with the Labor government coming back in, that that service was restored. It always really appalled me that the then national government weren't concerned about the systemic issues that we were identifying by actually talking to people about their issues on the ground. So a really broad-based set of services that community law provides. I also wanted to give some examples of the type of legal advice that would be kind of day-to-day bread and butter work of a community law centre, especially with my former youth law hat on. There were frequent instances when we would provide advice to young people about sexual harassment issues, often in the context of student jobs, and they simply just didn't know where to go, and we would be the first contact for them. For young people experiencing family violence issues, and on that we'd get calls directly from young people, but also from counsellors and people working with young people. We'd work on minor criminal matters as well, including where young people were charged with offences. But an interesting thing that I found working in that role is that young people often will go into situations where they're with a group and will want to defend their friends. So we, on several occasions, had young people claiming to be the person responsible for things like willful damage, minor willful damage, while they were out with their friends, when in fact they weren't the person who did it. And on reflection overnight, a week later, they sat down and thought about it and did want help defending that. Most of what community law were doing at the time when I was there was employment law cases. I think that's common across the country still. And it tells of that huge employment need in that part of the system. But I think one thing we struggled with, and the system continues to struggle with this, is the delay in actually getting justice when you have an issue in the employment space. Or for that matter, if you have what I like to call everyday legal issue where your recourse is with one of our tribunals. I'm sure government members would be horrified to know that if you wanted to take a privacy case, for example, to the Human Rights Review Tribunal, you could be waiting up to 3 years to get in front of the tribunal members and have a decision made. And that, of course, is not access to justice. I mention that because we can sort of protect this funding, but then, of course, we need to make sure that the other parts of access to justice are there as well. On the special fund itself, and others have spoken about the 60-40 balance in terms of what comes to community law centres, the amount, and Dr. Duncan Webb has referenced this, that comes from the special fund has fluctuated in the past. So there have been many times when the Ministry of Justice budget has topped up the funding, and other times when the special fund could accommodate the entirety of community law's needs. So back in 2019, the total pot of funding going to community law was 12 million, almost $13 million. The amount of the special fund was 10.9 million, so that top up was there. By 2023, we had more than 20 million in the special fund. And so you can see how when the markets are doing particular things, that really can affect special fund funding. Now, I raised this because I was a little concerned when the minister who was moving urgency listed this bill and said that it was part of budget commitments or budget savings commitments. Now, I think that's a problem, because there will be times when the special fund can cover the entirety of community law's funding, but in truth, as others have said, it doesn't cover the totality of legal need at the moment. So in my view, there currently is a need for the Ministry of Justice to be topping up that funding even further, and this shouldn't be, and I hope it's not, an excuse to say the ministry will no longer be looking at what the total legal need is. And so I am very perplexed at the entry of this bill, and that remains my concern, that that is not what the government should be doing. So I will be seeking assurances during committee stage that the government understands that its obligation is to look at access to justice across the board. I've just made reference to one part of our justice system which isn't operating as it should, and it must then provide the funds to ensure that people can access what they need to. I would also say, in terms of that slightly arm's length nature that community law have, the special fund funding does give it that. And I was troubled when I was at community law. We had Ministry of Justice contracts that had a no surprises clause in them. And from time to time when we were doing law reform work, I would advise the ministry that we were about to release a paper or come forward with a policy proposal. And on one occasion I had a response that said, yes, that's fine with us, go right ahead. And of course, that's not what a ministry should be doing. A no surprises clause means that you inform, but there is no permission, and that happened under the last national government as well. So again, in committee stage, I will be looking to ensure that it's very clear that the government understand the independence with which community law centres need to continue to work, and that the pot of funding that the special fund is earmarked for community law. It is not, while administratively it comes through justice, is earmarked by statute for community law and therefore protects their independence.
Rima Nakale.
Thank you, Mr. Speaker. Look, it's really a shame to hear that on the other side of the House, they think it's a waste of time to work a few extra hours to give our community law centres access to more funds. We don't think it's a waste of time, and I commend this bill to the House.
Sam Uffendal.
I commend this bill to the House.
The question is that the motion be agreed to. Those of that opinion will say aye. To the contrary, no. The ayes have it.
Legal Services Distribution of Special Fund Amendment Bill, second reading.
This bill is set down for committee stage immediately. I declare the House in committee for consideration of the Legal Services Distribution of Special Fund Amendment Bill.
Members, the House is in committee on the Legal Services Distribution of Special Funds Amendment Bill. We come now to Clause 1. This is the debate on the title clause. The question is that Clause 1 stand part.
Madam Speaker.
Lawrence Sunan, you're in.
Thank you, Madam Speaker. I was just in case it was. Thank you, Madam Speaker. So I want to check with the Minister in terms of the title for this bill. Now, it would be no surprise for, I think, anyone in this House to know that I do have an amendment here on the title. But I want to check with something with the Minister first. Now, everyone is clear in terms of the purpose of this bill. We just discussed that in the second reading. But the question is if the term distribution is the best term to use for the title, or if it actually represents what this bill does. Because to me, distribution is not so much in terms of how it is used, which is what we're seeing in a later clause, and what the circumstances in which the community law center is able to use it, but more distribution I would assume to be how that could be spread or distributed to other things that's beyond potentially the scope of this bill or potentially other lower community initiatives. So I wondered if, for example, the Minister would consider my amendment that the legal services expenditure of special funds or even usage of special fund might actually be a more accurate title that reflects what this bill does. So I'm going to start with that particular question and see if the Minister is able to make any comments on my amendment. And I don't, unfortunately, have a number for the amendment.
The Honourable Minister.
Thank you, Mr Chair, and I thank the member for his generous offer of that amendment, but no, we won't be accepting that.
Vanushi Walters.
Thank you, Mr Chair. And yeah, my question here relates to some of the history of this bill. So this was a bill that was passed in 2006, and it changed provisions that came before it, where the special fund also potentially funded the Law Foundation, as it was then, because the special fund wasn't at that stage accumulating sufficient funds. All of the funds ended up going to community law centres anyway. And so with the 2006 changes, that was made very clear in terms of the distribution. And so I'm just wondering really whether the Minister had considered tying the title to something that related specifically to community law. I mean, I could understand if that was not something the Minister wanted to do, 10 years ago, because at that stage the community law movement probably wasn't as cohesive as it is today. But certainly with CLCA now being well funded and the separate community law centres being extremely well coordinated and operating very much in unison most of the time, I think there's an argument to say that we have currently this excellent model that operates across the country, who are coordinating in terms of their practice, who I understand at one stage also looked at how they ensure that people who work at community law are all paid in a comparable way, so that they truly do feel like they're operating as one, who the public see in the form of the community law manual. So again, it's seen, I believe, very much as a government service that people rely on and part of the essential access to justice architecture. And I think it's potentially time that we recognise that this is a part of our legal access to justice architecture that deserves some protection in terms of the allocation of these funds. That will also allow community law to plan and to grow in I think, quite a different way. To know that not only is the funding for their legal services and support services guaranteed through legislation, but that it's guaranteed for the entities that they've set up. And I think that that will help them develop further entities. They've, in recent years, looked to setting up Te Aotearoa, or the bridge to law, which is quite a novel concept. It's a legal clearinghouse. Australia has a similar one, and that matches up lawyers, pro bono lawyers, with legal issues that are coming up in community. And I always thought that was extremely innovative. And so again, if there was a change to the title that truly reflected the mana with which we hold community law, then I think that will continue to allow them to take bold steps into access to justice architecture that can more greatly support those who do need legal help. One thing I've always thought about is, just given that I specialised in young people and providing them with legal advice, is how do we help people who don't know that they have a legal issue? And part of that is the education outreach work that community law centres do. And again, having that security, which sometimes is by being recognised specifically within legislation, will give community law centres that sense of trust that they need to grow programs to outreach to people and engage with the entities that exist on the ground, so that they can outreach and start providing almost pre-advice, if you like, to those people who need it.
Kamala Bilic.
Thank you, Mr. Chair. Just wanting to take a short call on this first clause of this bill. This bill, I think, may have an acceptable name, but I think perhaps we could improve it. And so one of the suggestions that I would make is a change to this Act as the Legal Services Clarification of Use of Special Fund Amendment Bill, because that's really what it's doing. It's already being distributed in this May. Yep. So it's really a clarification bill. So I think if we could get that in there, that would be good. The other suggestion that I wanted to make was it is a common thing in other countries to name bills after people that have been significant.
This has not been taken. We're still on part.
Title, yeah.
Oh, sorry, my apologies. Yeah. Carry on.
That's fine, Mr. Chair. So,
sorry, my mistake.
In other countries, often famous people who are associated with particular movements are named in bills, and you'll often see that in America, for example. You might see bills that were brought because of a particular person or to solve a particular issue being named after that person. That's not a practice I've seen in New Zealand. I don't know why that is, Mr. Speaker, and I don't know if there's a good reason, but maybe the Minister could clarify. But when I was researching the history of the Community Law Centre, this is something that's been around in New Zealand since the 1970s. As I understood, the first Community Law Centre was founded in Grey Lynn, and one of the key people who was involved in the foundation of the community law movement, and actually set up the Citizens Advice Bureau in Auckland as well. So actually an incredible man called Robert Ludbrook. And he actually, Mr. Chair, passed away only last year. And I seriously think that when we do pass bills that are so closely associated with the contributions of people, or perhaps a nice thing to honour those people would be to consider putting them in the title clause. So that's a suggestion made in good faith, and it was very interesting for me to learn about the origins of community law and how it came about. And like many things in our community, it's something that people saw a need. Obviously, in Robert Ludbrook's particular situation, I think he had actually received I think a Queen's or King's Honour, not sure which exact date he received it on, but was recognised for his service to doing this type of work, so recognising that there was a need for citizens' advice bureaus and also for community law centres. So, I mean, this, I suppose, is more aligned with a bill, hopefully with slightly more aspiration for the community law service provision in New Zealand. And I think maybe if we did start maybe naming bills after very important New Zealanders like this man, then we would maybe start to get some slightly more aspirational legislation through. And so that's a suggestion, but technical suggestion, go one way, to look at it in relation to distribution, which is actually, clarification of use, which is actually what it does, or have a more aspirational title, which actually recognises the mana, the history, and the important figures that were involved in setting up community law in New Zealand.
Mr. Chair. Ryan Hamilton.
I move that debate on this question now close.
The Honourable Dr.
Thank you, Mr. Chair. I just will have a brief mention on Clause 1. And the reason I want to do that is because a little later on I'll be proposing an amendment which seeks to make sure that transactions already entered into can't be revisited. And so that would then make this not only about the distribution of the special fund, but it would also make it a validation bill. And it is common. We've seen in this House on a number of occasions bills which have validation in the title, which essentially is a backward-looking thing. It's one of those for the avoidance of doubt, for clarity. Of course, our view is that it's not needed, but the government's view is that this is needed. And I'm perplexed as to why they haven't addressed the validation problem. If they think that money has been spent outside of, contracts have been entered into outside of the permitted phrase within the Act, then validation is absolutely needed. So, Mr. Chair, my view is that this bill should be... Sorry, going to take a call? Oh, thanks. Oh, yeah, well, it's good to know. I'm excited as well. It's exciting times here in Parliament. So I think we should just call it the Legal Services Distribution of Special Fund and Validation of Contracts Amendment Bill. Because if we're not going to go large and follow the advice of Camilla Balich, which is to identify in the bill the name of some of the doyens of the community law services, and the fact that in Grayland, I think you said it was established in 1978. I think it would be a great thing to do that. But if not, Legal Services Distribution of Special Fund and Validation of Contracts Amendment Bill. Let's do it.
Ryan Hamilton.
I move that debate on this question now close.
The question is, the debate on this question now closed. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kauma whā ngā poti whakahe.
Could you just repeat that, please?
Te kauma whā ngā poti whakahe.
14.
ACT New Zealand.
11 votes in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Tāka Te Wheres. Miriam Ena Kapkingi.
The ayes are 68, the noes are 48. The question is agreed. The question is that Dr Lawrence Junan's tabled amendment to Clause 1, replacing the word distribution with expenditure, be agreed to. All those in favour say aye. To the contrary, no. Noes have it.
Vote.
Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te kauma whā ngā poti whakaai.
ACT New Zealand.
11 votes opposed.
How exciting. New Zealand First.
8 opposed.
Te Pāti Māori. Tāku Te Wheres. Miriam Ena Kapkingi.
The The ayes are 48, the noes are 68. The question is not agreed. The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, come to Clause 2, the debate on the commencement of the bill. The question is that Clause 2 stand part. The Honourable Dr Duncan Webb.
Chair, I'll just take a short call on this, but really about the commencement, there's a couple of things that crop up. One is that, you know, when you're talking about contracting and you're actually creating a new contracting framework, you might want to just give a little bit of breathing space because it is essentially, if the government's correct in its legal analysis, it's changing the legislative authority for contracting, and there might be contracts out there or contracts that are, you know, about to be signed, which actually use the wording of the original legislation rather than the amended legislation. And I think just even if it was a week or 2 weeks, I would have thought that'd be useful. And again, the other thing is we don't usually like, on this side of the house, we don't usually like retrospectivity, but this might be one of those cases where the Legislation Design and Advisory Committee would note that it's actually in everyone's favour and it disadvantages no one to have a retrospective element, which essentially would mean commencement before the Act is passed. And, you know, there's some, that would be an unusual way to do it, having a commencement which was before the Act was passed, but that would be the other way around it, to say, well, you know, this framework has been in place, in fact, I think, since the Law Practitioners Act of 1986. So you could actually have a commencement going back to 1986, just to make sure that these contracts are all properly enforced. So there's a few thoughts on commencement.
Dr Lawrence Sudan.
Thank you, Mr. Chair. I want to ask the Minister some questions on commencement, but from a different angle from the previous speaker, the Honourable Dr Duncan Webb. Now, it is the House's understanding that this bill was first brought to the House under urgency. When it was brought under urgency in May, it was only under urgency for the first reading, so naturally it would have gone to a select committee process. Considering there wasn't any referral motion that was being brought to the House, at a minimum, the select committee process would have been for 4 months. So I wanted to check, in that case, what was the original intention of having the commencement date on the 1st of July 2025? Now, my only assumption back then was that because of the fact that it aligns with the government budget, because the bill was introduced under budget urgency. But now, because we're now long past that, 1st of July 2025, the commencement date has been adjusted by the Select Committee as the day after royal assent. But I think the question still remained, which we wasn't able to tease out in the Justice Select Committee, which is, considering this is going to go to a Select Committee anyway, why have a retrospective date in the first place? Granted, I think the day after royal assent makes sense, but I think the caveat that the Honourable Dr. Duncan Webb mentioned is an important one. And I guess when we're looking at this, if the original date was July 2020, 1st of July 2025, and now it's the day after royal assent, let's assume it is Monday or tomorrow, if the Governor General is available on a Saturday, I don't know. What then would happen to this particular period? I want to check with the Minister if anything have changed or were there any effect that were changed. Again, we have mentioned the fact that the bill was introduced in the House under urgency, and now we're reading it under urgency. Ergo, there must be a level of urgency that is involved in this. So there must have been some form of impact or effect the government may be aware of that we are not aware of between July and November. So yeah, so those are my two questions. I guess, what is the intention originally of the original date? Noting that it wasn't going to, the report back date was beyond the 1st of July. And also then, what is the impact of this bill not passing on the 1st of July 2025 and now in November?
Venushi Walters.
Thank you, Mr. Chair. And I just go back here to the question that I raised in the second reading, which is, Why is this bill commencing? I'm really just trying to identify the problem here. I have the Community Law Aotearoa submission to Select Committee in front of me. Paragraphs 3 and 4 of that, I think, speak to precisely why this bill is not needed. And I don't even mean under urgency, I mean at all. So I just want to read that because I would like to hear the Minister's response in particular to Community Law's submission. They say, although we view legislative change to be they view legislative change to be unnecessary, the bill appears to be intended to clarify a perceived ambiguity that use of the special fund and/or contracts for community legal services may not include functions that enable, facilitate, or support the provision of community legal services, such as administrative and management staff. CLCA's view is that the law already allows contracts to include these matters. Section 298 of the Lawyers and Conveyances Act sets out the purposes for which the special fund can be used, brackets, funding community law centres. The bill does not change Section 298. Our view is that funding of community law centres includes functions that enable, facilitate or support the provision of community legal services. Section 94(1) of the Legal Services Act governs the content of contracts between the Secretary and community law centres. In our view, Section 94(1) already allows the Secretary to fund functions that enable, facilitate or support the provision of community legal services as a necessary part of quote marks, purchasing community legal services. So there's a very clear view there. There's a very clear view there from a group of lawyers as well. So again, why is this bill commencing? Why is this bill commencing under urgency? But it remains to me very unclear.
Dr. Lawrence Sunan.
Mr. Chair, I just want to seek your guidance. Both on the Honourable Dr. Duncan Webb-Venushi Walters and myself have asked the Minister a number of questions that requires clarification from the Minister, and the Minister has not responded to any of our questions thus far. I want to seek your clarification that understanding that the Minister is not the Minister who's responsible for the bill, but the officials are there and are available. If the Chair would allow for the Minister to respond a previous clause's question if the clause completes and we move on to a new clause. Just want to check if that's something that would be acceptable.
That's a fair enough question. There's a number of issues come in concerning a closure: repetition, new material, and ministerial participation. And while questions are still coming from one side of the House, it's hard to think there would be a closure without any ministerial participation at all. But I'll leave that to the parties to decide. Minister, Honourable Penny Simmons.
Thank you, Mr. Chair. Mr. Chair, I'll respond. The government sought advice from Crown Law, and after considering the advice, the government decided that it would be preferable to have the law clarified. So the government acts responsibly when it gets that advice from Crown Law. Obviously, Community Law Centre Aotearoa's legal advice is not the government's advice. The bill was originally intended to be considered for the start of the new financial year, but obviously it moved on and had the Select Committee process, and the Select Committee report gave the amendment to start it, as it is noted, at the commencement date, the day after royal assent.
Mr. Chair. Cameron Luxon.
I move that debate on this question now close.
The question is the debate on this question now close. All those in favour say aye. Aye. To the contrary, no. The ayes have it.
Noes have it. Party vote.
Party vote is called for. Please conduct a party vote.
New Zealand
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha ngā poti whakahe.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori, tāku te Ferris, Maria Mena Kapakingi.
The ayes are 68, the noes are 48. The question is agreed. The question is that clause 2 stand apart. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, we come now to clause 3, the debate on the Principal Act. The question is that clause, the question is that clause 3 stand apart.
Mr. Chair.
The Honourable Dr. Duncan Webb.
Look, there's so much to talk about in clause 3. Of course, the clause 3 identifies the Principal Act, the Legal Services Act 2011, and says this Act amends the Legal Services Act. Of course, on this side of the House, we don't think it does. We don't think it amends the Legal Services Act at all. It just says the blindingly and bleedingly obvious. Namely that when you enter into a contract with a community law centre, that contract can not only be for community legal services but also for funding, facilitating and otherwise supporting the provision of community legal services. So really, Mr. Chair, I think that it should just say this Act relates to the Legal Services Act 2011, because that's all it really does. It doesn't actually change anything. It sort of just waves vaguely in the direction of the Legal Services Act and says, why don't we just add some unnecessary and largely meaningless words to it? So I think let's call it that this Act relates to. Actually, you could probably do better than that. This Act unnecessarily points towards and vaguely changes the Legal Services Act. But, you know, this government wants to waste taxpayer money on legislation like this, so be it. But let's say it, maybe that's what it should say somewhere. We passed the title clause. We could have put a wasting money and time title in, but we won't do that. We won't do that. So there you go. Let's say that the Act does what it in fact does and just sort of vaguely points towards and adds some unnecessary words to the Legal Services Act 2011.
Dr. Lawrence Zunan.
Thank you, Mr. Chair. I do have a question for Clause 3, the Principal Act. Now, as the previous speaker articulated, this Act assumes an amendment to the Legal Services Act, but I actually don't want to talk about the use of the verb here, but specifically in terms of the Legal Services Act itself. Now, noting that in the Legal Services Act, the section pertaining to the Community Law Centre is clause 93 to 96. You know, indeed, in the next subsequent clause, we'll get to it soon, we're amending clause 94. However, what is interesting is where this part or where the section that relates to community law centers sits under. It sits under Part 3 of the Legal Services Act 2011, which is the administration of legal service systems. But the issue then comes to the fact that when you are looking at Part 3, the other parts of Part 3, so for example, functioning of Secretary for Justice and Legal Service Commissioner, that is subsection 1, quality assurance systems for providers, that's subpart 2. It doesn't relate to the context and the detail of what some of the elements that we see in 93 and 96, because it's not, because for example, in clause 93, immediately preceding the clause that we are amending in this bill, it talks about the definition of the community law center. I wanted to check with the minister then, if that is the case, when this bill was first considered and introduced, why wasn't there a broader consideration of potentially reshuffling or moving around some of the sections of the community law center, potentially into another part or as a separate and distinct part, as you see later in some of the earlier parts with legal aid, so that way it has its own special, so that it stands alone as its individual part. Now, the other reason that I'm suggesting that, and again, this then potentially would have allayed the Honourable Dr. Duncan Webb's, I guess, a reminder that this bill in itself is not necessarily the most substantial bill, but I'm just suggesting that there could have been other things that could have been done that packaged things together. So why, if there was any consideration to the minister that other parts of it was considered to be separated out, but also because considering that the special fund element only relates to this part, which means that there is a special place of this part. So I think that the legal services or the community law center aspect should deserve its own sections. That's my second question, is whether the minister or the officials have ever considered having, rather than this being a sub-part 3 of part 3, to be a standalone part within the Legal Services Act 2011.
Venucci Walters.
Thank you, Mr. Chair. I'm going to stand to make a similar but different point to Dr. Duncan Webb, which is that, yes, while this on its face says that it amends the Legal Services Act, in fact, the change that the government want to make doesn't. The way in which the government have worded this change amends it, in my view, for the worse. For the worse. So maybe you can get away with saying that you do amend the Act, but I think the language used in the amendment is actually adds a level of unclarity, and therefore I hope that in the next part, when I speak to the amendments that I'm proposing, that the government will accept those amendments to actually make the law clear, in which case we go back to Duncan Webb's argument that it's not needed because the Act already says that. But it is very perplexing, once again, why the government believe that this is truly an amendment that changes the law, and again, why it was needed. I mean, the advice from the Minister is that Crown Law said that clarity would be useful. I'm a little bit puzzled as to whether there are other circumstances at play in terms of Crown Law's advice that the House isn't aware of. But it just seems to me to be, I mean, with any government, you of course have to prioritise what you're doing. There will be times when there is law that should be tweaked or clarified. I spoke to Geoffrey Palmer the other day, who said to me there's a... Let me tell you about that conversation. Who said to me there's a whole host of legislation. Oh, I can't believe you don't want to hear what Sir Geoffrey said.
I can't hear the member speaking, so that means it's too noisy.
Who said to me that there is a whole host of legislation, both primary and secondary, on the books that really ought to be repealed. Not even tweaked, but actually repealed, because it simply doesn't apply to modern New Zealand. His view was that a good way for a government to spend time, if you were serious about clarifying the law, would be to ask the Law Commission to undertake a project where they assessed past primary leg and secondary legislation and recommended repeals or updates. You could have the equivalent of kind of the slab bill, which we dealt with in the last Parliament, but it would be a mass repeals bill that would really tidy up and clarify the law. Now, that's a good way to spend one's time. The question is, why look at this one on its own and make a tweak which is unnecessary? And so, again, it really does seem very unusual, and I'm looking forward to hearing the Minister's response to both that as well as to Sir Geoffrey's suggestion.
The Honourable Member.
Mr. Chair, while I acknowledge that a number of members of the opposition consider their advice to the government might be superior to that of Crown Law, the government did in fact seek advice from Crown Law, and after considering that advice decided that it would be preferable to make this clarification with this amendment.
Joseph Mooney.
I move the debate on this question now closed.
Lawrence Sunan.
Very short questions, just to acknowledge the fact that thank you for your engagement, Minister, but if you wouldn't mind responding to my question as well, that would be greatly appreciated. But just to further on in terms of the question that I had, I guess the reason I've asked if the Minister has considered taking this particular part out of a subpart of Part 3 under the Ministry of Legal Systems and into its own distinctive part, very similar to Part 2, Legal Aid, is because the concern that I will have is whether then we're still going to be looking at the special fund being able to be ring-fenced for the use of the community law center, or it will also be looking at being used by other parts and of Part 3 or other aspects of the legal services system like the surveyor or assurer that I mentioned before.
Honourable Minister.
Mr Chair, as in answer to the earlier question from that member, I will note that the government sought the advice from Crown Law, took note of the advice from Crown Law, gave it consideration and came up with this amendment from it. So this is the amendment that we chose.
Rema Nakle.
On this question now close.
The question is, the debate on this question now closed. All those in favour say aye. To the contrary, no. The ayes have it. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te kaumawha e whakeheana.
ACT New Zealand.
11 in favour.
New Zealand.
8 votes in favour.
Party Māori. Tāku Te Whereas. Māori o Mena Kapaki.
The ayes are 68, the noes are 48. The question is agreed. The question is that Clause 3 stand apart. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, we come now to our final debate. This is a debate on amendment to Section 94. Secretary may enter into contract with community law centres. The scope of this bill is very narrow and is focused only on the entering into of contracts with community law centres. Therefore, I'm ruling that Venucci-Walters' amendment for the Secretary to consider the need for culturally appropriate services when contracting for community legal services, while within the scope of the bill, should be debated in this Clause 4 debate because it is better considered as a new subsection 2 to Section 94. Venucci-Walters.
Thank you, Mr Chair. I've been looking forward to debating Clause 4 and speaking to my amendments. And so we will turn to the first one. I made the point in the last clause that my sense was that actually the amendments made things less clear rather than clarifying. So hopefully these amendments will be received well by the Minister. The first one is in Clause 4, replace new Section 941A with A, purchase community legal services and or. So the current clause has purchase community legal services, a little colon, and then it's and then it's got B. And so what that might mean in practice is that for this to for contracts to comply with the Act, there would need to be 2 separate contracts depending on whether community legal services were being contracted for or whether services to fund, facilitate or otherwise support the provision of community legal services was being accommodated for. So if the argument is that this is about contracts for a community law centre on the ground and what we're wanting to do is cover some of their background support costs, etc., then I think what we absolutely would need, just for clarity's sake, given that is what this bill is claiming to do, is to just adopt that little and/or to make sure we are clarifying this. And Mr Chair, make sure we don't need to come back and use another urgency session to add and or maybe in a couple of weeks' time. I don't know, this is getting so comical that I really couldn't put it past this government to do something like that. So please, to the Minister, would she please consider doing that? I believe that was a recommendation from the Law Society, another very capable group of lawyers. They saw that the intention was for this bill to bring about a whole lot of clarity, and they've helped us out with that suggestion. I've put it in an amendment bill, and I think that that would be prudent for the Minister to accept. Now, the only reason why you would leave it as is if the intention was not to cover that gap of community law centres on the ground, but the intention was to ensure that support services of a different kind were being covered, and that those support services exist in a different contract. And what I'm thinking essentially is a body like CLCA, for example, who may or may not be engaged in direct legal services, but who certainly coordinate and provide support and ensure that there's coordination between the different community law centres. If the intent was to cover those in separate contracts, then I can absolutely see that you would want to keep them separate. But from what the Minister has said thus far and what I've seen in the papers, that's not the intent. The intent is to cover community law centre contracts on the ground. This is centres like youth law. This is centres like Mangere. Mangere, interestingly, has a lot of history as one of the earliest community law centres as well, in that I understand David Longy was quite involved. He was the MP for Mangere at the time, was very involved in the setting up of that community law centre, and I don't think they could have imagined the impact and the coordination that CLCs now have across the country. Initially, when they were set up, it wasn't a government initiative to set up community law centres across the country in kind of a fair and equitable way. They arose because individual advocates were advocating for those centres from the ground up, so contracts were quite different. And so again, the way they started, a lot of it was direct legal services, probably heavy, and then that administration across community law centres really grew in the background. So I've only managed to just speak to my first amendment, Mr. Chair, and I have two more, as you've indicated. The third has been more suitable to address in this this clause, so I really would like to continue, and I will be seeking the call to do that. And I also, on Mangere, I would also say that Judge Beecroft, our former Children's Commissioner, was highly involved not only in setting up Mangere, but actually also in setting up youth law. And if you look at the history of community law centres, you'll find, Mr. Chair, thank you, Mr. Chair, you'll find that there's a string of similar people who set up those first initial community law centres, who then went on to seed other community law centres as well. And Judge Beecroft is one of those people who, of course, along with Robert Ludbrook, then set up youth law. And I knew Robert very well, and had the sad but Robert passed not long ago. Well, it's probably last year now, but I attended his funeral, and it was extraordinary the reach that he had in terms of community law, but also into other parts of the voluntary legal advice sector. There were older members of the Black Panthers as well there, who talked about how Robert had been pivotal in terms of providing advice to them. And so this idea of providing free legal services sprung out of lawyers just kind of doing it. And then the architecture came up in response to grassroots contracts that were negotiated with then the Legal Service Agency. So you can see how really administration was really at the back of everyone's minds. So again, I think if we're going to get it right this time in terms of those support services, let's do it right. And I do hope the Minister agrees with that first proposal. Moving to the second proposal, Mr. Chair.
And probably the third one in this.
Moving to the second one, which is also on clause 4. So this one is to replace new section 941B with language that says fund matters that enable, facilitate and otherwise support the provision of community legal services. So this one was a suggestion directly from community law, because they didn't believe that the language the government had adopted was clear. Again, this is just comical. So again, you've got a proposal from it was a proposal from Parliamentary Council Office in response to what Community Law had said at Select Committee. So you've got a proposal directly from the entity who you're trying to help out. You're trying to clarify the scope of their role, and they've gone, here's what we'd like you to say. You have Parliamentary Council who draft the language for that. It seems a little odd to me that we wouldn't then include it within the bill. Again, I would say we don't want to be here back in urgency doing this again for clarity's sake. The last amendment tabled is what I had proposed would be a new clause 5, but on the instructions of the chair, I understand that it would be more suited for to be included as part of clause 4, and I'm happy for that to be the case. And that is to insert a new section that the Secretary must consider culturally appropriate services when contracting for community legal services. And it further says that when exercising the power under section 94(1), the Secretary must consider the need for community legal services that are culturally appropriate for all parts of New Zealand society, including kaupapa Māori services. So, community law has, since I was there, before I was there, and post, had kaupapa Māori community legal services, I think with increasing growth. And this is just an ask that we embed that within the statute to recognise that it is incredibly important that that's explicitly there. Many years ago, community law centres were told by the former national government that there would be potentially many fewer community law centres, and it created this sense of competition for contract, which I think really disadvantaged the sector. Eventually we moved past that, and there was a lot more cooperation, in my view, under a Labor government. But again, I think when you have statutory direction about what is protected and what the expectations are, then it makes for a sector who can cooperate and plan together much more effectively. Thank you.
The Honourable Minister.
Mr Chair, I note and acknowledge the suggested proposed amendments from the member. I can clarify for the member that the current drafting denotes that contracts can be made for either or both of the purposes stated in the new section 94(1) A and B, and so the proposed amendments from the member aren't necessary. Thank you.
The Honourable Dr Duncan Webb.
I have actually a really quite important question, and then I have a request. The question I have is, has the Minister or her officials turned their mind to the validity of pre-existing contracts? Now, I have an amendment paper, which I think is on the table. Certainly it's been delivered to the clerks, which proposes in clause 4 adding the following new subsection, which would say all contracts entered into by the Secretary to fund, facilitate and other ways to support the provision of legal services are valid regardless of when they were entered into, and in particular whether or not they were entered into prior to section 94(1)B coming into force. Because if this is a tidy-up, which you're saying it is, and there are contracts out there, because the problem is, as I understand it, and I was talking to my colleague Camilla Balich about this a moment ago, legal services is defined in the Act, and it's defined arguably relatively narrowly, and I suppose if you use the word, there's an assumption that if you use the word legal services when you're talking about contracting, that you're using the defined term. There's exceptions to that, but that's the general interpretive approach. And if you've done that and you've entered into these contracts and the money's been spent on, support services and professional development and all these other things, then there's a question about whether the money was actually spent out in breach of the contracts because they were for legal services. So that's my first thing. So, and I'd really appreciate if the Minister could, let us know, perhaps take some advice and say, no, there is no problem, or there is a problem but we don't care about it, or there is a problem and we can expect another bill to fix that very shortly. And the second question is this. because you've got community law saying that, in fact, this bill's not necessary on their reading of the law. You've got the Law Society saying, as I understand it, pretty much the same thing, and they're happy to provide their legal reasoning. But you've got a bit of a black box when it comes to Crown law advice. And we're all scratching our heads thinking, well, you know, they're seeing something we can't see. And for something as innocuous as whether this amendment in Clause 4 is needed, it will be really useful to provide the Crown law advice. And Crown law is, you know, for something like this, it's not top secret, it's not some, you know, big issue. It's just, well, we've got to this position for the following reasons. So it would be really nice to see that, because although I accept that, you know, my feeble mind isn't up to the might of Crown law, some of my colleagues are pretty clever, and I respect the Law Society and the Community Law Aotearoa to get it right. So at the moment, Crown law's the outlier here. It'd be great to see their advice. So there's two questions. And certainly the first one is important. Are existing contracts, do they breach this legislation, and if so, what's being done about it? And the second is, can we have a squiz, bit of a gander at the Crown law advice?
Mr Chair, to answer Dr Webb's questions from his multi-choice that he gave me, there is no problem. The contracts remain valid. And to your second question, no.
Dr Lawrence Zunan.
Chair, I want to seek the Minister's guidance or support of one of my amendment bills, and this is an amendment bill that is dated 43601. And essentially, the current wording of section 94(1)(b) states fund, facilitate, and otherwise support the provision of community legal service. And you know, and as some of the other members mentioned, that how it interacts with what is now 94(1)(a) has a lot of comparables. But I guess the question, so my amendment over here clarifies, and this is again a recommendation by a submitter, and particularly by the by the Community Law Centre Aotearoa, who deal with this every day, and they are part of one half of the contract of this contractual agreement, to suggest that rather than saying fund, facilitate, and otherwise support the provision of community legal service, it's better to word it as fund functions that enable, facilitate, or support the provision of community legal services. Because I think the idea that the function aspect of this particular section is incredibly important, because otherwise what you are seeing is that the secretary, in fact, then is locked into a contractual obligation to not just fund, but also facilitate and support provisions of community legal service. And I don't know if that's the intention of the secretary to also facilitate such provisions. Because again, when we're looking at something like this, we got 3 consecutive verbs with a very nice use of an Oxford comma. But again, I don't think that is the intention of this bill. So my recommendation is that the secretary, to clarify that the secretary is only funding the function, but that enables and the facilitation and the support of the provision of community legal service remains with the Community Law Centre Aotearoa. That's I want to seek the Minister's guidance on whether she will support my amendment.
Kamala Belich.
Yeah, just a short call from me, just really in response to some of the comments that the Minister has made in response to Dr Duncan Webb's issue that he raised. The Minister, and you can correct me if this is incorrect, seemed to say that there's no problem with the contracts and that they remain in place. If that is the case, then what is the purpose of this bill? Because as I understand it, the entire purpose of this bill is to secure the contractual arrangements moving forward. And so Dr Duncan Webb's question was, if that's correct, then surely we should ensure that the previous spending on contracts is also not going to be affected by the fact that this change allegedly needs to be made. And so it's I think it's made in good faith. It's a helpful suggestion. If there is genuinely an issue with previous funding, then something should be done to ensure that that funding isn't challenged, or that the contractual arrangements that happened in the past were made in a way that was consistent with the law. Because if it wasn't, then that's problematic. And if what the Minister said is correct, then why are we making this change?
Joseph Mooney.
I move the debate of this question now closed.
The question is that debate on this question now closed. All those in favour say aye. To the contrary, no. The ayes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
Te ko mawha ngā poti e whakahē ana.
ACT New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Party Māori. Tāku Te Whereas. Mario Mena Kapakingi.
The ayes are 68, the noes are 48. The question is agreed. Venucci Walder's tabled amendment to Clause 4, amending paragraph A, is out of order as not offering a serious alternative form of words. Venucci Walder's tabled amendment to Clause 4, amending paragraph B, is out of order as not offering a serious alternative form of words. Dr Lawrence Unan's tabled amendment to Clause 4, amending paragraph B of section 94.1 is out of order as not offering a serious alternative form of words. The question is that Honourable Dr Duncan Webb's tabled amendment to Clause 4, inserting new subsection 1A, be agreed to. All those in favour say aye. To the contrary, no. The noes have it.
Vote.
Please, it's in order.
Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko mawha ngā poti e whakahē ana.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Party Māori. Tāku Te Whereas. Mario Mena Kapakingi.
The ayes are 48, the noes are 68. The question is not agreed. The question is that Venucci Walder's tabled amendment regarding the need for culturally appropriate services be agreed to. All those in favour say aye. To the contrary, no. The noes have it. Party vote is called for. Please conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
Te ko mawha ngā poti e whakahē ana.
ACT New Zealand.
11 opposed.
New Zealand.
8 votes opposed.
Party Māori. Tāku Te Whereas. Mario Mena Kapakingi.
The ayes are 48, the noes are 68. The question is not agreed. The question is that Clause 4 stand apart. All those in favour say aye. To the contrary, no. The ayes have it. I'll report this bill without amendment.
The House is resumed.
Madam Speaker, the committee has considered the Legal Services Distribution of Special Fund Amendment Bill and reports it without amendment. Madam Speaker, I move the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. This bill is set down for third reading immediately. Honourable Penny Simmons.
Madam Speaker, I move that the Legal Services Distribution of Special Fund Amendment Bill be now read a third time. Madam Speaker, this bill amends the Legal Services Act 2011 to broaden the use of the Lawyers and Conveyancers Special Fund. Money in the Special Fund must be paid to the Secretary for Justice for the purpose of funding community law centres. The Special Fund serves as an important role to ensure that people can access free legal help in the community. However, there is ambiguity around whether special fund money can be used to meet expenses incurred by community law centres when delivering community law services. This is because the current law is narrowly framed. This bill makes a minor change to broaden the use of the special fund. This will enable the Secretary for Justice to enter into contracts to also fund, facilitate and otherwise support the provision of community legal services by community law centres. Madam Speaker, it is important to support the long-term funding of organisations that deliver community legal services and ensure people are able to access the legal help they need. To conclude, I'd like to thank members for their support of this bill, and I commend this bill to the House.
The question is that the motion be agreed to. Honourable Dr Duncan Webb.
Oh, thank you, Madam Speaker. And what a momentous day it is as we add 12 words to the Legal Services Act. You know, we've made our position clear. We're not going to stand in the way of this bill passing. Well, not for very long anyway. But because community law centres are really important. And I must say, it's good to know that there's cross-party support for the continued existence and hopefully the flourishing of our community law network, because as the Minister pointed out and other members have observed, community law centres fill a really important gap in access to justice. And access to justice is essential to the rule of law. And the ability to not only go to court, which is only one aspect of access to justice, but also just to know your rights and also to know how you can sort your stuff out in a legal sense is actually really, really important. And to a large part, it's that second aspect that community law centres fill. They are able to talk to people and say, well, look, you know, we think you're in the right or you're in the wrong, or there's some middle ground, but also navigating how then to vindicate those rights. Because many a time people say, oh, I want to go to court and so on. And look, maybe that's the right course, but many a time there's another way, whether it be through an alternative tribunal, one of our many ombudsman and dispute resolution schemes, or the disputes tribunal. But that kind of information and just that helping hand, you know, because I can remember I both used to volunteer at the community law centre. I used to be a supervising solicitor at the community law centre, and I've sat on the board of a community law centre. And someone who comes in, and quite often, you know, people might think their issues are trivial. I've bought this appliance, this, washing machine for $600 and it's broken. Now, for some of us, that would not be a particularly troubling thing, but for other people in the community, that is catastrophic because the weekly surplus that they have is so small that sets them back in a very significant way. And so to be able to sit down and say, well, look, that retailer might have given you the brush off, but the first step is to go back to the retailer and let them know a few things. And the first thing you need to let them know is that you've clearly taken some advice just on the lowdown. And the second thing is that you know what your rights are, that you can't simply be told, well, it's 2 years old, so it's out of warranty. And the third thing is let them know that if you don't get satisfaction there, you know where to go next. And, 9 times out of 10, equipping, an ordinary New Zealander with those 3 facts will be more than enough to solve their problem. All of a sudden, the person at the counter doesn't dismiss them out of hand. They go and get their manager, and their manager knows that there's a thing called the Consumer Guarantees Act. And that is really empowering. And so our community law centres do need to be funded properly. The Canterbury Community Law Centre does a great job down there in Christchurch. But one of the things that is really important, and perhaps this bill will make sure continues, is making sure that those lawyers stay up to date and they're well resourced. And recently I know they went through and reviewed all their salaries to make sure that they're paid on a scale which was not derisory, which arguably had been the case, but also to make sure they get further education so that when the law does change, they can make sure that they're giving up-to-date law, and also that they have all the research tools they need, that they can go online and look at the legal commentaries and the statutes and so on and so forth, which all costs money. So if that's what this bill does, well and good. We think it was probably the case anyway, but we've been told it's not, and so that's why we'll be supporting this bill further in this House. I mean, if you think about it, and there is that problem, I'm disappointed that in the Committee of the Whole, the Minister didn't really give a great deal of comfort as to contracts which were already extant. And it may be that the Crown Law advice that she won't let us see says that this doesn't affect existing contractual arrangements, but there is a question about that. The definition of legal services in the Legal Services Act is a little bit narrower. I had thought that it was relating to the lawyers and conveyancers definition, which is a very broad definition, essentially says what services are regulated services, and legal services there can be all kinds of services, but a slightly narrower definition, I think, in the Legal Services Act. So look, it's a piece of legislation which you're saying is necessary, but again, just want to really make sure that across all parties we ensure that the special fund that this bill talks about is properly resourced. And one of the things which has happened recently is that interest rates have been relatively high. We can talk about that in other contexts later, but one of the upsides of that is that the money going into the special fund has actually been pretty good. When we're in a very low interest environment, the government actually, and it was the Labor government that did it, had to top up the special fund. That hasn't been necessary recently, but it's perfectly possible that as interest rates do go up and down, that will need to happen again. And it's good to see that from what I have heard in the relatively short speeches from the other side, there is a commitment to ensuring that lower income people do get free legal services, and therefore I'm inferring they will be properly funded. Of course, the other thing is that it's not just low income people. Community law centres generally have an open door policy. We don't tend to, community law centres don't tend to seek as customers, middle class and wealthy people who can get their own legal advice and pay for it. But they also come in, particularly in the kind of clinics that they have where you can have a drop in and ask a few quick questions. So, it's not just super low income people, it's a wide range of people that come in. And also just recognising that in terms of early intervention, the work that community law centres do in the family space is really, really good, because when people break up and have property issues and child issues and care of children issues, getting to sort that out at an early stage before it gets tangled and acrimonious can be a really, really useful thing. And many a time, what perhaps we don't understand is many a time people split up and no lawyer sees it, often ever, but that's not a good outcome sometimes for the children in particular in the relationship, because it's always better to have some kind of structure around how that child is cared for, how the child is funded, right? Child support, either within the IRD system or outside of it, is an important part. And our community law centres, funded through the special fund, are a really good part of that. And I'm sorry if I'm boring you, Vanessa Wernick, but wakey wakey. It's been a long day.
But I mean, I must say, you know, the other thing that we need to address about the special fund is the proportion of it that goes to community law centres, and in terms of the interest on trust accounts, whether it remains appropriate that banks keep 40% of the interest on trust accounts. You've got to remember that's clients' money. So, you know, the general rule should be go back to the client, but in this case, the legislature has intervened and said, let's use it for community law centres, and then said, and let the banks keep 40% of it. That's a pretty significant share. And as I think I said earlier, perhaps a few in the second reading, that's about $10 million that the banks are getting of interest that would go to clients or the special fund. I mean, of all those three people, clients, poor people needing legal services, and banks, I know of those three where I think it should go, and I know the least deserving of them. But there you go. That's something we can address on another occasion. So look, a bill that's not urgent, could have gone in a statutes amendment bill, probably unnecessary and doesn't address all of the problems it needs to address. But, you know, we're generous people on this side of the House. We'll probably support it anyway.
The time has come for the dinner break. The House will resume at 7 p.m.
Good evening, members. When we broke for the dinner break, we were debating the Legal Service Distribution of Special Fund Amendment Bill. We're up to call number 3 in the third reading. It's a Green Party call. Lawrence Sunan.
Thank you, Madam Speaker. I rise on behalf of the Green Party to support this bill into its third reading. As I've mentioned in the second reading for this speech, this is a bill that was originally introduced under the budget urgency, and it was something we opposed initially, but through a very thorough select committee stage, as well as engagement with the submitters, we have now supported this bill. Madam Speaker, this bill was something that we did go through in the committee stage, and I want to just kind of highlight some of the key points in the select committee during the committee stage that deserves some attention on this bill. Madam Speaker, understandably, this is a small bill, only 4 clauses, yet we were able to have a good discussion on each of the clauses. I think particularly from, let's start with clause 1. From a title perspective, that we did have quite a robust conversation around the title. I would really like to thank the member Camilla Bellich in particular to actually give, as well as Venushi Walters, to give a very good and an insightful history of the context of the Community Law Centre Aotearoa that brings sort of this bill to us. It's now been wrapped into the Legal Services Act 2011. It is unfortunate that the Minister did not take on board my title amendment, and the main reason for that is because I do believe, or the main reason I put in the amendment is because I do believe that the distribution in this case is not the appropriate word to use. I think it might have been the member Camilla Bellich's suggestion of clarification of the distribution of a special fund would have been actually much more insightful, or clarification of the special fund, because it simply is not actually to do with the distribution of the fund itself. So in that sense, the title can be interpreted as a little bit misleading. In terms of the commencement date, Madam Speaker, we saw that the commencement date has changed, and it's now the day after royal assent. Now, the original commencement date is the 1st of July 2025, and this is there is a level of significance because, as I mentioned, this is a bill that was introduced under urgency in May, but only the first reading was introduced under urgency, and there was no motion that's been brought to the House at the time that is going to have a shortened select committee stage. So it was a question that we raised to the Minister, because we weren't able to get that in select committee, but it was a question we raised to the Minister during the committee stage on how they're intending to have this bill and this act come into force on the 1st of July 2025 when they were still in the process of the select committee. But also at the same time, it was members asked the Minister questions around whether between the 1st of July 2025, considering that, it was introduced under budget urgency, therefore, understandably there will be some budget implications. But considering that, with the budget implications, what has changed, if any, and what impact does it have to the government or to the implementation or the commencement of this bill, now that even after royal assent, you're looking at a 4.5-month delay in terms of the commencement and whether there's any significant issues. Madam Speaker, then we moved on to the principal act of this bill, and that is clause 3. And I think this is the area that we did spend a little bit of time on during the committee stage, and it's important to highlight the fact that this bill, and I'll talk more about clause 4, but this bill is a very small bill that could have been wrapped into the statutes bill, which was something that the Honourable Dr. Duncan Webb has mentioned. But instead, it's being introduced as a separate bill. So, we did check with the Minister to see if it was going to be wrapped into its individual bill that deserves a select committee process and everything, separate, beyond what we see in the statutes amendment bill. Whether there have been any thoughts about wrapping in other things from the Legal Services Act into it as part of a package, particularly when we are looking at the fact that the Community Law Centre part of the Legal Services Act, it occupies subpart 3 of part 3 on administration of legal services system, specifically clause 93 to 96, and clause 94 is what's being amended here. Whether there's been any consideration on expanding the scope and potentially looking at separating out the Community Law Centre into its own part within the Legal Services Act. The rationale for that is, we are looking at other parts of, there are two reasons for that. Number one is in terms of clause 93 to 96 on Community Law Centre, it doesn't necessarily fit nicely under the definition of administration of legal service system, similar to other subparts of that part 3 of the Principal Act. But also, other legal service providers or legal aids, for example, have their own section. It's part 2 of the Legal Services Act. And, if legal aid had its own section, that presumably there is the possibility that Community Law Centre should also have its own section within that particular act. But also, another important part is that this particular bill deals with special fund, and special fund in the principal legislation is only applicable to community law centers. And by embedding it as a subpart of a major part, there's also whether questions were raised on whether that is going to mean expanding, or whether we're still going to be able to maintain the integrity and also the ring fencing of that particular fund within that particular subpart. Finally, Madam Speaker, the crux of the bill is clause 4, which has the most significant amendment. Now, this is something that I think the member Venushi Walters has raised a number of really significant amendment papers which wasn't accepted, and it's a shame because a lot of that didn't come from, it actually came from the submitters themselves in terms of the amendment. It came from legal experts, the Law Society. It came from Community Law Centre themselves, which is the most affected by this particular legislation. So it was unfortunate that the minister wasn't receptive of some of these amendment paper. And I do want to mention my specific amendment paper as well, that the minister didn't really consider as a part of that, which I actually think is an important one, because the current wording of clause 4, section 94(1)(b), it does say fund, facilitate, and otherwise support in the context of the secretary. But the clarification I have, and this also came from the Community Law Centre submission, is that it should state that it's that the secretary is funding the functions that enables, facilitate, or support the provision of community legal service. The reason I want to raise this as a particularly important aspect is the way that we're looking at a succession or a sequential verbs of using fund, facilitate, and otherwise support, also then would imply that it's also the secretary's role to facilitate and otherwise support the provisions, when in fact my assumption is that the secretary's role is to fund, and the functions of that remains with the Community Law Centre, which then ties into the facilitate or support the provisions of community legal service. So this is something that the minister wasn't able to support one, but I'm hoping that by mentioning this particular nuance, that it does give scope for potentially both the Ministry of the Crown Law, the Ministry of Justice, but also provide some sort of clarification in terms of interpretation for the Community Law Centre as well. So to conclude, Madam Speaker, the Green Party of Aotearoa, New Zealand does support this bill. We do recognise that although this is a small bill, and we've heard a lot of murmurs from the government side as we were debating this bill during the committee stage, but it is a bill that has been introduced. It is out of all of the bills, a lot of the bills that's being introduced by the government, reasonably benign or actually completely benign. So, if we're going to be able to see more bills being introduced like this is something that we could actually encourage and have something that is reasonably benign that everyone could support. So with that, Madam Speaker, the Green Party commends this bill to the House.
The Honourable David Seymour.
Madam Speaker, I rise in support of the Legal Services Distribution of Special Fund Amendment Bill. This bill makes a change to how the special fund can be used. And people sitting at home that watched that last speech could be forgiven for having no idea what this bill is about or what anyone's talking about. But it's pretty simple. Lawyers and conveyancers up and down New Zealand, for various reasons, have trust accounts where they hold their clients' money for a period of time. Fans of that iconic New Zealand show, Outrageous Fortune, may recall Jethro got in trouble for abusing or misusing money in the trust account, and Gary Savage actually blackmailed him and stiffed him on a property deal as a result. A lot of lawyers have these trust accounts, most of them don't misuse it. What's interesting is that they sometimes accrue interest when they're put in the bank, and that interest goes to the special fund, and the Secretary of Justice, that is the Chief Executive of the Justice Department in New Zealand, uses that money to fund community law centres. And I actually think that's quite a nice feature of our legal system, because community law centres help a huge number of people, and it's not obvious what else would happen with that interest that could be better than this. But there's a small problem. The law as it stands in the Legal Services Act says that it has to be used for community legal services. And there's some dispute as to whether the depreciation, the maintenance, the electricity, the rent on a community law centre counts as a legal service or another use of money. So what we're doing with this legislation tonight is saying actually the Secretary of Justice can make some rules about what exactly is included, assuming they'll use their common sense to ensure that the money does actually go to providing community law services, even if the precise use is not paying for a lawyer to sit in a room. Pretty sensible stuff, not difficult to explain. And you know what, maybe if Lawrence Sunan learned to do that, we'd put up some more agreeable bills for him. Commend it to the House.
Jamie Arbuckle.
Thank you, Madam Speaker. I rise on behalf of New Zealand First to support the Legal Services Distribution of Special Fund Amendment Bill. And Madam Speaker, I'm going to take you back to budget night, because I spoke to this bill also in urgency on budget night, the last speaker of that session before the clock ticked over 12 o'clock. And I remember saying, as I was talking about the rest of the budget, as that budget was a game changer for business, that in some ways, and that policy that we'd announced that day in the budget was investment boost, what was a game changer. But when you take it back to this bill, Madam Speaker, this is a game changer for access to justice and access to legal services. And that's why this bill is so important to community law services. In the speeches that I've given through first and second reading, as I said, I sat on the Justice Committee, heard the submissions, and we got that substantial submission from the Community Law Centre. Though the services they provide throughout New Zealand, those 24 centres, they provide access to so many vulnerable New Zealanders, people. As we heard also, I said over 27,000 educational sessions that they gave in their last year. They give access to justice and to information that people require. New Zealand First supports this bill. It is very much a tweak to allow the services can be, or the funds can be accessed more. It shows New Zealand's First commitment of sensible and cost-effective solutions to improving service delivery. So it's about using funds that are there, not using taxpayers' money. I commend this bill to the House.
This is a split call.
I call Tabitha Paul.
Tēnā koe te maanga o te whare, nō reira tēnā tātou katoa. E tū ana ahau ki te kōrero I pā ana I tēnei pire, ko te Legal Services Distribution of Special Fund Amendment Bill. Ka parakatahi ahau I tōku reo rangatira, te reo o tō tātou tipuna, e mihi ana ki ngā kaiwhaka Māori, reo Māori I roto I tēnei whare. E mihi ana ki tōku kaiako reo Māori, ko Devin Wikaira tōna ingoa, ko whitiki te ingoa o tōna kaupapa. Ko te Legal Services Distribution of Special Fund Amendment Bill te ingoa o tēnei pire, he whakaaro nā te Pātika Kiriki I nei kupu. I te pānui tuatahi o tēnei pire, I whakakahore mātou I tēnei kaupapa. Ko te mea tuatahi o te whakakahore nā te whakaiti o etahi pūtea mo te legal aid funding ki ngā community law centres anō hoki. E rua tekau mā whā ngā tari o te motu o te kaupapa o community law. I te kōmiti whiriwhiri, e tautoko ana a community law I tēnei pire. Ara, kua whiti I tō mātou whakakahore, kua whiti I tō tātou poti o tēnei kaupapa o tēnei pire. Kua tautoko te pire mātou I nāia nei, o I tēnei pō. I tēnei pō, I te pānui tuatoru o tēnei pire, e tautoko ana mātou I tēnei kaupapa. Ko te kaupapa o tēnei pire, ka toha I te pūtea ki ngā hapori o te motu, ki te tautoko o rātou tangata me ngā mahi ture. I te wāhanga ruarau, I wa te kaumā o te Lawyers and Conveyancers Act, I te tau 2001, ko ngā ture ki te toha I aua pūtea e noho ana I roto I te Special Fund. Ka whakautu I te Secretary of Justice I ngā tārana te Special Fund, ko te mahi o te Special Fund ki te koha pūtea ki ngā tari o community law o te motu. I te wāhanga I wa te kaumā o te Legal Services Act, I te tau 2021, e kōrero ana I taua wāhanga e pā ana I ngā tikanga o rātou kawinata. Ko te mahi o tēnei pire, ko te Legal Services Distribution of Special Funds Amendment Bill, he mahi whakapai I te Legal Services Act I te tau 2021 ki te whakaai I ngā kawinata nā te wāhanga I wa te kaumā o taua ture. Ko te kaupapa o taua wāhanga ko te mahitahi. Mahitahi o ngā tari e mahi ana I ngā mahi ture. So, ai ara, kua whakamana I tēnei pire, kua tautoko ahau I tēnei pire, nō reira ngā mihi ki ngā kai whakamaori I tēnei whare miere, kia pai tō koutou wiki mutunga, kua ea tōku kōrero nō reira tēnā koutou I te pare.
Carl Bates.
Thank you, Madam Speaker. Madam Speaker, one of the Select Committee recommendations was to change the starting date of the Act because the original date has already passed. Therefore, it's important that we get this bill passed this evening and I commend it to the House.
Thank you, Madam Speaker. And I rise also to support this bill, as we've said we would throughout the speeches this evening. And it's true, it is a very simple bill to understand. I think the two key questions that we've been asking through committee stage are is clarification really needed, was the first one, and our view was that it wasn't. Our view was shared by community law or Aotearoa. And the second question is, even if clarity was needed, is this the most important work that the government should be doing for the people of New Zealand? And again, the argument was that no, it could well have been part of a statutes amendment bill. It could have been part of work that I mentioned Sir Geoffrey had suggested in terms of the review of laws that should be repealed on the books. But we are going to support it nonetheless. I did notice through the course of the speeches that on this side of the House we had a number of people stand up and speak to their personal involvement with community law, whether it be volunteering or as members of staff or as members of the board, and it is a fantastic thing to do in terms of contributing to our community. Didn't didn't quite hear that from the government side, so just some gentle encouragement that it's not too late. Lawyers or non-lawyers, there are plenty of things you can do to contribute to access to justice. Where I started my speech on the second reading was a comment on why we're in urgency, and I do think that's relevant here at the third reading as well. I was recently contacted, as I'm sure many of the other members were, by a group called Improving Urgency, who have a set of recommendations that they're arguing for, and they're doing it precisely at this moment in time because, as we all are very familiar with, our standing orders are under review, and this is the time when parliamentarians across the House will get to decide whether those provisions relating to urgency are good, or perhaps whether something ought to be done so that we avoid the situation that we're currently in, where we see ourselves in urgency to clarify a law that community law says doesn't need to be clarified. Improving urgency suggests that we look at a set of criteria that would be applied to determine when urgency is needed. So the presence of a genuine emergency, imminent deadlines that are linked into international commitments or legal obligations, that the issue requires immediate legal action to prevent significant financial or reputational damage is what they suggest in terms of where we could go. And of course, if you are fond of reading this fantastic book, McGee, you will also get some direction in terms of what urgency ought to be. The suggestions in there are legal reasons, emergency or unforeseen events, and political situations. So it does allow for the fact where you've campaigned on an issue and you are wanting to move that quickly through the House. But again, I just suggest that the stretch of the use of urgency is getting a little bit ridiculous, and I do worry that a few people have said to me, well, you know, your urgency will end at midnight, and at least that's a limit on it. In fact, we could, if the government wanted to, go into extraordinary urgency, which as the members in the government benches will know, I will have a lot to say, as I know my colleagues will on the next bill as well, and certainly have had a steady stream of coffee through the day. If we were to go into extreme urgency, as I'm sure the members will want to know in advance before they make this call, the House only breaks between 8 a.m. and 9 a.m. So we would essentially be going all the way through to 8 a.m., which would potentially be quite entertaining. And perhaps we could see if the length of speeches on that side get longer, or if they get any shorter, if that's even a possibility. Look, I do want to acknowledge community law. They are an extraordinary service, and they did a study when I was there with them back in 2018 that looked at value for money, and even back then they had a return on investment of $50 million of free legal services each year that cost $11 million, but it was said to deliver $50 million, and that's because issues were resolved at a very, very early stage, which is fantastic. But I did also want to speak to one issue which I do think is one the House needs to continue to be mindful of. Others, it does end on Saturday, as Mr. Seymour has said. Yeah, that would be true for today. So the opportunity is lost for this week, but why do I suspect that urgency is in our imminent future? Again, just moments away. Perhaps the public can watch and see whether that might be the case. So in preparation for the next block, I did also just want to acknowledge the history of the Lawyers and Conveyances Act in 2006. When I was going back to the Hansard to look at that bill and the changes made, I came across this beautiful quote from Nandor Tanchos, And so they were considering the percentage of money that the banks kept, and it looks like the Select Committee interrogated, even back then in 2006, whether the banks should be holding as much of the percent as they are. Of course, currently it's 40% on law. I will make the point that I understand that negotiations have happened with a number of banks who are looking at reducing that margin voluntarily. My view is very strongly that that should be reduced in statute. So Nandor says that the bill as it was introduced originally sought to amend that provision so that the banks would retain 45% and community law centres would receive 55%. So the only amount that they managed to negotiate that down was 5%. They got it down to 40% and community law retaining 60%. But he also makes this point. He says, the question of the true cost... I'm very much on the bill, and I'm quoting Hansard into Hansard about an issue that's very relevant to the bill. This is so good. So he says the question of the true cost of the service has never actually been resolved to anyone's satisfaction. This is the service that the banks provide in setting up and maintaining those accounts. So I am moving to amend the proportion the banks would now retain from 40% to 30%. The concern about that proportion is that if we get it wrong, the banks may cease to provide the service. So he was acknowledging that it couldn't be too low, but it shouldn't be too high, and that even at that stage they hadn't truly analysed what that appropriate amount was. I do think that that's a matter for this House to consider at some stage, because what we know is that at the moment there isn't sufficient free legal advice and certainly not free legal representation for people who need it. So it's something we should look at. I did want to acknowledge one more time Te Aotearoa, which is also a community law centre initiative trying to help address that gap where pro bono lawyers assist community members with legal issues. An interesting fact from last term was Chris Bishop had a members' bill that attempted to allow lawyers to provide free legal services without necessarily that funnel, if you like. And our view was very firmly that community law play a very important role in terms of directing that capacity to precisely where it's needed. And the other interesting service that they started was the legal information bot, where people could type in questions and have those answered, which was fantastic, especially for young people. Many people have been acknowledged today, names dropped and such. I did want to mention one more at closing. Piers Davies, who's been a significant part of the community law movement and who in 1 week's time will step down from the Youth Law Board. He told me about 10 years ago that he was going to step down, and he's really pushed and done everything possible to ensure access for justice, but especially for young people. So to all our heroes in community law, but today especially to Piers Davies, I commend this bill to the House.
Tom Rutherford.
Madam Speaker, happy Tuesday. Where else would you want to be on a Tuesday in urgency, Madam Speaker? Isn't that great? And Madam Speaker, I will just wake the House up after that 10 minutes of nothing, Madam Speaker, but you know, this will be refreshing. An extraordinary urgency, well, that sounds exciting, so I say to the member, bring it on. But this, Madam Speaker, the Legal Services Amendment Bill, it's a great piece of legislation, great for our community law, and therefore I'm going to commend it to the House.
Honourable Rachel Brooking.
Thank you, Madam Speaker, for this opportunity to speak on the Legal Services Distribution of Special Fund Amendment Bill. And this is not a bill that I've participated in before now, so it's been interesting to hear the debate on this third reading. And of course, Madam Speaker, I was a lawyer at one part of my life and was very much involved with the ins and outs of the trust fund. And as David Seymour said before, this is a very important function that law firms hold. Because of course, if you are doing a conveyancing or a much bigger transaction and your lawyers will hold your funds for you, if the lawyers do something bad, then that's going to end badly. And that may have happened in the past. So one of the things that we've been doing in New Zealand for a long time is using some of the money that's made from those funds, as David Seymour said, to fund these community law. And we know also that community law are great organisations that help people in need. And I want to pause on that for a moment, because now I'm not a lawyer and I am a constituent MP. And the phenomenal work that the Dunedin Community Law Centre does is just so helpful to so many people. And I want to commend all of them for the work that they do, be it on an immigration case or when people are having civil disputes and need a little bit of help. Community law is there for them. So it's very important for many of our citizens that community law is able to operate as effectively and as helpfully as possible. And Madam Speaker, I'm also the member for a university town, which of course has law students, and many of them volunteer at community law, or they certainly did in the past when I was a younger lawyer and would help at Dunedin Community Law. And it turns out that somebody who'd studied a lot of trade regulations and international environmental law and the Resource Management Act wasn't that helpful. But luckily, most of my colleagues had done things like family law and more property law papers, and they were much more helpful than I ever was. But so I do want to make that shout out to community law. And we've heard from the various speeches that the drafting of the current law could be read to be very narrow and not include costs such as the lease for the premises that, of course, these community law organisations have to operate out of. So everyone's agreed that it's good to fix it. It does mean, it says in the bill here, where the special fund cannot be used to meet costs, Crown funding is required instead. So noting that I haven't been part of this bill, that does look to me like this is a move away from Crown funding for any community law functions, and that this is another way to help the government's books by really more levies. And we've seen that with the waste levy, for instance, that it gets used for a whole lot of different things. So that is a negative. But we're trying to focus on the positives here because, as the member before me said, it's Tuesday night in Parliament's time and Friday evening in other people's times. I want to pick up, though, on some other points that were made in the discussion of this bill. And David Seymour was asking me to tell him about it, and I'll tell him about his speech, where he said something along the lines of, if the opposition speeches were clearer or shorter, then perhaps the government would put up more agreeable bills. And we are seeming to be in agreement tonight. So I'm wondering if that is a promise that the member hasn't qualified for being unclear or clear.
She could improve her average performance if she sat down before time.
Oh, I'm wondering about this statement that David Seymour has been making about the opposition speeches, and if there is some sort of promise here that rather than taking us into urgency time and time again and looking at bills in all stages, that this government will commit to the sorts of bills that all members of this House can agree on. So I'm hoping that that is what he is saying. I can't quite hear him. Oh, I'm hearing that it's not what he's saying. Well, a challenge to you, Mr. Seymour.
And the member's time has expired because that is the end of the speech. Greg Fleming.
E te manga o te whare. Tuatahi, mihi ana ki te mema o te pāti kakariki mo tōna kōrero e te reo takitaki. Mo te wā tuatahi, mihi ana ki aia. Ka reri te reo o te whenua I tēnei whare, ka piki te ora. Aha ko te, tēnei te kupu hau mō mātou, I tēnei pō. Whakaupa. Whakaupa means to delay, prolong, or protract. And, Madam Speaker, I shall do nothing of that. I commend this bill to the House.
Camilla Bellich.
Thank you, Madam Speaker. Pleasure to be able to take a slightly longer call than the full call that I didn't have. I only had a part call in the last reading. But community law is a very interesting subject matter, and I did touch on some of my experience in community law. I volunteered there. I was also on the management committee of the Wellington Community Law Centre before the community law centres were merged into a national body, which is a change of structure. And then I did go back to volunteer as a lawyer at community law once that structure was in place. But the issue really is this is an extremely special and important part of the way that we provide legal services and legal advice to the community. I think really it's the people who work in community law, like my colleague Venushi Walters, who was heckled somewhat during her speech, but I think we need to acknowledge Venushi Walters studied at Oxford University and is a qualified lawyer, and instead of going to earn the big bucks at one of the major firms, she ran youth law for many, many years in community law centres and has done more pro bono work than I think probably anyone who's legally qualified in this House. So she has made a massive contribution to community law and also to the spirit of free legal services and access to justice. So I just wanted to acknowledge that, Venushi, because you are an exceptional lawyer and an exceptional citizen in the sense of your commitment towards access to justice. So it's important for us to remember that, and also your long experience with community law and your contribution there too. So community law, it is, I do agree with some of the speakers on the other side who acknowledge the way that community law is funded, and it is, as we've traversed, a very interesting funding mechanism where all of the very, very wealthy trusts account, I don't know if account can be wealthy, but anyway, they usually have a lot of money in them, and that's because lawyers hold money on trust for a number of different important transactions, and that's to ensure that they get paid on time, and it's also to ensure that they're safe, and it's to uphold different contractual agreements. So for whatever reason, sometimes your personal money can be held by your lawyer in their trust account, and there's lots of rules associated with running a trust account, and as qualified lawyers, anyone who's ever gone through that process, there's a lot of training and education that you have to go through in order to be able to legally manage one of those in a responsible way. So these are significant functions of our way that our legal services are provided. And one of the ways that the legal community, and in fact governments of the past and successive governments have decided to utilise the function of that, is through allowing the interest that accrues on those trust accounts to be, rather than them to be just kept by the bank, although there is a percentage which is kept by the bank, and this has been mentioned a few times, and I'll just park that there for now while I finish explaining how the trust account works. That money then, or 60% of that interest, goes to this community law funding. We've got 24 community law centres throughout New Zealand. I visited a few of them, certainly not all of them, but I do know, I haven't been to the one in Wairarapa, but I'd love to attend the one in Wairarapa. I think that all of that I have visited have been incredible services, and I mentioned it very quickly in one of the contributions that I made, but I think it's worth saying again. The members of this House will know how useful community law centres are because of the number of times they refer their constituents to those services. And it could be that they refer them to attend and see a lawyer, or it could be that they refer to their very excellent community law guide. And before there was a plethora of information, legal information on the internet, this was really the one free area that you could find very, very good, solid legal advice, this community law guide. It's kept in most public libraries, I think, still today. usually distributed for free and updated, and it's a hugely important resource that community law provides and has done for many, many years. So that is an example of something that community law does. I think that that would fall within the current definition without this Act, and the reason I say that, Madam Speaker, is because if you look at the Legal Services the Legal Services Act, the definition of legal services actually covers education. So I think that particular area would probably be fine without this change, and that's reassuring because that has been something that has been funded for a very long period of time. I think community law could do more, and I think the frustration with this bill as it's gone through the House is not that there's huge disagreement that, on what this bill does. There is disagreement as to whether it's necessary or whether it's the best use of Parliament's time or whether, in fact, the due diligence has been done to ensure that previous spending of community law centres has been for the right cause. But I think the frustration has been that actually the potential for our community law, and when we look at the funding, which is the subject of this bill, this doesn't fundamentally change the percentage of interest that goes to community law. This could have been something that could have been looked at in this bill. I know that's a policy area for perhaps for the government or an incoming government to look at, but certainly I think there's more that community law could do and more that they could provide, and I think there's an appetite for that. I think there's also a need for that too. My own experience of working in community law was a lot of the time that people would come in and seek legal advice, often they were wanting common sense advice. And to be that first person there when they come through the door and have a problem, and to just be able to point them in the right direction, that is something that you can do as a lawyer. You don't necessarily have to be a lawyer, and that is why I think it's great within the suite of legislation that this bill is a part of. We allow law students to work at community law centres, and it forms a part of their training as well. I mean, this could be, I'll use one example from my time providing advice in this particular type of circumstances. I had a woman come and see me, and she said to me, "I've been sacked." And I talked to her about it, and she wasn't going to go into work the next day because she was so upset about having lost her job. And when I went through it with her, I found out she hadn't actually been dismissed, and that there was every indication that her employer was expecting her at work the next day, and it had just been a miscommunication around something that she had done at work that wasn't, that she'd been told was wrong, but she'd taken that entirely the wrong way. And I think that shows the value of being able to access that type of advice. She was feeling incredibly vulnerable. If she hadn't turned up to work the next day, it's very likely that maybe she would have ended up losing her job. But just going through, what's happened, what documentation have you received, this doesn't look like a dismissal to me. It looks like you've just had a performance issue raised with you, was enough for her to feel much better, and within a very short period of time go back and I didn't see her again, but I assume hopefully she was able to go back to work. So these types of services can provide very meaningful help and advice for people when they access them too. So in relation to this bill, our general view has been we're supportive of it. We wish it would go further in order to fully bolster and support community law. We think there's probably ways that it could do that. We're not 100% around the need for it, just due to the fact that it just is quite a difficult concept to think of how legal services would be able to be provided without all of these other utilities, as some other speakers have talked about, in terms of the rent for the premises, the other items that you need to provide advice, the photocopies. These things, as I understand, have been being paid for by community law under this agreement. This bill probably will clarify that. So there's unlikely to be, there's one thing I can say about this bill is it makes it clear that the services that have been provided to date are very well within the law due to this clarification. But it could have gone further, and there could have been other things that we focused on too. It's reassuring to know that community law centres also support this bill. So I think the government really for allowing us to discuss the important work that community law does, and I would encourage them to think about the really amazing contribution community law makes to the community and what we collectively as a parliament can do to support that important work moving forward. I think it helps not only us as parliamentarians in our job, it helps the members of the public who access those services, and there could be even more benefit if we were to truly fund and support community law within New Zealand. So, Madam Speaker, I do appreciate the opportunity to speak on this bill, and I commend it to the House.
Rima Narkley.
Thank you, Madam Speaker. Madam Speaker, it's a pleasure to be the technically last person to contribute on this bill. And speaking of technicality, Madam Speaker, I think it's very important to clarify, because there's been some interesting opinions from the other side, that the current law is unclear with respect to whether the special fund can cover indirect costs. And what we're doing here is clarifying this discrepancy. I commend this bill to the House.
Very good. Scott Willis, you were very quick off the mark that time.
Thank you, Madam Speaker, and it is very much appreciated. It's my pleasure to be able to take the last call on this bill tonight, and certainly nice to have the little bit of angst from opposite as well, or the gaslighting that we typically get, because it does indicate that I think the members opposite are feeling a little bit angsty. They want something else. We want to be here. We appreciate this opportunity. We certainly appreciate this opportunity.
I can't actually hear Mr. Willis. I don't know if he's speaking to the bill or not, because I can't hear him.
No.
So we'll have some quiet so I can hear what he's saying.
Thank you, Madam Speaker, because politics does not have to be adversarial, and this bill, as minor as it is something that we are all agreeing on. We're agreeing on. Really, the amount of heckling I'm getting for agreeing to a bill is quite surprising, but not so surprising really when we consider the nature of the government on the other side, because we do have a government that is pushing and has desired to push such a minor bill through urgency, and Sir Geoffrey Palmer has called the extreme use of urgency a shambles. Madam Speaker, we've heard the value of community law. We've heard from Sir Rachel Brooking. I did not know that Rachel had volunteered in the fantastic Dunedin Community Law Centre, but I do know that this is a great place for people to contribute. We've heard about the need to think about how to best resource community law, and this bill is doing a little bit there, but really not very much. So I'm really in support of the Honourable Duncan Webb, Venushi Walters and Camilla Bellich, that we look at a review of how that funding works in the future, because this bill isn't really going anywhere near far enough, and it's not doing anything very much. So, Madam Speaker, those are things that we think are valuable, and we shouldn't just stop here. Given we've got this sense of bonhomie when we're all getting on, why don't we look for other places where we can actually make some progress? Why don't we look for some other places where we can actually make some progress? Because the bitchiness and that might come with fatigue, but it is not necessary. And it's good to hear that we've got students involved. One of the things that I've particularly enjoyed with community law or understanding in community law is the many kaupapa community law services designed by Māori for Māori. And they're really important to give Māori decent legal advice to help fight the Crown on land and te tiriti issues, for example. Particularly important at this juncture of our Parliament, we certainly need to give assistance to people who are concerned if their te tiriti rights are being ignored. And this is really important. There are a whole lot of things that are happening in community law that we don't necessarily see, but it's the type of thing that really gives confidence to people to be able to take their concerns to somewhere where they can get some professional advice, and it doesn't cost the earth. So, Madam Speaker, this bill is a minor bill, and we should be mindful that we don't waste Parliament time on minor bills. However, given the opportunity to speak on bills while we have the luxury of being in Parliament, and we're grateful to the government for keeping us here, we want to make sure that this bill moves forward, but we want to also make sure that there's not the use of urgency for little purpose. And that, Madam Speaker, is our equal concern. Because, Madam Speaker, we have seen from this government a shambles of process which really makes the public limits Parliament's ability to communicate with the public.
The question is that the motion be agreed to. Who spoke during voting? Don't do that again. The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Legal Services Distribution of Special Fund Amendment Bill, third reading.
I call on Government Order of the Day number 16.
Judicature Timeliness Legislation Amendment Bill, second reading.
Honourable Scott Simpson.
Do you...
Madam Speaker.
Honourable Nicole McKay.
Madam Speaker, I present a legislative statement on the Judicature Timeliness Legislation Amendment Bill.
That legislative statement is published under the authority of the House and can be found on the Parliament website. Honourable Nicole McKay.
Madam Speaker, I move that this bill be now read a second time. I would like to begin by acknowledging the Justice Select Committee for their examination of this bill. My appreciation also goes to the submitters who took the time to participate in the Select Committee process and for their contributions. This government is committed to reducing delays in the courts system. We are very conscious of the fact that many New Zealanders are waiting too long to achieve justice and get closure through the courts. That is why this bill is so important. The amendments in the bill are necessary to support the efficient, fair and timely resolution of court proceedings for all court parties and participants. The bill increases the cap on the number of High Court judges, enabling 2 additional judges to be appointed. More judges will help the courts better manage the growing workload. One thing that has been heard through the Select Committee process and other comments on the bill is that the increase of 2 additional judges may not be enough to meet the demand for judicial resource. The Minister of Justice has therefore introduced an amendment paper to be considered at the Committee of the Whole House stage, which will enable the appointment of a further 3 judges. This will bring the total of potential new judges to 5 so that our senior courts can more effectively manage the workload. Madam Speaker, the court system is complex and more judges alone cannot address the timeliness challenges. That is why this bill also improves various court processes so the courts can run more efficiently. The bill makes changes to improve pre-trial case management so there is less duplication. It ensures appeals are heard by the most appropriate court, and it gives judges better tools to manage proceedings that plainly abuse the process of the courts. It also allows coroners to close certain inquiries when it is no longer appropriate to conduct these. The Justice Select Committee has made recommendations that clarify and refine the bill. This includes changing the commencement date to 1 February 2026, enabling an order that deals with plainly abusive proceedings to be made on the papers, and ensuring consistency across the Coroners Act. Madam Speaker, I support these recommendations, which will help improve efficiency in the courts. Justice delayed is justice denied. This Judicature Timeliness Bill goes some way to addressing this. I commend this bill to the House.
The question is that the motion be agreed to. Greg
Madam
O'Connor.
Speaker. Madam Speaker, there's a couple of truisms in the justice system. One of them is that you can't hide the bodies, and the other is that whatever else you try and do with crime statistics, look at what happens in the courts, because that also tells you the truest story. So when I look at this bill, there's two things I look at. Yes, we do need some more High Court judges. There's no doubt about it, and we'll certainly agree with that. But you've actually got to look at why we need more judges. Yes, we need to speed up things, but actually have a look at the cases that are going before the court where the increase is. And the increase is actually murder, attempted murder and manslaughter, which are Category 4 offences. Now, we often hear, and every government's guilty of this, is talking about how aren't we doing well on crime? Often it will involve a different way of looking at crime statistics, and they will always be presented in a manner which makes the presenter look best. I always remember visiting New York at the time of all the reforms over there, the Bratton reforms. And that was when it all of a sudden, each city looked at what New York had achieved, and they had a thing called ComStat, and it was where they actually started counting the crimes. They made each area, each precinct, actually responsible for the crime that happened in their precinct. And this caught on right around the states. And it exposed a few things. One of them, Philadelphia, was the city that had these wonderful results. They'd shown that, boy, hadn't crime gone down. And in every category, crime, it looked like they had basically solved the problem forever of crime, except for the murders, Madam Speaker, because they couldn't hide the bodies. And so that's why we have a look at the statistics. We have a look at what's happening in our courts, which of course is what this bill is about. And rightfully, every speaker should be concentrating on the bill. And I'll promise you, Madam Speaker, that's exactly what I will be doing. So, Madam Speaker, we look at then, so that is why this is a very good idea that we actually do increase the number of judges. How high? I've actually got an amendment paper. It's interesting that here we are again. Many of our speakers tonight have spoken that we're late on a very late, very, very late on a Tuesday night speaking about this. And this is why we actually wonder why we have to come back here to increase, and one of the provisions of this bill, to increase the number of judges by 2. I have an amendment paper which says that let's have a range of judges so that as crime goes up and down, as the number of bodies perhaps go up and down, Madam Speaker, we can actually have some flexibility in the system, but of course, being a second reading, I won't spend too much time on that amendment paper, and look forward to about perhaps 11:30 tonight when we're in the Committee of the Whole on this bill. It would be a shame for anyone to be wasting some good sleeping time. So then this comes to the second part of this bill, in particular, Madam Speaker, where we actually talk about the cases and why we need these cases to be filled. The average cases, again, there's been some sort of, I won't say playing with statistics, but some sort of obfuscation around the statistics. But one thing that is clear is the cases that are coming to court are actually taking longer to resolve. They're more serious. You can put that down to something, and I spent some considerable time as a detective. In fact, I trained detectives, and I look at now at the sort of evidence that comes before trials compared to perhaps when I was training detectives. And I look at things and I suppose the complication, the things like DNA wasn't available, cell phones weren't available, CCTV wasn't available. And these are all the things now that if you go and sit through any serious trial, certainly any serious criminal trial, you'll very quickly see that that's where the first of the evidence is, because any detective, any police officer going to a crime scene, the first thing they do is look for a phone. The first thing they do is look for CCTV. The first thing they do is look for DNA. So as you can imagine, a little more complicated than things like fingerprints, a little more complicated even than perhaps getting a confession. or other ways and means of taking cases before the court. So you've got this combination, you've got more serious crimes, more, as I say, more murders, attempted murders and manslaughters, category offences going through. They're all taking that much longer. Again, these are the things that are putting considerable pressure on the criminal justice system. And very sensibly, this will attempt to resolve some of those issues. Again, it's not going to be, because the other thing you do need, of course, is courtrooms. So none of these things by themselves will work, because the bottleneck in the criminal justice system is almost invariably the courts. Because you can periodically, you'll see police for various reasons will be taking action on a any particular sort of crime, and it might be several months down the track, but the bottleneck will occur when they all need to go through the criminal justice system. An attempt was actually made to solve that. In fact, the national government in 2012 introduced a system called tag and release. It was actually quite an interesting system, Madam Speaker, where they actually had a strategy of reducing the entries into the criminal justice system by 19% in a year. Well, that just meant that when the bottleneck was moved from the courts back to the police stations, so as people were arrested, they would come through and they would be tagged and released, pre-charged, warned, and they would never be in the system again. There would be very little paperwork involved, and they'd be back out to do their deeds again. Worked quite well for about 2 or 3 years, until very quickly the offenders cottoned on to the fact that this was a risk-free occupation to go and play up on a Saturday night down in the local city centre, because at worst it might cost you a couple of hours sitting in the watch house or sitting in a cell, but you'd be very quickly back out. There'd be no court appearance in the number 1 court on Monday or Tuesday morning, and so you very quickly realise it was consequence-free, and that's when we ended up, like so many, when we introduce any new strategy, it's almost invariably about 3 or 4 years down the track before you really do understand the impact of it. We're in sugar-hit country, we're in politics, so often we're all looking for some new strategy that is going to solve everything from common cold to the AIDS, and we'll stand on every mountaintop and talk about it. Any of these new strategies that come in, and again I'm looking at strategies like this that we're talking about on the bill here, Madam Speaker, which you rightfully are looking at me to see, making sure that I am referring back to the bill, that these new strategies that we do. Well, I'm just making sure that you didn't feel any need to actually point me back to the bill there, Madam Speaker. I know
well, you stayed on tag and release for a while, so I knew that you were on the bill.
I know an extremely difficult job it is to sit where you are, Madam Speaker, and you're doing a fine job. So anyway, Madam Speaker, coming back, I may have just lost my train of thought there in that, as I went through that. Yes, Madam Speaker, so ensuring, so also I'll just move through this, because I do notice the time has moved on a little, because there's another important part of this provision too, relations to the Coroner's Court. Now the Coroner's Court is now this is also something that very much related to what I've been talking about before, because the Coroner's Court traditionally is that which reports last in the whole process. So again, typically when there's a homicide, the detective who's in charge of the body, their job will be one of their jobs is to open the inquest, to go along and open the inquest. That will then carry on through the trials, and way down the track you'll often get, finally, it will be closed by the coroner. The best thing you can ever do is get a certificate as to cause of death, which means that the coroner doesn't need to be involved. But often these deaths do go into the system, and having an off-ramp for the coroner where new evidence becomes available that precludes the need for what is often a very expensive and complicated process of having a coroner or having an inquest. So again, quite a sensible provision. It's hard to see where it would be used. The initial thought would be perhaps it's used for where it becomes obvious that maybe a self-inflicted death. That's actually not the case. Self-inflicted is one of the exclusions to this. Self-inflicted deaths will always go through the system. So, Madam Speaker, realising there will be other opportunities later on tonight during the Committee of the Whole to talk about some of these issues. But again, some of these things we won't know for 3 or 4 years down the track whether they have worked because it is a slow, grindingly slow system. The justice system, it does get there in the end, but really evaluating the success of things like this, as you usually say, 5-year review would be a good idea. We're commending this bill to the House.
Dr. Lawrence Yunnan.
Thank you, Madam Speaker. And I thank the previous speaker because, again, I think the previous speaker, Greg O'Connor, is absolutely spot on. We're talking about the fact that we seems to be sort of in this sort of sugar rush. I see in the sense that we keep on chasing for what is the short term as opposed to seeing some of the long-term impact that we have on some of these. But in terms of the Judicature Timeliness Legislation Amendment Bill, the Green Party does support this bill because it does make some good progress in that sense, in towards both timeliness and also access to justice, and also in terms of addressing some of the issues within our court system. I think I want to first just address probably the more significant section of this bill, which is the increase of the number of High Court judges from 55 to 57. But I think also what's really important to acknowledge as well is the Minister's Amendment Paper 443, which further increases that number from 57 to 60. And I'm sure this is something that we'll be discussing in the upcoming committee stage. So that being the first, major section of the adjustments in this bill when it comes to the Senior Courts Act 2016. But also a significant part of this bill is on the other half of the changes to the Senior Courts Act, which is around plainly abusive civil proceedings plainly abusive civil proceedings. And this is sort of functioning, and we've seen a few of these bills coming through the House from a court perspective on, for example, vexatious litigant and etc. And this is sort of very similar to that in the sense that the registrar is able to inform or is able to refer the plainly abusive civil proceeding to the judge, and the judges will have power to make orders and give directions in respect of plainly abusive civil proceedings. This is something that the Select Committee did flag to both the officials and also on this bill, mainly because the fact that it is unclear what the plainly abusive civil proceedings would entail, and then whether that is going to inadvertently prevent or provide barriers for some of the genuine issues that we're seeing, or for people who's got, for example, who are either from the disabled communities or neurodivergent, who may not simply understand some of the nuances in terms of vexatious litigation. However, I think overall during the Select Committee stage, there was something that was discussed, and the additions were added into it as sort of a safeguard. And I want to particularly mention an area which is the new section 164B, the new subsection 2A, which also covers some of these in terms of what judges has to report and how judges be able to make some of those rulings. So that's the first major part of this bill. Oh, actually, before I move on to the second half of the bill regarding the Criminal Procedures Act and so the Coroner's Act, it's also important to mention in terms of some of the submission process as a part of this. And, in terms of the Select Committee process, we did see that there were not as many as we thought for a bill that increases the number of judges, which does have, a budgetary implication. Again, this bill was one of the bills that was issued, that was brought to the House under urgency in May, and now we're getting around to this bill now as well. So there is a backlog of bills. So in this case, in terms of the Select Committee process, there were 28 submitters on this with a wide-ranging opinions, and there were broader themes as well. I think in general there was a complaint, or there was a concerns raised by some around whether this is prioritizing timeliness over fairness and how that is going to be addressed. I do think that as we are starting to see an increased number of High Court judges, particularly when High Court judges are also increasingly more diverse. Actually, in general, our senior court judges are still are becoming more diverse. In saying that, I would like to, I guess, bring it to the House's attention that although, we're in the latest census, we're seeing that there are 19.2% of people of color or migrants of color here in Aotearoa, New Zealand, that the number of High Court judges, or judges in general, not simply High Court, but the number of judges who are of, for example, Asian descent is less than 4%. The number of High Court judges, which is district court and above, I think currently sits at 1. So despite the fact that, we have this enormously diverse population, our higher court judge appointment process or our higher court judge demographic hasn't necessarily reflected that or kept up with the changes in our demographic. It's also, I guess, important to mention that one of the things that is recommended, and then we are looking at increasing the number of High Court judges, is also to do with the simple fact that as population are increasing, the number of cases are going to be increased, the number of cases are going to be more complex, not necessarily in the sense that there are more complex laws, but again, like I mentioned before, that the nature of the cases are more complex. One of the things that we are unfortunately seeing a reduction in funding is around the Section 27 reports, which is incredibly crucial when it comes to the timeliness of our judiciary process, and especially, like I said before, when the judges themselves do not necessarily have the same lived experience or share the same experience as those who are in front of the court, it does cause certain delays if there isn't a robust cultural report or process. And I do draw the House's attention to some of the latest issues and the latest work that's being done by particularly Chinese lawyers around contractual agreements within Chinese communities, which has been hugely complex and has also meant that courts, that cases become more complex, the ruling becomes more complex, and then there's more reasons then for people to appeal at a higher court. I think something like that, in terms of if you want to address judicature timeliness, that we should also really looking at whether some of those meant that we are seeing more appeals happening further and further higher up into not just simply the High Court, but also the Court of Appeal as well as the Supreme Court. So all of that tied together, and that's one of the, I guess, themes that did come through in terms of submitters. The other theme that did come through in terms of submitters, and this is again similar to what I mentioned in the second reading of the previous bill on legal services distribution of special funds amendment bill as well, which is that there's this general undertone of concern that people have in terms of equity for Māori within the justice system. And I think this is also a feature that we see here within this particular bill. And again, although that particular feature may be embodied as part of the timeliness of the court system that we're hoping to see going forward, the specificity of how that provides equity may not have been covered or addressed in this bill, and that's unfortunate, but also understandable. And then we're hoping that the government is able to bring something that will be able to allay some of those concerns that the community have in the future. Now, moving on to the second part, part 2 of this bill, which is also an equally important section, and although but actually comes out from sort of beyond, I guess, the court system, but also involves within some of that. And part of that is around the Criminal Procedures Act 2011. And I want to kind of start by addressing some of that in terms of the court. In terms of the Criminal Procedures Act 2011. And I think for this particular part, one of the things that's most important is how the pre-trial processes, if the defendant is charged in respect of 2 or more offences in different district court officers and how the process will be managed in that. And I think we will have some of the questions on this during the committee stage as well, because I think this is really important. And it was one of the things we did discuss is how that is going to be coordinated and managed between different district courts. This is also another one that I mentioned before, is how Court of Appeal judges may remit first appeals to the High Court. And this again comes to what I mentioned before, that cases becoming increasingly complex. We do allow people the right of appeal, and how that process is going as we see further and further going into Court of Appeal and also the Supreme Court. Finally, we're seeing an amendment to the Coroners Act 2006. Who knew that I'm running out of time? That the Coroners Act 2006, and I think the most concerning part of this, and that will be maybe discussed a little bit further, is the retrospective element of this. And, you know, for example, as of 30th of June, there are 3,240 active coroner inquiries. So how is that going to be managed as part of this? Madam Speaker, the Green Party does support this bill. We do have some amendments on this that we want to seek guidance on, but then we are waiting to the committee stage.
Honourable Brooke Van Velden.
Thank you very much, Madam Speaker, and I rise on behalf of the ACT Party in support of the Judicature Timeliness Legislation Amendment Bill. And the ACT Party does love efficiency, and we are backing this bill because it will bring efficiency that can be made across the judicial system. And this bill will improve timeliness in the justice system by appointing more judges, giving courts better tools, reduce duplication and support our coroners. And for that reason, I commend it to the House.
Jamie Arbuckle.
Thank you, Madam Speaker. I rise on behalf of New Zealand First to support the Judicature Timeliness Legislation Amendment Bill. It's probably one of those bills, actually, Madam Speaker, if we could change the title, would actually be quite good for some of the members. But anyway, we've got past that. The major parts of this bill is changing the number of High Court judges from 55 to 57. A lot of that is about the complexity around cases now, and also, Madam Speaker, the obvious thing around population growth of New Zealand. Striking out plainly abusive proceedings on the papers, that just makes sense. It's no difference from us striking out submissions when we get abusive language. Streamlining criminal pre-trial processes, so if you got a number of different trials or cases across the country, putting them all into one court in one place just makes sense. And what I do want to highlight is the coroners being able to close inquiries. That was something that was quite debated within the process of the submissions and through the Select Committee process. And looking back retrospectively at something is often something that we don't change or allow to be changed. But we've got over 3,200 cases sitting there, and it only makes sense if we can give closure to families with some of those cases been sitting there for over nearly up to 3 years. So on that, I look forward to the Committee of the Whole, and I commend this to the House.
E tu ana hau ki te tautoko I tēnei pere, engari e kōrero hau I te reo Pākehā mō tēnei pere. I rise in support, or to support this bill, the Judicature, I've never said that word before in my life, Judicature Timeliness Legislation Amendment Bill. So we agreed to support this bill to Select Committee. We had some parts about the bill that we wanted to explore around the vexatious litigation element, because we didn't want there to be any provisions that kind of dismissed claims in the court that might have been legitimate but complex, and we wanted to make sure that everybody has that access to justice. So we supported it with reservations, but now that it's gone through that process and the Select Committee has happened, we are happy to support it through its second reading. Yeah, woohoo! Our main concerns are around vexatious litigation within the High Court, and we felt that these safeguards against that kind of behaviour and conduct were already in the High Court rules, but we can see that there is some merit to transferring these to the Senior Courts Act. and that we're pleased that standard discretion by judges apply. We're particularly pleased about this given the different bills that have come through this Parliament in this term which have had a significant impact on judicial discretion, which I'll talk about later on if I have time. This bill, we hope, will address the backlogs that currently exist in our courts. We know that they are quite big. We know that according to the latest New Zealand Law Society report that there were over 140,000 court appearances that were delayed because of COVID-19, and that we've mainly resolved a lot of those, a lot of that backlog now, but still there are delays, and as everybody says, and I wonder if people have said it today, but access delayed, or justice delayed is justice denied, which is a great saying that really encapsulates parts of this bill. So obviously the bill does more than amend the Senior Courts Act. It does some other things to other acts, including the Criminal Procedure Act and the Coroner's Act. Now, I'm not going to talk about the Coroner's Act because I don't know a lot about the coronial inquiry. I've amended a law, have you? Good. Anyway, back to the bill. So, one thing that was also raised in the New Zealand Law Society report is that the cost of civil jurisdiction within the High Court has increased over time. So they've found that cases going through the High Court have become more complex and have taken a longer amount of time to litigate. And so allowing the number of judges to increase from 55 to 57 will really help with those lengthy cases that are really chewing up the High Court's time. And we think that it's a good thing to have more and better judges within our justice system. The other thing is delays in courts are really problematic because they really erode the public's sense of confidence and trust in the justice system, particularly for those individuals who have got cases before them that are really traumatic or personally affecting, whether they're dealing with, say, I don't know, a violent partner or someone who is abusing them or something like that. The fact that they have to wait so long due to backlogs is really not a good thing because they're obviously waiting in fear. But I think that whole part around public confidence and rebuilding that back from those, 100,000 plus court appearance backlogs is a good thing to, for us to do everything we can to reduce that wait time. Again, we could get into judicial discretion in depth, and I'm thinking in particular about the changes to the sentencing law reforms, which really erodes judicial discretion when it comes to sentencing and things like sentencing discounts. And also my colleague Lawrence made a really good point around Section 27 reports and how that has also contributed to the lengthiness of the courts because the judges don't have a full picture of the person who stands before them. And ironically, removing Section 27 reports has actually made everything more expensive because now lawyers have to get psychological assessments and drug and alcohol assessments to give the judge a full picture of the person who stands before them. So I could go on and on, but sadly I cannot.
But your time's running out.
But my time is done. Thank you.
Cal Bates.
Thank you, Madam Speaker. Madam Speaker, this is a government that is tough on crime. In the past year, there have been 182 patches seized, 643 insignia items seized, 178 firearms seized, 856 charges for the prohibition or prohibited display of gang insignia in public places, 255 finalised charges and 188 convictions. In order to make sure the system works, that these can go through the courts, we need to make sure there's enough judges, and therefore I commend this bill this evening to the House.
Honourable Dr Duncan Webb.
Thank you, Madam Speaker. And that is the kind of depth of analysis we expect from Carl Bates. Just got us all the way there, didn't it? This bill is another access to justice bill. Sadly, it's a bill that's here because this government seems to think that the only way to address problems in our society is incarceration. we're tough on the causes of crime on this side of the house, and we want to address the problems rather than, and we want to fix up people rather than lock up people, and that's the fundamental distinction between our two approaches to criminal justice. Having said, well, you know, some young person over the other side talked about ram raids, and the fact of the matter is that we address ram raids, and thank you to the national government for at least seeing one thing and picking up one of our programs, which is the fast track program, wrapping around families with troublesome young people, rather than boot camps which do nothing, which are an abject failure. The fast track program, which was to address those young people doing things like ram raids, said what are the problems in these families that are giving rise to this kind of behaviour? And we looked at it, and it was problems like mental health, problems like drug and alcohol addiction, including in the family, problems like not having enough money or even enough food, or young people not going to school and not engaging with services. So thank you to the national government for picking up and in fact expanding our fast track program, and the reduction in the number of young people offending is largely built on the back of the program that we started. So thank you for that. And that's one of the kind of things that we could do which would not necessarily require an increase in the number of High Court judges. Because a High Court judge, and this is the thing, like they get, and I'm not begrudging a High Court judge and the amount they get paid. I can't remember the exact number, but it's hundreds of thousands of dollars. But that's actually not the cost of a High Court judge, because on top of that, you've got to accommodate them. You've got to give them assistant, an executive assistant. You've got to give them a judge's clerk, and you've got to give them all of those other things that go with. So it's well over $1 million. And if you think of that $1 million in terms of what you could do elsewhere in the system, it's worth thinking about. Now, look, having said that, I want to be clear that we want to make sure that our justice system is properly resourced. And for that reason, we're supporting this bill. Now, it's important to note that there's no obligation to appoint the number of judges set out, and maybe there should be a minimum number of judges to make sure we've always got enough. Because the last thing we want is the executive nickel and diming the judiciary by not appointing enough judges. Now, that hasn't happened to date, but it's a protection that we might want to consider. But lifting the cap is appropriate. Having said that, I also want to look at the other things that are in this Act, which everyone else has some of the other speakers have skimmed over. In fact, National Party members skim over everything, because the backbenchers, at least their ministers engage with the issue, but the backbenchers aren't actually engaged with the very tricky issues that present themselves. So, if you look at, for example, the powers given to registrars and judges to dismiss out-of-hand claims on the basis that they are an abuse of procedure, it's actually both conceptually and practically challenging. And if we think of some things that have happened recently, there is a real danger that someone comes up and someone presents themselves, and they don't present themselves well. They present and they are a difficult person, and they present themselves and present their case in intemperate language. And they may even do it in a way which has all the hallmarks of not just an annoying person, but a person who's, a little bit, I want to be careful with my language, but a little bit not balanced. That doesn't necessarily mean there's not something to the allegations they're making. And so when we come to say a registrar can refer a matter to a judge on the basis that it is plainly abusive, we need to exercise real caution. Now, there's always been a power on the court to dismiss matters which are an abuse of the process of the court. It's always been there, but there have been protections there, and the protections have always been if you file a case, and it might, it's inevitably a lay litigant, and they could have
a claim which is not well formulated, not put in legal language, and it might have all kinds of things in it, some outrageous allegations and some language which is not appropriate. But sometimes in the middle of it, deep down, if you look hard enough, there's a kernel of truth. Now, that gets tested in court, and it might get thrown out at the first instance, but there's a right of appeal. You can go upstairs, go to the Court of Appeal, and you can argue it there. So, but here, if you look at it, in this case, this gives the power to judges to essentially throw out proceedings which they think are plainly an abuse, and this is important, without hearing from the person who filed that claim. So they can look at something and go, that's got nothing to it. And abuses, the general test for an abuse is that it has a collateral purpose, that it's not brought for the purpose, a legitimate purpose of vindicating some legal right, but it's in fact brought, for example, to harass or to damage the reputation of another person. They are classic collateral purposes. But, many a time, and it's often said that there are many open and shut cases which are not open and shut. There are many cases where there is no reasonable defence, where all of a sudden there is a reasonable defence. So I guess when we come to look at this, in Select Committee, and the Select Committee report rightly reflects these views, that we need to approach this with real caution, because we talk about access to justice, and at the same time, what this does is limit access to justice by giving the power to the court to shut down a claim without a hearing that they consider, that the court considers, the judge considers to be plainly abusive. And we just need to be really cautious there, because, as it happens, it's an issue. Vexatious litigants is an issue that I looked at closely. And the number of times with vexatious and abusive litigants where their behaviour is appalling, but their claim has something to it. And it's easy to conflate the two. It's easy to conflate poor behaviour, appalling language with the fact that underlying it all is a genuine grievance that deserves to be heard. So I guess my point as we come to this bill, rushing it through the House, of course, as is the want of this government, when the courts come to exercise this power, is always to pause. And one of the kind of practical things is this, that vexatious litigants in particular don't go away easily. In fact, one of the hallmarks of them is that when they are turned away in one sense, in one forum, they will open up another litigation in another forum. And there is few useful strategies to address this problem. But one is to actually give them a fair hearing, to follow the rules, to listen and to give reasons. And one of the challenges of the framework proposed in this Act, and I'm not saying we shouldn't do it, but we should exercise it cautiously, is that is not the case. That you don't give a hearing, you don't hear from the person involved, it's done on the papers, and then think about it this way, if you were a difficult person who felt you had been aggrieved, what would most wind you up? And your claim being dismissed out of hand, never having the chance to eyeball a judge and saying this is what my problem is, and being talked to respectfully by a judge, that's what people want. That's what we're denying. So that's why, in respect of that abusive procedure, we need to be very cautious indeed.
Thank you, Mr. Speaker. Mr. Speaker, indeed this bill does deal with a number of changes, but for me, one of the main ones I'd like to highlight is that we're going to be getting, after the amendment is passed, hopefully, 5 more judges, because on this side of the House, we don't give $2.75 million to the mongrel mob who provide meth to destroy families. We actually get judges there so that we can get our victims heard, and I'm so proud of the fact that under our government, there's 38,000 less victims, and we look for making that number even higher. I commend this bill to the House.
Thank you, Mr. Speaker, and thank you for the opportunity to also take a short call and say a few words about this Judicature Amendment Bill, which I always thought was pronounced somewhat different. And when I say always, for my whole life I've been pronouncing it incorrectly, at least it's since when I first was aware of it, which dates right back to about first reading. So, but Labour is going to support this bill because we do believe that New Zealanders deserve a justice system that doesn't leave victims waiting years to have their day in court. And but we do need to be honest about the bill, Mr. Speaker. Adding more judges is essentially the legislative equivalent of putting out the buckets when the roof is leaking. It's necessary for sure, but it's hardly some bold system strengthening approach, and not certainly not this bold approach, this silver bullet, this big fix that the government likes to pretend it's taking. And this is what happens when the government confuses being loud about crime with being serious about crime. And they can talk about cracking down until they're blue in the face, but without the workforce, the rest of the workforce and the infrastructure and the basic supports to actually move the case through, nothing much changes. I thought it was interesting, my colleague Greg O'Connor talked earlier about the Category 4 cases and how that now makes up 76% of the High Court inflows. And that's, clearly not just a blip, that's actually a structural shift. We heard that trials are longer, that they're more complex, they're also more frequent. Yes, increasing this cap is appropriate for now, but it's hardly bold, and it's the very least this government could be doing to get to the bottom of this problem. But more importantly, I think the government also owes New Zealand a bit of an explanation, as my colleague, the Honourable Dr. Duncan Webb just said, for why most serious violence cases are spiking and why they're not doing anything to actually address the drivers of crime. If you're going to brand yourself as tough on crime, law and order government, as has been branded in the contributions to date, you actually need a bit of a plan to stop harm from happening in the first place, not just react to it after it does happen. That's a little bit half-baked at the very least. So the government can keep pretending and absolutely put their head in the sand. Well, after 2 years, the government has made a very small change to try and address a problem that they claim to be a big change. And it's a little bit hypocritical that they're here making a big deal about it. And you certainly don't clear a backlog by ignoring the people, all the rest of the people that run that system, do you? Mr. Speaker, as I said, we are going to support the bill. We do fundamentally believe that victims in every community deserves to have their day in court, and you can't deliver timely justice and fair outcomes if you don't have a system that does so in a timely manner. But again, I don't think that we should be overstating what this bill actually achieves. It's modest at best. It's practical for sure. We've got no qualms about the practicality of it. Noting again, as colleagues have done, we are in urgency. If the government was on top of their legislative program, we wouldn't be sitting here at this very, very late stages of urgency, suddenly getting to grips with this very simple change that's apparently going to make this very big move. So let's not overstate it. The government continues to choose, and it is a choice, absolutely choose not to confront the wider problems in our system, and that is why so many people are ending up in the system in the first place, and why those violent crimes and those serious crimes like murder, and as my colleague Greg O'Connor very eloquently said earlier on, you know, you can't hide the bodies, and the government certainly can't hide from the fact that they're not doing bold things in this space. We do need a justice system strengthened from end to end, and on this side of the House we will certainly continue to keep advocating for a much more comprehensive evidence-based approach that actually delivers the things that people in this country deserve.
Great Freeman.
Pleasure, Noku Te Whiwhi, Te Tū, kia kōrero ai, I pāna ki te Judicature Timeliness Amendment Bill.
Tēnā koe.
So he aha te Māori mō Judicature Timeliness Amendment Bill. Te piri whakatika I te tōmuri o te pūnaha whakawā he rongo pai ake, ka tuku au te piri nei ki te whare.
Taito tuku. Thank you, Greg. Bernice Walters.
Speaker. Thank you. And it's a pleasure to rise and speak in support of this bill at second reading. And we are supportive of it because it is an access to justice bill, as colleagues have said. And I hate to start with a negative, but it's a bill that also perplexes me because I feel a little bit like the government are doing the access to justice hokey tokey when it comes to decision makers in the justice space. And I say that because hokey pokey hokey tokey. Say it 5 times fast. I say that because in the draft bill we have the additional 2, the amendment papers going to hopefully change that. I'm very supportive of a change in terms of an increase, but I will be supporting changes that my colleague is making in his amendment papers as well. But in the same year, the government have also reduced the number of decision makers on the Human Rights Review Tribunal. So the Human Rights Review Tribunal currently has, I believe they have the 2 chair people, but also the 3 deputy chair people. The deputy chair people can hear the case with a community panel on their own. And that speeds up the system essentially. It means that you don't need to have the chair people there at every case. However, in this year's budget, those additional deputies have not been extended. So it takes the Human Rights Review Tribunal down from 5 to 2 decision makers. Now, if you speak to people involved in the tribunal, this is sexual harassment claims in the employment space. These are discrimination claims. These are also health claims that go through the Health and Disability Commissioner, and their Privacy Act complaints as well. Some of them will tell you that it can take 2 to 3 years to get to a final decision. 2 to 3 years when we have 5 decision makers. And so it begs the question, why would you reduce the number of decision makers there when clearly there are already delays, if your theory of the game is that increasing the number of decision makers is going to help with the system. So, access to justice hokey tokey aside, a little bit of consistency would be very much appreciated, but we are supportive of this bill. I think what the government tend not to do is see the access to justice space as a whole, and I do think that that's part of the problem. I will speak to other things that they should be doing to achieve the goal of this bill later in my speech, or if I don't get the opportunity to in Committee of the Whole. I did want to first touch on a point that the Honourable Dr Duncan Webb raised, which was self-represented litigants. And I do think that that is something we're going to have to watch in terms of what this bill does to ensure that the vexatious provisions aren't used outside the scope in which they were intended to be used. So the first thing is the problem of the way in which the litigants can behave, and Dr Webb made the point that their behaviour can become conflated with the issue itself. But I also think the other problem is the scale at which we're seeing a growth in self-represented litigants. So I do have some helpful data here, which shows that at the end of June 2023, we had more than 70% of civil cases in the district court involving a self-represented party. 70% in the district court. Now that's compared to 52% at the same time in 2015. 8 years and a massive increase in self-represented litigants. The family court, you have a doubling in the last 10 years of the people who represent themselves. So it's not an issue we can ignore. We really need to make sure that we find a way for the courts to recognise these people will not have the same set of skills necessarily as a legal representative. Interestingly, the community law centres, we've obviously just passed a bill about community law. Community law Auckland did have a system where they would go into the courts and assist self-represented litigants and just help them understand court procedure. But I think the question is, well, how do we expand a model like that so that if we are going to bring in provisions that may potentially be quite rights damaging for self-represented litigants, that we're also providing them with the support and maybe not legal advice, but certainly with some legal support at the front end so that they are able to support themselves while they are in court. We had a number of submissions that we heard at Select Committee on this. The Law Society is always extremely comprehensive. They raised the issue of the definition of plainly abusive and the fact that, again, in regards to self-represented litigants, that may present as a problem. And I may speak to a few more of the issues that they raised in the course of committee stage. There's also amendments to the Coroners Act which allow the coroner to close cases. Now, when I read that provision, my mind went back to the last term of Parliament where we had a petition in front of the Justice Select Committee about the slow pace at which coroners' cases were proceeding. And so I do think that this goes some way to addressing that. But what was also clear when people were submitting to us is that it was a very emotional process. Some people were waiting for considerable amounts of time for very personal decisions, for them to be able to access life insurance payments as well. And we have to remember that there will be people who would like their case to go through, their family member's case to go through a coroner's hearing, who will be confronted with a coroner's decision to close a file instead of investigating. I do have an amendment on this point, which just asks that if the coroner is deciding to close a file, that they turn their minds to precisely the same factors as they would have to if they were opening a file or opening the initial file as well, which I think is a sensible change and hopefully one that the Minister will agree with. And I will speak more to the amendment when that comes through the pipeline. Just mentioning briefly Greg O'Connor's amendment, which is looking at setting a range of judges as opposed to a cap or a lower threshold. So the problem with a lower threshold, if you said that there always had to be, say, 60 judges, is that at any given point you would have to have appointed more than that lower threshold. And that's obviously because there may be unforeseen resignations, for example, so you couldn't dip below the statutory provision, or there may be a death, in which case you would also be below the statutory provision. And so a low threshold is somewhat problematic. Having a high threshold in terms of what the cap is potentially quite useful. Although, again, what I would suggest, and this is the amendment that has been tabled, is that a range would be the best option. The reason why you might not also want a minimum is that you may not want unconstrained powers of appointment. So the thing about the High Court judges is that there are those are very serious, sensitive, important decisions that are being made at the High Court. Judicial reviews go to the High Court, which is of course a case about whether the proper process has been carried out in public institutions and by government ministers, and certainly within that balance, that delicate balance that is Parliament and the discretion of ministers versus our judiciary, you would not this would ever happen, but you would never certainly want to provide for the powers for someone to stack a court by making a large number of appointments in a short period of time. Just in my last 30 seconds, Mr. Speaker, I did mention there are other issues that ought to be addressed in this space as well that just feel like they're being ignored. And this morning on RNZ, we heard about the poor state of our courts. And the fact that in some of them, I think it was Aotearoa, that there were cockroaches still being seen on climbing the walls. Certainly in Waitakere, there's mould and there are leaks, and there was and I've had to interview clients in the hallways as well. So all of this is part of what true access to justice means, and I look forward to speaking more about that at committee stage.
Tom Rutherford. This is great legislation, increasing number of High Court judges. I commend it to the House.
Scott Willis. It's interesting that we have such in-depth and insightful contributions from the government side. They last all of 5 seconds, and I would try to reach the brevity of my good friend Greg Fleming as well. But unfortunately, I have a little bit more time on my hands, so we'll give it a bit more attention, because the Judicature Timeliness Legislation Amendment Bill is actually a small bill. It's a small bill, and it's a small bill that we are paying attention to. We do support it, but it is also a bill that really does show that this government is a government that mistakes busyness for action. Simply trying to get stuff done without really doing anything. That's the nature of this government. So we don't need to be too concerned with this bill. What we need to do is consider the pipeline to the courts. We really do need to consider the pipeline to the courts. We need to get tough on inequality. That's what we need to get tough on. And that's the focus of the Green Party. Te Pāti Kakariki, guaranteed minimum income to reduce desperation, cleaner, cheaper, smarter power to reduce power bills, public transport for affordable mobility, provision of jobs through our green industrial strategy. All of this will have a positive impact on the numbers entering the court system. This bill is a bill that's dealing with the symptoms. It's dealing with the symptoms. It's not dealing with the cause. Mr. Speaker, as my colleague Tamitha Paul mentioned, 140,000 court appearances were delayed through COVID, and we're now doing catch-up. So that's why we will support this bill. We will support this bill. But there is also that question that my colleague Lawrence Zunan mentioned, a question of how do we do things a bit better? How do we get more diversity and representation in our High Court? Because that's something that we know we're lacking. We're currently lacking at the moment. We do have a very diverse society and a multicultural society. That's really valuable. How do we get that diversity and representation in our court system, in our High Court? That's one thing. So we're also pleased that this bill increases the number of High Court judges, but what it doesn't do is meet the request of the Chief Justice, who said that we needed to have a 25% increase in our High Court judges. So it's not quite getting there. It's not following the recommendations from our Chief Justice. So this is problematic. We've got the question that we also heard that things are getting a bit more expensive and a bit more complicated because there's that lack of Section 27 reports. So by causing a whole lot more problems in society, we are creating the need for a bigger court system. Again, we're addressing the symptoms, we're not addressing the problem. And we're not addressing the cause. And that's the problem really that we're facing here. We'll support this bill because we do need that representation. We'll certainly support this bill, and we do need courts that work, and we do need access to courts. But, and I'll say again, we cannot ignore the causes that drive people into desperation, that drive people into our courts, and that's why we need to be focused. We need to be tough on inequality much more than focusing simply on the ambulance at the bottom of the cliff. That's exactly right. And as my colleague Lawrence Zunan said, one of the things we could definitely do is get tough on landlords and put $3 billion into our court system. Now that would be very helpful. So, Madam Speaker, our concern is this bill is a small bill. It is helpful. It doesn't do a great deal, and it doesn't go far enough according to the Chief Justice, but it does do something. However, there is so much more to be done, and we are very focused on this side of the House on getting tough on inequality and not giving away more to the tobacco companies. Thank you, Madam Speaker.
The question is that the motion be agreed to. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it.
Judicature, Timeliness Legislation Amendment Bill, second reading.
This bill is set down for committee stage immediately. I declare the House in committee for consideration of the Judicature Timeliness Legislation Amendment Bill.
Say it in a really funny way now.
Members, the House is in committee on the Judicature Timeliness Legislation Amendment Bill. Members, we now come to Part 1. Part 1 is the debate on Clauses 3 to 9, Amendments to Senior Courts Act 2016 and Schedule 1. The question is that Part 1 stand part.
Mr Chair.
Mr Chair, I'm pleased to be leading the Judicature Timeliness Legislation Amendment Bill through the committee stage. This bill supports the government's commitment to an effective and efficient justice system. The bill amends the Senior Courts Act, Criminal Procedure Act and the Coroners Act to improve timeliness in New Zealand's courts by maximising judicial resource. The amendments will increase the cap on the number of High Court judges from 55 to 57, give courts better tools to address proceedings that plainly abuse the process of the court, meaning these can be disposed of quickly by a single judge, reduce duplication at the pre-trial stage of criminal proceedings, ensure appeals are heard at the most appropriate level, and enable coroners to close inquiries they have previously decided to open if it is no longer appropriate to conduct the inquiry. These improvements will ensure judicial resource is focused on the most critical matters. The benefits of improved court timeliness will be felt across the justice sector. I wish to also draw Minister Goldsmith's amendment paper to the attention of the House for consideration during this committee stage. The amendment paper makes a further increase to the number of High Court judges that may be appointed to 60. This is intended to better enable the courts to respond to unexpected long-term absences. When a judge is unexpectedly on extended leave, for example, due to illness or serious illness,
This puts a strain on rostering and negatively impacts timeliness. The additional 3 judges would be appointed to cover this unexpected long-term absence to maintain timeliness in the High Court. The amendment paper also makes changes to better support the transition between High Court judges. It would enable an incoming judge to take office up to 3 months before the retirement of an existing judge. This will make the transition between judicial appointments more efficient. I'm happy to take questions on that as we debate the bill during the committee stage. But there are key changes of this bill that have been made at Select Committee. In the report to the House, the Justice Select Committee recommended 2 key amendments. The first is clarifying that an order to strike out proceedings may be made on the papers. Clause 7 of the bill inserts new sections 164A to 164C into the Senior Courts Act. These provisions relate to striking out or otherwise dealing with plainly abusive civil proceedings. The Justice Select Committee recommended amending new section 164B to allow a judge to make an order to strike out or otherwise deal with a plainly abusive civil proceeding on the papers. The second one is clarifying that a coroner need not provide information about circumstances of death. Clause 20 of the bill inserts new section 65A into the Coroner's Act to allow coroners to close an inquiry they have earlier decided to open if new information or a change in circumstances mean it is no longer appropriate to conduct the inquiry. For consistency with other existing provisions in the Coroner's Act, the Justice Select Committee recommended that new section 65A be amended to clarify when a coroner does not need to provide information about the circumstances of the death. The coroner would need to have taken into account the public interest in the death and be satisfied there is no clear benefit to the public in providing that information. And I thank the Justice Select Committee for their work on strengthening this bill and their support in the House of progressing this bill through Committee of the Whole and third reading.
Greg O'Connor.
Chair, thank you, Minister. It's interesting, Minister, that we focus on the judges in this amendment as though the judges are the only people that exist in the whole of the system. In fact, anyone who's had anything to do with courts, particularly high courts, will know that the judges are very much part of a big machine. In fact, the role of judges has probably diminished, truth be known, because now with the amount of prescription imposed on judges, the days of the old character judges, like say Sir John Jeffreys is one that comes to mind in Wellington in particular, who actually commanded a lot of authority, not just from even their presence in the courtroom, but from actually the wisdom of their judgments, that often were resonated right through, whether it be lawyers, police officers and even defendants. Just interested that this amendment really just focuses particularly around the number of High Court judges. I've got an amendment paper, Minister, around the High Court judges. What we've said is we've now, and I noticed that the Minister's amendment is now moved it to be no fewer than 60, or to 60. My amendment says that let's keep this flexible. Flexibility in the system is got to be preferable to the very prescription that I see as being something of a bar to justice, or certainly slows justice or prevents individualising a lot of the decisions that the smart judges used to make. My amendment says that perhaps that we should have that flexibility that says the number of High Court judges appointed from time to time referred in section 62B must not be fewer than 60, but not exceed 65, because this would again allow for the ups and downs, the variations that do come. There will be times when there will be the need for various reasons. For example, you'll see at the moment, particularly around where the economy is under strain, there's a lot more civil cases coming through where businesses have come into strife and all the associated legal issues that arise from that. So again, that would just give the issue that may well be we need to go to 63 judges for some time to deal with that. So my amendment is to deal with just that. It's actually amendment to the Minister's amendment, which of course is the one that has been placed on the table just now. So as my question would be, how did we come to the number that we have, and is there any reason why we can't introduce some sort of flexibility here around 5, aware that there is, as my colleague, the Honourable Dr Duncan Webb pointed out, there's a lot of cost involved in one of these High Court judges, which again reflects on the point I made, is that the judge is just one part of a very big machine in these courts. So the question being, how did we arrive at the number we did, and is there any reason why we can't have the flexibility between 60 and 65 to reflect the conditions that may exist at any one time?
Mr Chair.
Honourable Nicole Kenny. Okay.
Yeah, no, just when I stood up, the chair went back and I went with it. No, it was fine. I thank the member for putting his thoughts together on this bill, and the questions that he asked are really good ones as well, and I like to take the opportunity to be able to answer it. And I'm referring to the member's amendment paper number 443, where he is looking to amend the amendment paper of Minister Goldsmith. And in answer to his questions about the minimum and maximum number of judges, there is a reason why we don't increase it to 65, and that's because the High Court judges are paid through a permanent legislative authority, which is held in section 1351 of the Senior Courts Act 2016. The judge's remuneration is set independently by the Remuneration Authority to maintain judicial independence, and so we need to think about that every time we add numbers to the cap, because it means that there has to be an appropriation put aside for that number, and it includes, of course, as the member had pointed out, additional staff that need to go with those judges too. So to increase the cap even further means having to put aside additional funds. Now, we don't tend to go under the cap that we've had, so we've by saying that we'll have no fewer than 60. The reality is that when a judge is appointed, they're effectively appointed until they retire, so they're there for life. But the change in the amendment paper that Minister Goldsmith has proposed is to allow the transfer of some of these judges who are coming up for retirement, and there's quite a few of them coming up for retirement, but there's also, unfortunately, a number of people who are getting quite sick at the moment. And the way that the current legislation is recorded is that we cannot implement a new judge until an existing judge actually retires. Then a new judge comes in and has to have 3 months worth of training. So we're actually down a judge for 3 months while that training occurs. So the amendment paper is proposing that we open up to allow an extra 3 more judges, 5 in total, with those 3 judges being able to train within the 3-month period that a judge is either going to be sick and stand down or is retiring. And then that way we have no loss in continuity between the judges for that 3-month period. So that's the reason why the amendment paper is asking or proposing a request for an extra 3. And the reason why we are not capping it at, say, 65, mainly because the funding would have to be put aside, and we think that we've landed at the right number, allowing the 3 months changeover for 3 judges at a time and increasing the cap by 2.
Is the danger of that not then, Minister, that the workload is irrelevant in this? Often we hear members across the House boasting about the strategies that are being implemented that are going to end up with more people in prison and certainly a harder attitude towards. So surely a flexible system that every part of the system must move. I remember Bill English saying in about 2016 and 17 when he was lamenting that prisons were a failure of society and lamenting the number of people that we actually had in prison in New Zealand. He also added that, heck, I'm not going to put more police officers on because I know if I put more police officers on, I'm going to need more prisons, I'm going to need more judges, that it's going to impact on every part of the system. You may remember during my second reading speech, I mentioned that the courts tend to be the bottleneck in the justice sector, the whole criminal justice system. So where we can't even have the flexibility to apply more or less, and in fact it's only going to be ever governed by the vote, then surely, Minister, then it means that we actually have got no then ability to actually reflect the reality, and often we hear that we must be able to have that flexibility to react to the reality of the world in which we are living. So by just being only driven by the vote and, as you said, little else, then we actually just build that bottleneck and in fact could create a less or a lower functioning and a more unfair justice system for that very reason.
Dr. Lawrence Zunan.
The Chair. I just want to follow both my colleague, the member Greg O'Connor, as well as the Minister's response on this. I think because the number of judges is probably one of the more significant aspects and has probably the broadest impact to our court system for the Judicature Timeliness Bill. First of all, in terms of the Honourable Paul Goldsmith amendment, it's really heartening to see another further increase from 57 to 60, and I'm really, really happy to see that the government is increasing that. And also I want to acknowledge your response to that, Minister, because can I just check in terms of that, with what the Minister is saying is that the extra 3 is more about adding that flexibility. So we're not always going to have 60 because there is a degree of ebb and flow. Which is also good because I think that also feeds into, I think, what Greg O'Connor was saying in terms of the adaptability when we need it. And there are stages maybe we will push up to 60, but as the Minister yourself said, there are people who are getting to retire who are ill as well. I wondered, 2 questions, I think. Number one, I do have an amendment paper on this as well, and it's amendment to the Honourable Paul Goldsmith Amendment number 443, which pushes up from 60 to 69. And the reason that it is 69 is because that in the memorandum that the Chief Justice mentioned in 2030, an additional 25% is what the Chief Justice said is needed in our court system to be able to kind of work through and everything. So hence, 25% of 55, 125% of 55 is 69. So I want to check if the Minister would consider that. The other question I have for the Minister, and the Minister mentioned in terms of the appropriation for this, and I don't know if the Minister remembered that we had this very sort of same conversation during the estimates scrutiny week, where I asked you about in terms of the appropriation that was set aside for High Court judges and the fact that appropriation didn't line up with the number that is specifically 2 High Court judges or the remuneration equivalent of 2 High Court judges. But in there, it was lower than 2, and the Minister responded by saying that people retire at different times and leave at different times, and appointment may not always be the same. But now we're seeing that being pushed up by another 3. So I do want to check that that is not something that, at least upon initial reading on a face level, the budget 2025 appropriation for courts has allowed for. So I want to check with the Minister then, is this something that will potentially eventuate as kind of working within what the budget allocation is, or is it something that will eventuate as part of a supplementary budget? I don't know if the Minister is able to actually speak on that, but I want to check anyway, because the addition of 3 High Court judges is significant and does means that, you know, like the Minister said, more money needs to be set aside. So those are my 2 initial questions to begin with. I wondered if actually 3 questions, and I wondered if the Minister wouldn't mind just speaking to a little bit more about what the new clause 4, subsection 3, where the replacing the Governor General thinks that 1 or more additional judges are, with at any time the Governor General thinks that an additional judge is. I want to check with the Minister, because there's no real sort of explanatory notes attached to it, what that change of phrasing means.
Mr. Chair, I thank the member for his questions. In regard to his amendment paper dated 7:36 p.m. I have the same response as I gave to the previous member, Greg O'Connor, which is that under the permanent legislative authority is how our judges are paid. So the increase of 2 permanent judges has been accounted for, as the member had pointed out. The extra 3 that are added on are therefore replacement of any judge that retires or gets ill, for example. It just allows us to bring in that transitional 3-month period. So then when the judge who is standing down has stood down, they are no longer being paid, and the 3, it may only be 1 at a time that is needed, but it's, as you mentioned, as the member mentioned, it's about the flexibility and allowing up to 3 judges at any one time to be trained within that 3-month period. But the costings for that will change after that period of time. So I hope that answers the member's questions.
Timothy Paul.
Thanks, Mr. Chair, and thanks, Minister, for your constructive answers to my colleagues' questions. I have some questions in relation to clauses 5 to 7 of the bill, which are new sections 164A to 164C, and these are the provisions that discuss plainly abusive civil proceedings, and really keen to flesh out the strikeout provisions. So I have some questions, and they are all kind of centred around those 2 concepts that, among other concepts, underpin our justice system, the rule of law and the concept of natural justice. So the bill talks about if a person
is...
is...
164A to 164C?
164A to 164C, new sections? Which is, yeah. So obviously if someone is struck out for plainly abusive proceedings, they will have to, they will be struck out twice, or where a person has been struck out twice within 2 years, they will be, what is it? What is the wording? They're not going to be able to file further proceedings for the following 3 years, 3 years within those senior courts. I just wanted to ask how you arrived at some of those timeframes. So the time frame of being struck out twice within those 2 years, is that based on those kinds of provisions in other laws, and what rationale helped you to arrive at the 3 years to be struck out? Is that based on other similar provisions within our law, or is there a reason for why we've gone with 3 years? Interesting that we went with 2 strikeouts, since the Minister's a 3 strikes person, but yeah, keen to just understand a little bit more about how you arrived at that rationale. And another question I had is, And apologies if I'm missing some of the details that might have been provided during Select Committee, but obviously Lawrence, as our permanent member on the Justice Select Committee, is privy to a bit more information. But I wanted to know if there was any analysis done on who might be affected by these kind of provisions, and whether there's been any analysis of, I guess, maybe what type of person in our society is most responsible for essentially wasting the court's time with plainly abusive litigation, because that would be really helpful to understand, you know, what type of person. Is it a person who is using litigation to abuse another person, which we see sometimes in the family court and other courts when it's, you know, an interfamily or domestic dispute? Is it people who have a lack of understanding of the law and therefore are constantly just, I guess, using the court's time because there is a lack of misunderstanding? Is it people with a lot of resource who are able to pay for lawyers and all of these kinds of things? So, yeah, trying to understand who will be most impacted by the strikeout provisions. And while we're here, it would be, I'm keen to start talking about that language of plainly abusive litigation, because, and there's a lot that we could discuss about that phrasing. And we note in the Law Society's submission on this bill that the bill doesn't provide a definition for plainly in this context. And so keen to understand, what does that mean? What are some examples of things that are plainly abusive? Does it mean that it is, you know, the use of strong or inappropriate language, or is it just that someone is continuing to seek the same recourse with the same outcome and they just continue to pursue that same avenue over and over again? So what does plainly mean in the context of this bill, and what does plainly abusive mean in terms of case law? What examples can we look to in case law or within proceedings to understand the way that term is used in this context? So we'll start there. I'm sure there are probably many more questions around the use of plainly abusive, so keen to dive back into that, but keen to get the Minister's answers on some of those questions.
Honourable Nicole McKee.
Thank you, Mr Chair, and I thank the member for her questions. I've got quite long answers, so bear with me, but I hope it helps. I'm going to start with Clause 7, Section 164A. This is enabling a registrar of a senior court to refer civil proceedings that they believe are plainly an abusive court process to a single judge of the court in which the proceedings were filed, to consider whether to make an order striking out or otherwise dealing with the proceeding under new Section 164B, which I'll get to. The process for striking out or otherwise dealing with civil proceedings that plainly abuse the process of the court in new Sections 164A and 164B is modelled on an existing process that's already in the High Court rules. The bill applies this to the Court of Appeal and to the Supreme Court as well. The intent is to enable proceedings that are plainly an abusive process to be dealt with efficiently by a single judge in each of the senior courts. Currently, at the moment, they need to get a panel of judges, so bringing quite often 3 or more judges in. So this is allowing them to have one. The registrar's role in referring a potentially abusive proceeding to a judge is the same as the existing role of a High Court registrar under the High Court rules that I had mentioned just before. And then moving on to 164B, the new Section 164B enables a judge, if satisfied that a proceeding that the registrar has referred to them as plainly an abusive process, to strike it out or make that order or give directions. A judge can strike out a civil proceeding if they're satisfied that it's plainly an abuse of the process, and that plainly an abuse of the process, I've been told, is a very high threshold. The courts have adopted a 2-limbed test in determining whether something is plainly an abuse of process. The first test is whether it would be manifestly unfair to the respondent that they be required to respond. And the second test is whether right-thinking people would consider the court exercising very poor control of its processes if it permitted the matter to proceed further. Again, already detailed in the High Court rules. This provision is enabling only. A judge still will keep his discretion, his or her discretion, on whether to make an order under that section. The judge can also make an order to give directions to ensure the proceeding is disposed of or proceeds in a way that complies with the court rules. And I note, and the member said she's not on the Select Committee, but the Select Committee added to section 164B, another order may be made on the papers without the opportunity to make submissions. So this ensures that the new power is consistent with the current strikeout power contained in the High Court rules, which allows an order to be made without allowing the person who filed the proceeding to make submissions, and that came from Select Committee. And then if I move on to 164C, because it just sums them all up together, the restraint that has been made in new section 164C is similar to the existing provisions for a general order in sections 166 to 169 of the Senior Courts Act, which allow a judge to issue an order restraining a party from commencing or continuing proceedings if satisfied that at least 2 proceedings brought by that person were totally without merit, so meeting those 2 tests. The key difference from the current law is that the restraint in new section 164C applies automatically where 2 proceedings are struck out as plainly an abusive process. It does not require a party to apply for an order or a judge to make an order on their own initiative. The restraint itself is not able to be appealed, but the strikeout orders that lead to the restraint can be. So if a strikeout order is set aside on appeal, the restraint no longer applies. People will still be able to access the courts if they are restrained, but they need to seek permission from the High Court first, so they still will have that opportunity. The intent here is to prevent the repeated abusive proceedings that waste courts' time and the time of parties.
Dr. Lawrence Zunan.
Thank you, Mr. Chair, and thank you, Minister, for the comprehensive explanation. That's really, really helpful in terms of that. I just want to, I guess, pick up the last thing that the Minister said on 167C, which is that people, for example, still have the ability, but they have to go through a High Court judge, which I think answers one of my questions, which is around what happens if the kind of appeal, the kind of cases being brought to, for example, in the Supreme Court, particularly when it comes to things like Bora, are still able to do that. I'm assuming that a High Court judge will be using their best judgment to decide if that is of a serious enough nature that the order isn't going to be, I think, in effect in that particular case. So thank you, Minister, for that. Now, I want to check with the Minister. So as part of this Select Committee process, in 164B, the 2A, the Minister did mention that one of the things that was carried over was the idea of may make an order to give directions on paper. But noting that the intention of that is to be able to make it on paper without notice to the person filing the proceedings, okay, so without giving the person who filed the proceedings the opportunity to make submissions, but at the same time, it would not affect the person's right to appeal an order. It could be that we've been doing this for 70 plus hours, but if a person doesn't know that that an order has been made by a judge, how would they then have to wait until they re-appeal an order? How would they know to appeal an order if they don't know that they've got notice? Is I guess, the crux of my question.
Mr. Chair.
Honourable Nicole McKee.
Thank you, Mr. Chair. Thanks the member again for his question. The allowance here is for the judge to make the order without the papers, without the submission. And there is a process that every judge and court goes through in order to serve orders on a person once an order has been made.
Questions? Ryan Hamilton.
I move that debate on this question now.
The question is that debate on this question now close. All those in favour say aye. Aye. Contrary, no. The ayes have it. Party vote has been called for. The clerk will conduct a party vote.
Use it enough.
49 votes in favour.
New Zealand Labour.
34 votes opposed.
Green Party of Aotearoa, New Zealand.
15 votes opposed.
Act New Zealand.
11 in favour.
New Zealand First.
8 votes in favour.
Te Pāti Māori. Taku Te Wheres. Maria Minu Kapkingi.
The ayes are 68, the noes are 49. The question is agreed to. The question is that Greg O'Connor's tabled amendments to the Minister's amendments to Clause 4 set out on amendment paper number 443 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The ayes have it. The ayes have it?
Ayes have it.
All right.
We're voting.
The ayes have it. The question is that Dr Lawrence Yunan's tabled amendments to the Minister's amendments to Clause 4 set out on amendment paper number 443 be agreed to. All those in favour say aye. Aye. To the contrary, no. No. That's very loud. The noes have it. Party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes against.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
Act New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori. Taku Te Wheres. Maria Minu Kapkingi.
The ayes are 49, the noes are 68. The question is not agreed to. The question is that the Minister's amendments to Part 1 set out on amendment paper number 443 be agreed to. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Part 1 as amended stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, we now come to Part 2. Part 2, this is the debate on clauses 10 to 29, amendments to other legislations and schedules 2 to 4. The question is that Part 2 stand part. Dr Lawrence Yunnan.
Thank you, Mr. Chair. Thank you again to the Minister for a very informative response to the Part 1 around the Senior Courts Act. I think we're going to start in terms of Part 2 with the first half of that subpart 1, which is amendments to the Criminal Procedures Act 2021. And then we will, after that, move on to our Coroner's Act 2006. So starting with this one, noting that Clause 12 is probably the most significant one with the management of pretrial processes if defendant charged in respect of 2 or more offences in different district court offices. I just want to check with the Minister. So in this case, particularly when we look at 156A, subsection 2, it does say that the district court judge on the judge's own initiative or the application of the prosecutor of the defendant may direct the pretrial process to some or all proceedings by managing one of the officers of the district court. Can I just get a clarification from the Minister? With that, when you're looking at 2 different court judges, is this to do with when a defendant is charged with the same crime in 2 different areas or with 2 different crimes in 2 or more areas? So that's my first question to the Minister. The second question I have to the Minister is what I'm finding that's quite interesting in terms of subsection 3. Oh, sorry.
Apologies. Could you just repeat that first question?
Oh, yeah, sure. Okay. Yeah, definitely. So my first question is, so a defendant's charged with 2 or more offences, is that the 2 or more offences means that the offences each will have to take place within the jurisdiction of a different district court, So one offence in one district court, one in the other one, or two or more offences that crosses both district courts. So I think to start off with, that's my question, which then might provide some clarification for further questions. Because I wasn't clear if 156A1B, when it says proceedings in respect to the offences have been commenced, it doesn't necessarily mean that the charge, it doesn't necessarily clarify the charge itself. My second question is what we see in terms of 156A3, particularly when we're looking at A, B, and I think A and B is a very important inclusion to ensure that if any sort of pre-trial processes is being shifted between different district courts, that the timeliness and interest of justice is still a core part of it. But I just wanted to check with the Minister, how would a judge, how would that look in terms of the process itself when a judge makes that determination?
Mr. Chair.
Nicole McKay, Honourable Nicole McKay.
Mr. Chair, before I answer the members' questions, I'd just like to clarify even further an answer to a previous question, which is about when the first strikeout order is made and what happens with that. So when a judge makes the first strikeout order, they must inform the litigant of potential for automatic restraint to apply if they bring future proceedings that abuse the process. This means people will have a fair warning of the consequence of making abusive applications. And decisions for strikeout may also be appealed. If overturned on appeal, the strikeout decision will not count towards restraint. So that's further to Member Tabitha Paul's question to that. And then also to the member's question, when someone is accused of multiple offences, charges can be filed and proceed in different district court office locations. This means the defendant can have court appearances at several locations, and that can add to delays and inefficiencies within the court system. So having the ability to bring them into one actually not only is efficient for the courts, but it's probably efficient for the person because it means they don't have to go to several different jurisdictions and can have everything heard in the one place. So efficiency all around.
Dr. Lawrence Yunan.
Thank you, Mr. Chair. That clarifies my question on that part. Thank you, Minister. I just want to now move on to 3192, and this is my last contribution for subpart 1. I'm just going to check one thing. Yes, and then I'll move on to the Coroner's Act. So in terms of clause 13, so this is new section 319. I think this is a really interesting section in terms of the ability to ease the workload of the Court of Appeal and the High Court and a more efficient and timely determination of the District Court Appeal. But I'm curious to know, because this section specifically says applies to the first appeal, one application. I guess I kind of want to know in terms of the processes. You make the first appeal under this part of the District Court. But what happens if, for example, it goes to High Court, and that gets bounced back, are you able then to make a second appeal, which then this process, the new process under 319A, will not be available for someone who are making subsequent appeals?
Mr. Chair.
Honourable Nicole McKay.
Mr. Chair, I'll speak to the intent of the bill and what the new 319A inserting into the Criminal Procedure Act actually does. The provision is about enabling a single judge of the Court of Appeal to remit certain appeals and applications for leave to appeal to the High Court for determination. This new provision is limited to appeals and applications for leave to appeal under Part 6 of the Principal Act, for which the Court of Appeal is the first appeal court for decisions of the District Court. The provision is enabling a single Court of Appeal judge to remit cases for which the Court of Appeal is the first appeal court to the High Court for determination. So appeals relating to most district court jury trials and some district court judge-alone trials are currently heard by the Court of Appeal as the first appeal court. This is enabling some first appeals to be remitted to the High Court, which will mean that these cases are determined by one High Court judge instead of 3 judges in the Court of Appeal. And this will ensure more efficient use of judicial resource while retaining the Court of Appeal's oversight of the appellant jurisdiction in criminal cases. So that's the whole intent and purpose of that particular clause. The member was asking questions about second appeals, but it actually has to flow in how the courts themselves appeal. So the intent really is to just outline the fact that we shouldn't have to have 3 judges to refer a case back to the High Court because it's automatically gone to the Court of Appeal. We're basically saying bring the High Court back in and allow one judge to make that decision.
Dr. Lawrence, no.
Mr. Chair. Thank you, Minister. That also clarifies my question. So I'm going to move on to a new section now. And that is now looking at subpart 2. So we've now moved on from the Criminal Procedures Act and then into the Coroner's Act. And I'm looking at clause 20 of this. So coroners may close inquiry despite initial decision. Now, one of the things that was brought in as a bit of a concern that was the retrospectivity of this particular section, and that the fact that it would apply to inquiries opened before, on, or after the bill's commencement date. And I have lost my place. So I wondered if, for example, the section 7A that has been introduced as a part of this, where the coroner decides to close the inquiry under the new 65A, and it's not required to provide information about it, how would that interact with the retrospectivity of clause 20? And I guess in some ways, when we're at the select committee stage, we could see the intention behind that retrospectivity, particularly in terms of some of the outstanding cases. But I just want to engage with the Minister in terms of some of the Minister's thoughts around this area and the retrospectivity for the closure of inquiry. So that's my first question. And my second question for the Minister, and I guess this crosses over another bill that is currently going through as well, which is the Regulatory System Courts Amendment Bill. I want to check with the Minister if there's any thoughts around how this particular bill interacts with Clause 31 of that bill, and the way that the consistency can be matched between the Section 64 of the Coroner's Act and also the Section 94 of the Coroner's Act. So I guess in this case, when we're looking at Clause 31 of that other bill, was also has a section around, I guess a clarification of Clause 31 of the Coroner's Act. So yeah, I guess the first question I have for the Minister is, what is the Minister's, any thoughts around the retrospectivity elements of this? And my second question is, how does the Minister foresee this bill, and particularly this clause, interacting with the Section 64 and 91 of the Coroner's Act, which is currently going through under the bill in the House? Mr. Chair.
Dr. Lawrence.
Sorry, Mr. Chair. The Minister is just getting some advice, I hope. I want to move on then to, while I'm waiting for the Minister on those two particular questions, I might move on to Clause 21, which is Section 83 amendment. And this is to do with appointment of specialist advisors. I want to check with the Minister on this particular section when it was discussed in the Select Committee. Also was one of the ones that we would have thought would be quite obvious as something that should have been included. I guess for something like that, I wanted to check with the Minister, because the Minister was also the Minister in the chair when we did the statutes bill, and was hugely informative and engaging in that. For something like this, Would that be considered something that could also have been brought through as part of the statutes bill instead of having been brought into a separate bill altogether? That's my next particular question. So my 3 questions just to the Minister is, Clause 20 is, what is the Minister's thoughts on retrospectivity? What is the Minister's thoughts around interaction with another bill that's currently going through, particularly that also has implications to the Coroner's Act? And in terms of Clause 21, Section 83 amended, is that something that could have been introduced or been brought into another bill, and particularly like a statutes bill or a regulatory systems bill?
The Honourable Nicole McKee.
Thank you, Mr. Chair. I'm going to apologise to the member because I've missed quite a bit of what the member has said, but I did pick up some of the first beginning part of what he said. So what I might do is actually, in speaking to Clause 20, which is the new Section 65A, which the member was talking about, if he bears with me while I actually refer to Venushi Waters' amendment paper timeline 08, because I think that might actually end up answering some questions for you. And it's about the coroner's consideration of Section 63 matters when they've decided to close an inquiry, which is what the member was asking about, the closing of an inquiry. In considering whether an inquiry is no longer appropriate, a coroner will cast their mind to the reasons why they initially opened it in the first place. The reasons for opening the inquiry under Section 63 are actually quite a non-exhaustive list. They will not have all been relevant to the decision that the coroner made to open an inquiry in every case. And I recognise that the decision to close an inquiry, as the member had mentioned, I mean, it can have quite an impact on families and friends. So the changes in new Section 65A3 of the bill require the coroner to notify interested parties of the proposal to close the inquiry, and they must provide the reasons for doing so. The notified parties will then have 15 working days in which to make submissions to the coroner on the proposal to close the inquiry. This consultation will, by its design, involve a discussion on what led the coroner to open the inquiry in the first place, and also why they since decided it was unnecessary to prolong the inquiry any further. So there's a whole lot of conversations that will be occurring. They won't just say, that's it, we're going to deny it. And in fact, if I recall in legislation, if the family are really adamant that there was, say, some foul play, then a judge will take that on board in their consideration. But the purpose of them being able to close the inquiries was when it became quite obvious that a person had, for an example, died of natural causes. Once an inquiry has been opened, the inquiry must go through all of its processes, even when the coroner and all people understand that actually the person died of natural causes. So this is allowing them to be able to close the inquiry when everybody determines the same outcome. At the end of the day, the judge will make the decision, but the coroners that I know are quite empathetic to the families, and they do work with them. They're not going to go about trying to close off inquiries unless they actually do have an understanding that there is a reason for doing so.
The question is that Venushi Walters tabled amendment to Clause 20 replacing new Section 65A brackets 1 be agreed to. All those in favour say aye. To the contrary, no. No. The noes have it. Party vote has been called for. The clerk will conduct a party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT, New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Party Māori. Tāku Te Whereas. Maria Meno Kapakini.
The ayes are 49, the noes are 68. The question is not agreed to. The question is that Part 2 as amended stand part. All those, the question is that Part 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Schedule 1. The question is that Schedule 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Schedule 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Schedule 3 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Schedule 4 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. Members, we now come to our final debate, Clauses 1 and 2. This is the debate of Clauses 1 and 2, title and commencement. Dr. Lawrence.
Mr. Chair, I was waiting for the question is, but anyway, so I do have a final question. It's a reasonably short question. It actually is my last question. It actually genuinely is my last question. I am deeply appreciative of the House's patience these last, I feel like 75 odd hours. But also more excitingly, I think for this House, it is also my last amendment. There is amendment. I would like to refer the Minister to my amendment at 8:35:02 p.m. on the commencement date. The reason is, so the commencement date, now I'm going to refer to this bill in conjunction with the bill that we just discussed, which is the Legal Services Distribution of Special Funds Amendment Bill, because both bill was introduced at the same time. Both bill had a commencement date of 1st of July 2025. However, I want to check with the Minister on why the updated commencement date for the two has changed, because for this one, for the previous one, the commencement date is this Act comes into force on the day after Royal Assent. However, for this particular bill, the commencement date is this Act comes into force on the 1st of February 2026. I guess for personal sort of consistency, my amendment is to seek the Minister's guidance on whether the support on this is just to simply also change Clause 2 amendment replacing 1st of February 2026 with the day after Royal Assent to be consistent with the other bill.
Mr. Chair.
Honourable Nicole McKee.
Thank you, Mr. Chair. In speaking to the members' amendment paper 8:35:02 p.m, the reason why 1 February 2026 has been inserted is because time is needed to put the operational measures in place to implement the changes.
Greg O'Connor.
Madam Speaker, just in relation to the title of the bill, I just wonder why we've got such a complicated title. If one Googles the word Judicature and pronounces it properly,
Judicature.
It refers to the administration of justice by courts and judges, or more broadly, the judiciary. So why don't we just call it the Judiciary Timeliness Legislation Amendment Bill? I defy anyone in this House, when they saw this bill tonight, that didn't look at it and say, what the hell is that all about? I think there was a bill went through this House some years ago. I think it was one of my fellow members over this side who passed a plain English bill. We're all about getting anything nice and simple. And how about an amendment that says we, instead of the Judicature bill, we call it the Judiciary Bill, so we will all know exactly what it's all about.
Mr. Chair.
Honourable Nicole McKee.
Judicature. Judicature. This sounds so cool. And actually, to the member, I really like hearing you try to say it.
Ryan Hamilton. The question is that debate on this question now closed. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The ayes have it. Too late. The question is that Clause 1 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. The question is that Dr Lawrence Zunan's tabled amendment to Clause 2 replacing the 1st of February 2026 with the day after royal assent be agreed to. All those in favour say aye. Aye. To the contrary, no. No. The noes have it. The party vote has been called for. The clerk will conduct the party vote.
New Zealand National.
49 votes opposed.
New Zealand Labour.
With 34 votes in favour.
Green Party of Aotearoa, New Zealand.
15 votes in favour.
ACT New Zealand.
11 opposed.
New Zealand First.
8 votes opposed.
Te Pāti Māori. Tāku Te Whereas. Maria Meno Kapakingi.
The ayes of 49, the noes of 68. The question is not agreed to. The question is that Clause 2 stand part. All those in favour say aye. Aye. To the contrary, no. The ayes have it. I will report this bill with amendment.
The House is resumed.
Madam Speaker, the committee has considered the Judicature Timeliness Legislation Amendment Bill and reports it with amendment. Madam Speaker, I move that the report be adopted.
The question is that the report be adopted. Those of that opinion will say aye. Aye. To the contrary, no. The ayes have it. The bill is set down for third reading next sitting day. The government has indicated that it no longer wishes to continue urgency. The House stands adjourned until Tuesday the 9th of December. Good night.
That concludes our coverage from the House of Representatives. More information about Parliament is available at www.parliament.nz. House of Representatives' normal sitting hours are Tuesdays and Wednesdays, 2 p.m. to 6 p.m. and 7:30 to 10 p.m. and Thursdays, 2 p.m. to 6 p.m. The House sitting program is available at www.parliament.nz.